yesterday, so I just want to put on the record that I'm denying the motion without any further consideration or discussion by the parties. Reasons. One was it had to do when he called the state of Wisconsin as a witness for failing to appear, and then for failing to state a claim upon which relief can be granted. There's no legal basis for those motions in law or in fact.
Good morning, everyone. We are live with the Darrell Brooks trial.
I'm not asking for any further commentary or statements on the issue.
I object to that.
And I intend to have you call the next witness. I just want to confirm with the state who is here this morning.
I object to that ruling, Your Honor.
Noted for the record.
Present this morning, Your Honor.
I would like the legal finding of fact.
Night.
Your Honor, consistent with the court's instruction yesterday afternoon, we have present Douglas Kohler, Detective Steve Guth, and Erica Patterson are here now and available.
All right. I expect you to call those first three before we get to any other person. Not whatever order you want among the three, but
Hey, Pace and Rose. Good to see you. Hope you're doing well.
State for the record that I intend to appeal that judicial decision made about the motion to dismiss.
Noted for the record. All right, let's bring the jury out then.
Actually, we didn't address subject matter jurisdiction. It still has yet to be proven for the record. And I wanted to address the fact that with this, is it Kohler? Is that how?
Subject matter jurisdiction. You'd think he would get the hint by now.
Repeatedly, there's a written.
It's nonsense.
You have three witnesses that you subpoenaed. The state made arrangements for them to be here. Whatever order you want to call them in this morning is fine, but those three are here.
That's what I was trying to address right now. I was asking about
go ahead.
the name.
What do you want to address?
The Kohler. How do you pronounce the name? Kohler. I'm still
I don't know.
having
You'll
trouble.
have to ask the witness.
I'm still having trouble finding the file for that particular witness.
Yeah, call the jury in.
So I don't know how I'm supposed to.
Mr. Brooks, you were well advised. These are your witnesses that the state made arrangements. You knew who was going to be called. I put that on the record yesterday. So of those three, whatever order you want, but I'm not moving past those three.
I didn't say anything about moving past the three.
I know that. I'm just setting the tone for today that we're going to keep moving.
Okay, I simply stated I'm not ready to ask that witness questions if I can't even find the
I
your
understand,
paperwork.
but that's you not having your paperwork's on you, not anybody else.
So what
Exactly. Everything he's doing right now is trying to stall.
which means when I'm notifying the court that I cannot find the record.
Well, you
I
did
can't
very
find
well
I can't
yesterday
find the
without
file
your
for
file.
that.
So
I'm saying
I don't
that
think that's the
particular
issue.
witness.
I'll make a record. Yesterday you asked a question. Hold on a second. Can you have them step back out? Just they can. Yesterday, you said you did not have a file for one of the witnesses, and you did a fine job from my perspective. So
I did what?
you did a fine job. I just
Yeah,
want to
but
say my
they
assessment.
also
You did a good
provided
job.
me with one sheet for that particular witness at that time.
Okay.
So
I'm
I just went
bringing
off
the
of that
jury
3
in.
paragraphs.
How you're prepared or not is solely on you, sir. You've had all of this information. Now we're at the end of the third week of trial. These are your witnesses. I presume that you are prepared in whatever way that is.
How
You're not
can I
gonna
be
hold it
prepared
up.
for? I'm not. So the witness is just supposed to get up there and just. I'm just like,
I'm
yeah.
not going to have this commentary. Okay, I'm done. The jury's coming out. Be prepared to call.
So
one of the
that's a
three.
rush to judgment.
That is not a rush to
Kick him out. Kick
It's
him
clearly a
out.
rush to judgment if I'm telling you that I don't have the
No,
file.
in my
How am I
opinion,
supposed-
you're attempting to delay. So
No,
let's
I'm not.
keep
I'm not
going.
attempting to delay nothing. You want to come check the boxes yourself?
The judge could have a
Always
great
trying to pull
career
some fast
as a
fast
preschool
maneuvers.
Mr.
teacher.
Brooks,
And
That is
Miss
true.
Judge, Your Honor.
Mr. Brooks, the jury's coming in.
Yeah,
Show
and
respect to
they
the
deserve
jury.
to know this too. It's still issues that need to get addressed. We didn't even address everything.
Mr. Brooks, I addressed all of the issues.
No, I
and you
still
know
had another one that didn't have nothing to do with nothing we just talked about.
All
There
right.
was a whole nother issue that needed to be addressed that I needed to
And we'll
bring on
address
the
it
record to
later.
your attention.
We'll address it later.
It needs to get addressed now before we go any further because it's an important matter. Just like the subject matter jurisdiction is important. That hasn't been proven on the record.
Ladies and gentlemen of the jury,
Just
this is
like the
not
rush to
the
judgment.
time for evidence to be presented or arguments to be made by the
I can't
parties. The
even
jury
present
will,
any evidence. You won't let me even put
disregard
any evidence in the record.
all of these statements
is a
made
rush to
by
judgment.
Mr.
That's
Brooks at this
unfair.
time. All right,
That's unfair what
the
you're
court
doing.
will address legal matters outside the
Then we
presence.
need to
Everyone
address
can
the
be
legal
seated.
matter that I was trying to get
He is such a freaking child. Anything to delay this trial.
to. Answer, Your Honor. You're a public servant. You're
Mr. Brooks,
supposed to be able to answer simple questions.
Mr. Brooks,
If I'm saying I have to bring
call
it to
your
your
next witness,
attention,
please. That's the stage of
I
that
have
we
to
are
bring
at.
it to your attention, Your Honor.
Mr.
I'm
Brooks,
merely seeking
please
to bring
stop.
an issue to your
I'm
attention.
telling you to please, I'm asking you to please
And I'm
stop
asking you,
because
can
we
we
have the
address?
jury present
I'm
and
asking you.
we need to continue with the evidentiary phase of this trial. Call your next
I'm
witness.
asking you to address a legal matter, as you said that those have to be taken up outside of the jury.
I will
There
do
was
that
a
at the
legal
next
matter.
break.
There was a legal matter that needed to be addressed beforehand,
I
so
will
we
do
don't
it.
have to take up time,
I will do
valuable
it at the
time
next break.
afterwards to address something that needs to be addressed now. That way,
Mr.
the
Brooks,
court and you
For the
yourself
third
are on
time,
notice.
I will.
Now he's not even going to call a witness. He's more concerned about arguing with the judge over
I'm
nonsense.
directing you to call your next witness.
Your Honor, we're not going to move past this, seeing as how you took an oath to protect the Constitution. I have your oath. I have a copy of your oath right here. The oath that you took, Your Honor.
Mr. Brooks, I'd like to continue with testimony.
Sir.
We have witnesses waiting for you. Please call your next witness.
The oath that you swore to protect the Constitution, which you are now not doing.
Mr.
So
Brooks,
you're going
call your
against
next
your
witness,
sworn
please.
oath. You're going against your sworn oath.
Mr. Brooks.
Hello to everyone just joining, watching the Darrell Brooks trial.
Take them outside of their presence.
And we're gonna
I
take
didn't-
testimony right now. Call your
I
next
merely
witness.
seek to put you on notice on the record for something that needs to be brought to your attention
And
and
I
to the
will-
court's attention.
And I will address it at
That's
the
what
next
I'm
break.
merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll. And
Mr.
then
Brooks,
it gets
I will
overlooked.
address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go. Call your next witness.
Your Honor, Your Honor, you have to answer this question. You're
Mr.
making a
Brooks,
judicial determination.
Call
to
your
rush
next
me to
witness,
judgment.
please.
You're rushing me to judgment, Your Honor.
There's
Kick
no
him
rush
out.
to judgment
There
here,
is a
sir.
rush to judgment if you won't address a legal issue that I informed you that I had some legal issues that needed to be addressed before you just run right past that, Your Honor.
Exactly, Casey.
Not a
It is
public servant.
9:37. Call
It is
your,
8:37.
sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing me to judgment.
There's no rush to judgment. Call your next
We
witness,
had a
please.
legal matter that needed to be addressed, and I'm merely trying to
And I'm
notify the court.
telling
at
you
the
I'm denying the
onset-
request to address it at this moment. Call your next witness.
You said what?
I'm denying your request to address it at this moment. Please
How
call,
can you deny
please.
something that we're supposed to do before the
Mr.
jury
Brooks.
even comes out?
call your witness.
I'm not seeking to be disruptive. I'm just seeking to understand why we do this
Everyone
every day.
is in the courtroom waiting for you. Please call your
Your
next
Honor,
witness.
we do this every single day. We've done it every single day.
Kick him out.
We're trying to make sure that the court is notified of
Put it
things
in
that need
writing,
to be
hand it to the
discussed.
bailiff, and if I deem it important enough to interrupt the witness, I will, but call your next witness.
How can I call a witness and write something down and do?
You
do
can
both?
take a minute
This
to
is the
write down what it is.
This
I'm
is
not
the
asking
reason
you
why
to,
it needed to be addressed beforehand.
Mr. Brooks,
That way
the
it
jury
doesn't
is
become an
remaining in
issue.
this courtroom. Call your next witness, please.
Your Honor, you're rushing me to judgment.
There's no rush to judgment, sir.
Are you not a public servant, Your Honor?
Mr. Brooks.
Do I not have your oath of office?
Under
3 of them?
90611, this court has the authority, as you know.
Do I not have?
Call,
Say delegation of authority order. That would be great.
On record that you would not provide for no good reason. That these are three
sir,
of your
you are
oaths.
doing this,
right
and I've
here.
repeatedly told you, you can see the jury's here.
You're
You're
doing-
doing this.
Listen,
We need to go
I'm not
forward.
attempting
I agree. He should be moved to the other
to
room.
delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up instead of waiting until a break or a lunch and things of that nature, which
In
kills
my
valuable
discretion,
time.
it's my authority, it's the courtroom that I'm
Your Honor.
presiding over. I'm not gonna address
Is
that
this-
at this
Is
moment.
this not your
And
oath?
I'm not gonna answer
Did you not
questions.
swear as a public servant that you will protect the
Mr.
United
Brooks,
States Constitution?
Call
Did you not do that?
your
3
witness.
times. I have all of them here. Your oath, Your Honor, as a public servant. And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
We are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor, you're
Call
rushing
your
me to
next
judgment.
witness.
You're rushing me to judgment, Your Honor.
He's doing everything he can to get a mistrial and to delay the trial, and it's not working.
I object to that.
Your objection's noted.
And
for the
I
record.
want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these needs to be stayed until this matter is before a adjudicated court of competent jurisdiction. Because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of the
Mr.
charges
Brooks,
against me. I don't even understand that part
I
of it.
understand
haven't
your
been provided
request.
a complaint. I haven't, Your Honor, there's so many issues.
Mr.
and
Brooks, we will take,
I'm not attempting to
Mr.
to be
Brooks.
disrespectful in any way.
we
I'm
need
not
to
attempting
continue.
to delay the proceedings
Your
in any
requests
way.
are denied.
That's exactly what you're doing. You're
Witness
delaying
prepared
it.
at this point
So don't say you're not.
And not
We object to
consider
that, Your
any
Honor.
of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's
With that,
it's a rush to judgment
Mr. Brooks,
because, Your Honor, I just showed your oath that you swore to. You swore, you
Mr.
did
Brooks,
this, Your Honor.
please call your next witness.
You took these oath of offices. You did, Your Honor, 3 of them.
I understand
Which
my
is
oath, sir,
very,
very
very
well.
commendable that, that you decided to be a public servant in these type of matters, Your Honor. I respect it.
I would say that the judge is being a bit too patient with them.
All right, I'm going to have to excuse the jury since Mr. Brooks.
Oh boy, here we go. Jury's being excused.
I'll be back out shortly.
You have to
All right.
honor these oath of offices. You have to, as a public servant, Your Honor. I respect you being a public servant. And this is not to take a shot at you in any way, but these
Mr.
issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. They need
I'm
to be.
excusing the jury. Can you please stop?
Your Honor, this is a rush to judgment. This is a clear bias.
No, it's not.
You are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this
So you're
courtroom
holding me
for
in
the
contempt?
questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm
Consent
advising you
isn't
at this
required.
time to call your next witness, or you will forfeit the right to call these witnesses.
You can't take my
Under
Sixth Amendment
90611,
right.
you
You
are
cannot-
refusing to
you
call a
I
witness.
didn't refuse anything, Your Honor, and you can't deny me my Sixth Amendment right, which is
Mr.
to
Brooks, do
call
you want to
witnesses,
be present in
which
this
is to subpoena
courtroom
witnesses.
while you question your first witness? Because it is now 8:44 and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination despite what you
This-
believe the
This
law
didn't have anything
is.
to do with the jury,
subject
Your Honor.
matter that is what you referenced in front of the
I
jury, and
referenced
then you
that
referenced
after I
my
had
oath.
raised the issues that I was trying
Subject
to
matter
raise.
jurisdiction, as you know, is not
As I
something
don't
the
know,
state has to be, the
it
state
has
must
to be
prove.
proven. It has to be. And
You
if
are
it doesn't,
frankly
show me
confusing
lawful law.
civil
Show me lawful
jurisdiction
law,
in
Your Honor.
federal cases with criminal court jurisdiction in the state.
subject matter jurisdiction or personal jurisdiction?
Mr. Brooks,
Or personal jurisdiction? You don't. You haven't proven.
you have not,
You
I
haven't proven
excuse
for the
the
record.
jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now or we're moving forward.
That's what I want to do. That's what I was attempting to do.
And if you interrupt me one more time, you're gonna go do it from the other courtroom.
And
Because
so
you're
holding
being,
me in
all
contempt.
right, he can go to the other courtroom and we will address these issues
Are you
because
holding
you
me in
are
contempt?
not being respectful, you are disruptive, you are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes because of your nonstop commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said
Okay.
you have a legal issue you want to raise before we get going. What is that issue?
Okay. The legal issue is this. Detective Kacey yesterday testified for the second time under oath in reference to exhibits 13 and 14 that show the backyard of my mother's home, which he stated that he had been to the home, had seen the backyard, all this stuff, when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
Because
fine.
she's
That's
willing,
how we'll
she's
address
willing
that.
to come.
But that's not something we needed to address this
It needs
right
to be
away,
addressed
sir.
because of the issue of the subpoena. That's the reason why it needed to be addressed. That's the reason why I was trying to attempt to
It
bring
could
it
have
to
been
your
done on a
attention.
break. All right, so
Will I be?
you're
because
putting,
I have-
you're asking me to add Dawn Woods to the witness list for you.
Yes, but I also have a question about the subpoena
The subpoena for whom?
for my mother. But I would also like to subpoena the phone records so it can be made part of the record.
He wants to subpoena everyone.
The prosecution
All of this just to freaking delay everything.
should be able to have heard that phone call as well. So they should be on notice of what was said.
I don't know what phone call you're referring to. If
I'm
you're
referring
referring to
to
a
a phone
jail
call
phone
from-
call,
I'm referring
then
to a jail phone call that was made last night, October 20th, between 7:54 p.m. and 8:10 p.m., which I'm sure the prosecution has heard by now. And that also brings up the issue of perjury testimony.
sir, the way that you will address the issues that you're talking about are to call witnesses to challenge that or to present the evidence in support of your position. If you're telling me you need to add Dawn Woods to the witness list, I approve of that. You can fill out a subpoena and I'll direct the state to serve that upon her, and at the appropriate time, we'll have her brought, we'll indicate when in the order of folks she can be brought in. So I'll grant that request.
Will I be
In
able
terms
to,
of the jail records, you'll have to subpoena the appropriate custodian or a witness who can testify to that.
that's what I was trying to gain knowledge of. 'Cause
Well, I can't give you advice on that,
I'm
sir.
not trying to ask for advice. I was, is that
That's
legal for
asking
me to
me
subpoena?
for, I can't direct how you do that. I can't tell you how to do that. You are acting as your own attorney and you will need to figure that out. So you have the subpoena forms. You can research the issues. You have access to legal research materials and other things. And that's how you'll have to address
I
that.
accept for value in return for value this document.
Was that a subpoena form? Thank you. Is there any other witnesses you're asking to add to your, and you can also call Detective Kacey if you want, just so you know.
So that make 3 times he's able to testify?
If you believe he has information that he hasn't testified to, I will give you permission to call him as well.
No, I don't think it'd be necessary. He know what he did.
Well, in any event,
And he know what he
Oh.
didn't do.
We're going to bring the jury back out. And then I expect you to call a witness.
And just so I'm clear, because I was trying to get to that issue, what witnesses are here? Because I don't have any paperwork for Kohler. I don't know. how to
Douglas
pronounce
Kohler,
it.
Stephen Guth, and Erica Patterson. Of those three, I expect you to call one of those witnesses.
I set for value in return for value this document.
For the record, Judge, Attorney Witchow just handed to the defendant for his benefit the police report as it relates to the statement of Douglas Kohler, since he's claiming he does not have it.
Since I know that I don't have it. So let's make that record correct.
You don't have it with you in the courtroom is what you're saying.
I can't find it anywhere.
You've had it previously.
Yes, I had it at one point.
All right.
He is such a freaking little child.
Are you ready to proceed forward, Mr. Brooks?
Yes.
All right, let's bring the jury out.
Well, that was about 20 minutes wasted on the day so far. Is he finally going to call a witness? Oh, I wouldn't be surprised at all, PJC. I think his mother is definitely going to help him delay things.
Jen.
Zach, help Jen.
For the record, he should have been sent out of the courtroom. Just my opinion.
Thank you, everyone. Please be seated. Mr. Brooks, just to make sure, don't block any of the microphones with anything. Both of those microphones should be on. You want to make sure that. Thank you. All right, go ahead, call your next witness.
Yeah, the defense calls Douglas J. Kohler.
All right.
So he's finally called the witness. And yes, Doreen, hopefully I'm pronouncing that right. I agree, he's doing everything he can to delay this trial, but ultimately it's not going to work. Yep, 100%. I mean, it's like he can basically at this point do what he wants.
Your way to the witness stand, which is up toward me, up one riser.
Yeah, just like the witness he called yesterday, Payson. That witness didn't help him at all. That guy may as well have been a witness for the prosecution. All right, I'll turn the volume up now.
Thank you, sir. Have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Douglas Kohler, DouglasKolar.
Thank
you. Go ahead, your witness.
Good morning, Mr. Is it Kohler?
Kohler.
Kohler. Good morning, Mr. Kohler. I want to direct your attention to November 21st of 2021. Do you call that evening pretty well?
Fairly well, yes.
Well, let me back up for a minute. First of all, what do you do for a living?
I'm an IT director for a law firm.
Been doing that for a long time?
I've been in IT for over 20 years.
Yeah, that is a long time. Directing your attention back to the night of November, evening of November 21st, 2021. What did you do that day?
Well, that day I was preparing my daughter to march in the parade with her dance troupe. You know, watched football earlier in the day and got her dressed, and we had to change our plans last minute because my son was not feeling well. So it was just my daughter and I that went to the parade.
And do you recall what time you arrived at the parade?
It was at least an hour before the start time of the parade.
And do you recall where you were positioned at in the parade?
I moved with the dance troupe. So I
Kind of going with the flow.
correct.
And at some point you observed something happening. Would that be fair to say?
Yes.
Do you recall what that was?
Well, after my daughter had finished and I was walking back to our vehicle to go home, I noticed as we were approaching White Rock, which is what we were parked off of, I noticed a vehicle coming through where the parade participants were going. It was a red vehicle. It was honking its horn. It passed a few parade entries on the right-hand side, and then it passed between two of the groups. It veered to the left and went around the next group on the left-hand side, at which point a police officer attempted to approach the vehicle. That police officer had reached for the door handle, and at the time of that approach, the vehicle started to speed off.
I just want to back up just a little bit. You stated that you heard the vehicle honking its horn.
While it was on White Rock Avenue, it was honking its horn.
Here we go again with the car honking its horn. Something he's been
In your
doing
opinion,
throughout the trial. It's ridiculous.
did the vehicle appear to try to avoid hitting people?
At that point, yes.
And you made reference to it coming in, the vehicle coming in contact with an officer. Did you see where the vehicle went after that interaction with the officer?
There was no contact between the officer and the vehicle. The vehicle attempted to make contact. The officer attempted to make contact. But after that attempt, the vehicle sped southward. You know, I know those streets don't run straight north-south on Main Street.
Did you notice the vehicle strike anyone at that time?
I did not.
And what did you do after you saw the vehicle? Once it was out of your view.
Once it was out of my view, I grabbed my daughter and walked as fast as I could to my car.
And to the best of your recollection, how would you describe the vehicle as far as make and model? To the best of your recollection.
To the best of my recollection today, I only remember a red SUV.
At some point, did you report to law enforcement officers what you had observed that evening?
On the Tuesday morning following the parade, I sent an initial statement to the police.
Would that have been the Waukesha Police Department?
Yes, it was to the Waukesha Police Department.
Oh yeah, it definitely drives me crazy when he says that phrase. It's been driving me crazy throughout the trial.
Did you said you sent a statement. Did you initially speak with anyone verbally?
Initially, no, I did not.
At some point, did you speak with someone verbally?
Yes.
And was that sometime after the Tuesday statement that you initially gave?
Yes, approximately 2 weeks after I made my statement, I was contacted by someone with the Waukesha Police.
Do you recall if the vehicle had any tinted windows?
I believe the rear windows were tinted like most SUVs are.
I agree, coward. Any excuse he attempts to give is pathetic. Rotten hell, my heart breaks to all the witnesses that have to relive this nightmare. No remorse. And I agree, and that's a big thing that's being forgotten in all of this sovereign citizen circus. He killed 6 people and injured 62 others,
Had verbally speaking.
and he's treating it like a joke.
You do any follow up on the reports after that?
Yes. The officer that I spoke to had advised me to add to my statement the items that we had talked about.
The law enforcement officer asked you to add certain things to your report?
He had asked me some questions, and the questions that we talked about on the phone, he asked me to add to what I had initially submitted.
And after that conversation, did you have any further conversations after that point?
I had no further conversation after that point.
Had you yourself been contacted by any further law enforcement after that point?
No.
So it'd be fair to say that you were subpoenaed to testify at some point. That'd be fair to say?
Yes,
Do you recall when you received that subpoena?
I received my subpoena last Tuesday.
The 18th?
Whatever day last Tuesday was.
Do you recall whom you received that subpoena from?
The Waukesha County Sheriff. Or
Do you
one
recall-
of the sheriffs.
I'm sorry. I didn't-
Or one of the sheriffs.
And did you do any follow-up information once you received the subpoena? Like, for example, sorry. For example, calling the district attorney's office?
I did not call the district attorney's office. I did reach out to the clerk's office to see if there was any further information.
What do these questions about the subpoena have to do with anything? It's another delay tactic.
Were you or your daughter injured in any way during this incident?
No, we were not.
Exactly. That's all it's doing, Frank. It's killing time. And of course, now these long pauses in between questions because he doesn't know what the hell he's doing.
At this time.
Thank you.
Yes, Your Honor, thank you. Good morning, Mr. Kohler.
Good morning.
Thank you for being here. To be clear, sir, the subpoena you received was issued on behalf of the defendant, Darrell Brooks, correct?
I don't know. That information was not filled out on the subpoena.
Okay. You did provide a typed statement to the Waukesha Police Department, correct?
Objection leading.
And
Overruled. Oh, if there's an objection, let me rule on it first before you answer. Overruled. Go ahead. And his answer, I believe he answered it, but if not.
I agree, Joseph, and he's using basically the sausage traffic stop script.
you did provide
It's
a
completely
to
ridiculous.
the police.
And here we go now with all the ridiculous objections.
Overruled. It's cross. 90611, so 2.
Yes, I provided a written statement.
And in that statement, you described the SUV as driving erratically down White Rock Avenue, correct?
Objection. Didn't testify to that. That was asked and answered.
Overruled. The witness may answer, and it's sub 3, not sub 2, by the way. Go ahead.
Yes, just the event of driving past some participants on the right and then veering to pass the next group on the left.
Okay. You said at that point, when the vehicle was on White Rock, it was honking its horn, correct?
Correct.
There was no objection. You can answer.
And you saw an officer run up and try and open the door to the vehicle, correct?
I don't know that he was trying to open the door, just trying to, I don't know what he was trying to do. He ran and his arm had gone towards the door handle.
Okay. And that was at the intersection of White Rock and Main Street, correct, sir?
Yes,
And you got a look at the driver of the car, correct, sir?
Objection speculative.
Overruled. The witness may answer.
yes, I did.
And you described the driver in your written statement as a black male with dark dreadlocks and visible tattoos. Is that correct, sir?
Objection leading.
Overruled. The witness may answer.
Yes,
Is that consistent with your memory, sir?
Objection speculative.
Overruled.
Somebody should give him a dictionary so he can find out what these objections
Once
mean.
the vehicle went past the officer, you indicated that you saw it accelerate or speed off. Is that correct, sir?
Objection leading.
Overruled. 90611 sub 3.
yes, at that point, it sped away.
Thank you, sir. I don't have any other questions.
Any redirect?
Briefly.
Go ahead.
Referring to the written statement that was just testified to the best of your recollection.
Hey, Ravenwingg. No worries, my friend. We are just watching the Darrell Brooks trial.
An older model red Chevy Blazer.
I do recall putting that down at the time, but that was at that edition that I added 2 weeks later.
So at that time, during the evening of the incident, to the best of your knowledge, that would have been your opinion of the vehicle that you saw.
At the time of that, the day of the parade, I just remembered the red SUV.
To the best of your recollection, what assumption would lead you to describe the vehicle as a Chevy Blazer?
I believe in my assumption, it was just to say it was a older boxy style SUV, and in my mind, that relates closely to a Chevy Blazer.
No further questions.
All right, thank you. You may step down. And you also are excused. Thank you for being here. You may call your next witness.
One second.
More stalling.
If I may have just a quick second.
Okay.
Just call your damn witness. He's not really even looking for anything. He's just making himself try and look good while basically just stalling for time. That's all he's been doing throughout this trial is stalling. Oh, I bet you they are.
Defense will call Stephen Guth.
Hey, Enzo the God, good to see you.
I believe one of my assistants went to retrieve Detective Guth, Your Honor.
Thank you.
Oh, I think that it's going to take more time just filling out the paperwork than actually determining their verdict. Wouldn't surprise me already if they already know how they're going to vote. Like, this is an open and shut case. It's clear that Brooks did it. He's the one responsible. It's going to take more time for them to fill out all the verdict forms they have to fill out. So here's the two he called the witness, yet too many already. Address that. It's his SUV. I can't freaking stand him.
Right, good morning, Detective Guth, if you would, as you are, come to the witness stand, remain standing, raise your right hand, and my clerk Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please have a seat. Please state your first and last name for the record, or names, I should say.
Stephen Guth, Stevenguth.
Go ahead, sir, you're witness.
How long have you been in law enforcement?
Over 20 years.
And how long have you been a detective?
Just over 7 years.
Directing your attention to the evening of November 21st of 2021. Do you recall that evening?
I do.
And were you on duty that evening?
Not initially.
Hey, Shaughn. I wouldn't doubt that at all.
What do you mean by not initially?
It was a regular off day for me, but I received notification to respond to the police department for the mass casualty incident in the downtown area of Waukesha.
So at that point, I'm assuming you were dispatched to that location?
I was not dispatched. I received a Signal message. We use Signal. It's an app that's used that we can share information for investigations. I received a Signal message that this tragedy just happened.
And so what did you do from that point?
I immediately dropped my wife and kids off and responded to the parade.
And got to the parade, what did you do at that point?
I went to the downtown area to assess and see what I could help with.
At some point during your investigation, did you make contact with a woman by the name of Erica Patterson?
Yes,
And what was the nature of that part of your investigation?
I wanted to speak with Erica Patterson because by that point, when I made contact with our command center, they had learned the name of Darrell Brooks and had learned that Erica Patterson was the estranged girlfriend of the suspect of this investigation.
You made reference to estranged girlfriend. What do you mean?
I don't know if I should answer that.
I think the question was pertaining to the word estranged, but we'll move on.
The jury will disregard that last question, that it's been withdrawn. And the statement made by Detective Guth following that.
I'm assuming at some point you took a statement from Ms. Patterson.
I did.
Do you recall if it was recorded, written, you writing it? What was the nature of how the report was taken?
Well, her words were spoken and they were recorded, and then I prepared a report.
Did you prepare the report that same evening?
No.
When did you prepare the report?
Sometime after the 22nd of November,
Why not the same evening?
because after I spoke with her, I wanted to go back and speak with her again.
Did you obtain any statements from any other people that may have been involved with Ms. Patterson?
I did not.
Do you know, to your recollection, if any other officers have taken statements from parties that may have been involved with Ms. Patterson?
Well, the night of November 21st, 2021, I did have a partner with me, another detective.
Do you recall him talking to any other parties that may have been involved with Ms. Patterson?
Well, the detective that was with me was a female, Detective Barron.
The question was, do you know if your partner had any interactions with parties that may have been involved with Ms. Patterson?
I don't believe so.
Hold on,
but
are
I
you
can't-
specifically referring to a date certain or just in general?
I think it was. clear.
I
The
need
date
it
would
clear
be-
for the record.
the date would be-
Well, you know what they say. He who represents himself has a fool for a client.
No, I
And he's making a circus out of this court while doing so.
Did you learn at any point that there may have been other parties involved with Ms. Patterson?
In which incident?
I'm referring again to November 21st of 2021.
Yes.
Do you recall who those parties were?
Corey Runkle and Nicholas Kirby.
Hey, Bama Green Eyes, good to see
You
you.
yourself speak
I
with
hope you're
either of
doing
those
well.
parties, Nicholas Kirby or Corey Runkle?
No, I did not.
Do you recall if your partner spoke with any of those parties?
Which partner?
I'm guessing the female partner that you made reference to.
No, she did not.
And in that recorded interview with Ms. Patterson, what did you learn about the evening of November 21st, 2021?
Which recording?
Are there multiple recordings?
Yes.
What did you learn about the evening of November 21st, 2021 from both recordings with Ms. Patterson?
Your Honor, I'm going to object at this point, as this testimony covers ground that was very clearly covered during the state's case in chief.
I'll give Mr. Brooks some leeway. You are asking for hearsay, though. You understand that.
Completely agree with you, comedian Wool.
Fair enough. Go ahead. You may answer.
I learned several things. Initially, I think is what you were getting at. Ms. Brooks wanted to report that she was injured by Darrell Brooks on November 20th, which would have been Saturday. She stated that she met with Mr. Brooks at Frame Park, and they were arguing over the fact that she did not give him money, and he injured her by slapping her in the mouth and punching her in the eye. The next day, I went back and talked to her again, and she clarified that that actually did not happen on the 20th. It happened on the 21st, and that she got in a motor vehicle with him over the same argument. He was mad that she did not provide him with money. He proceeded to try to take her phone because he thought she was talking to other guys. Slapped her in the mouth, punched her in the eye. She jumped out of the motor vehicle because she feared for her safety and made her way back towards Frame Park. While walking back towards Frame Park, she was calling her friends, Corey Runkle and Nicholas Kirby, to come help her. When she arrived back near Frame Park in front of White Rock School, there was a confrontation in front of White Rock School with Mr. Brooks, Erica Patterson, Corey Runkle, and Nicholas Kirby, where there was some kind of shoving match. And that's when Mr. Brooks got back into the motor vehicle and took off down White Rock towards Main Street. Erica Patterson then made her way back towards Women's Center.
You made reference to being told about an incident from Saturday, November 20th. And then stating that in the second interview, Ms. Patterson stated that didn't happen. Is that correct?
She didn't state that it didn't happen. She just stated that she didn't drive around with him on Saturday, November 20th. But she also met with him and was slapped in the mouth that day too.
If it pleases the court, I have a document here I would like to show the witness.
All right, if the bailiff could have it to the state first to look at it.
Hey, Cats
And then use the
Gamer.
Document camera, if that's hooked up. Otherwise, the bailiff can take it to the witness.
Before we go through that process, I'm going to object. Well, maybe
Let
we
me
should
see the
talk about
document.
this. Yeah.
And give that back to Mr. Brooks, given the content of that.
It looks like
document,
he's looking up at the ceiling. Like,
sustain the objection.
it looks so ridiculous.
Sustain on what grounds?
It's not relevant. Yep, to this witness's testimony.
How is it not relevant?
Here we go. He's going to start arguing again.
Made reference to November 20th. That's what this document is talking about.
It's not relevant to the charges at issue. We can take it up later, and if need be, I'll let you recall the witness, but I'm directing you to move on to a new topic.
Your Honor, I'm gonna respectfully object to that and ask for a finding of fact.
The objection's noted, it's sustained. Well, their objection sustained, yours is overruled. Please continue.
Is that noted for the record? I would like a written finding of fact.
Of course, it's on the record.
That was denied. Keep going, please.
Denied on what grounds, on what lawful law?
90611 him.
You don't have to answer that question as a public servant.
Sir, I've ruled on the objection. It's on the record. Please keep going.
Once again, information that needs to be known is being hidden.
It's not relevant, sir. Please continue.
It's very relevant. He just opened the door on that by saying November 20th.
Objection, move to strike all of the comments made by Mr. Brooks in the last 20 seconds or so, especially with regard to any implication that he hasn't had all of the discovery material.
Objection, I never made any
Prior to
mention
trial.
of not having any discovery material. That never
The
was
jury will
stated.
just disregard, as I've told the jury repeatedly, comments made or statements made by the parties, whether they be lawyers or the parties themselves, are not evidence, and you're to disregard them and not consider them in any way. And if the statement suggested facts that are not in evidence, you should not consider that in any way either.
Thank you, Ravenwingg, for being a member for 6 months. For the record, on the record, let the record show. Exactly.
So is it fair to say that in your report, you referenced 2 incident reports?
You can find videos of the trial, the court videos, on a bunch of YouTube
Overrule the
channels.
objection and let the witness.
Law and Crime Network is the best, in my opinion.
Go ahead and ask your
You
question.
need semantics.
I think you were referring to that he had two.
That's it. That's what his report says. He makes reference to 2 reports, 2 incidents.
Two incidents,
Yes.
not 2 incident reports. Reports would be separate documents. That's what I'm talking about. With that understanding, that you're referring to, I think you're referring to incidents with Ms. Patterson, correct?
Yes.
Go ahead. Ask your question. I think that clarifies so that the witness can answer.
In your, let me back up. You wrote your own report. Would that be fair to say?
Yes.
And in your report, you referred to 2 incidents. That'd be fair to say?
Just to clarify, which report are you speaking about? I wrote several reports.
The one written November 22nd of 2021.
That doesn't surprise me.
Reports and 1 CAD call.
It's like objection is his favorite word.
CAD call, yes.
What do you mean cab call?
Not cab, CAD.
Cab.
CAD.
Cab.
CAD call.
What do you mean cab call? What?
That's a call for service that does not generate a police report.
And what was that CAD call?
That was a call for service near Frame Park for a fight involving potentially a domestic related incident.
Do you recall any other details about that CAD call?
There wasn't much in it because the officer had to leave to go to the parade.
Do you recall mention of a knife during that CAD call?
Yes,
To the best of your recollection, do you recall anyone recovering a knife or you yourself recovering a knife?
there was no knife involved in that incident through my investigation of the report that you have.
But it is fair to say that that's how the CAD call went out, that there was potentially a knife fight.
That's how it was initially, I believe, reported or communicated through dispatch to the officers that responded.
More stalling. Come on, get on with it. See, a real attorney would have their questions prepared and not just winging it.
You made reference, and I'm referring to the second interview with Ms. Patterson. You made reference in your report that in the previous interview that Ms. Patterson was not completely forthright. What exactly do you mean by not completely forthright?
She did not give me all the details of the incidents to me initially.
Do you recall why?
I don't know why she didn't.
So it'd be fair to say that Ms. Patterson had been untruthful with you in the first interview.
No, she told me she was extremely afraid of you. And that's why she didn't want to tell me everything.
Well, you just stated that you didn't know why she was not forthright.
I can't read her mind, but that's what she told me.
At any time during your investigation in regards to the incidents with Ms. Patterson, did you at any time see interviews that were conducted with Nicholas Kirby and Corey Runkle?
What do you mean by see them?
Had you seen any statements made by those two parties?
No.
Understatement of the year, Frank. Throughout this trial, each day, my fury with him gets more and more intense. Like, I can't wait till his sentencing when he tries to object the verdict and sentencing. That's going to be a real clown show, I think.
Would it be fair to say, assuming that those two parties were present for the incident on the evening of November 21st of 2021, would it be fair to say that at some point they were interviewed by law enforcement officers, to your recollection?
Yes.
And you've never seen any of those interviews?
They weren't video recorded.
Had you seen any written statements from them or report from law enforcement?
I received a summary of what they stated verbally from another detective. Yes.
So it'd be fair to say you did have knowledge of what they said transpired on November 21st of 2021.
I had knowledge of what they said. I didn't see anything. Correct.
And to the best of your recollection, seeing what those two parties had said, what do you recall?
Objection.
Grounds.
Evidence, you didn't see what they said, and also calls for hearsay.
Sustained.
What did you read
Objection.
from those statements given by those two parties?
Objection. Calls for hearsay.
Grounds,
Sustain.
grounds for the sustain.
Calls for hearsay.
I believe he wants to call at least 13 witnesses, but one of those witnesses is the state of Wisconsin. Yesterday, he literally tried calling the state of Wisconsin to the stand. So in reality, I think he has 12 witnesses planned.
One second.
Oh, yes, it is. I have a feeling you're exactly right.
Recall what officer took those statements from Nicholas Kirby and Corey Runkle in relation to the incident on November 21st of 2021?
Yes. Yes.
In his mind, he does, yes.
What law enforcement officer is that?
He really does think that.
Detective Van Ells.
In his mind, he thinks he's winning right now.
And after that report that you wrote on November 22nd of 2021, was that the end of your investigation into the incident of November 21st of 2021?
No.
That's gonna be great. I can't wait for it either.
What was the extent of your investigation after November 22nd of 2021?
Judge, I'm gonna object. Well, on the defendant's behalf, I believe here, based on some previous rulings the court has made.
Sustain.
Ask a freaking question. Oh my god. He is so unprepared and has no freaking clue what he's doing. This is why you keep your real attorneys. Never ever represent yourself in
Did you
court.
speak with Ms. Patterson again after filing your report?
Yes.
In reference to the incident from November 21st of 2021?
I don't understand your question.
Did you speak with Ms. Patterson after you filed your report in relation to the incident from November 21st of 2021?
No.
in relation to the alleged incident on November 20th of 2021.
I think that's absolutely true, Frank. Because if you go back and watch the interrogation videos, he wasn't doing any of this soft sick crap. He learned it from. He had to have learned it from someone in jail.
It also goes to one of the ultimate issues that the jury will need to determine, so it's sustained.
No questions, no further questions right now at this time.
All right, thank you. Any cross?
Finally, about time.
No, Your Honor.
All right, thank you, sir. You may step down.
I love how the prosecution doesn't have any cross exam for that witness.
Later for that particular witness.
All right, I'll try to raise that on an appropriate break. Call your next witness, please.
He thinks he's doing a great job, but he is really doing terrible. He's helping the prosecution.
Witness left.
Yes. For that, yes, for that time. Yes. I
No
believe.
one else is here?
No, it's not 10:30 yet.
Now he's gonna try and stall some more.
Who's supposed to come at 10:30, right?
Call your next witness, please. I don't have that list right at my fingertips.
So what happened?
I don't have that list right at my fingertips, but I know there's a witness available, so please call your next witness.
You should know who you have as witnesses and what time they're gonna be there.
Does the state have that? You could pass it over. I don't have that at my fingertips.
Sure, let me try to, I have it, but I'll write it up for Mr. Brooks to review, Your Honor.
Yep, just did.
While we're doing that, if the jurors want to stand for a minute, go ahead, or anyone else in the courtroom.
Like, really? I mean, he is so unprepared. He doesn't know who his witnesses are, doesn't know what time they're coming, yet he thinks he's doing a great freaking job. When really, he's making an embarrassment of himself. All of this for his 15 minutes of fame and then eventually he's getting sentenced to 6 life sentences in prison.
I accept for value in return for value this paperwork.
Thank you, if everyone would have a seat then. Please call your next witness.
And who determined this order?
Mr. Brooks, I'll take up that issue outside the presence of the jury later. There's a witness available. Please call the witness.
That's not the witness that was intended to be called at this time.
I understand that, sir. Under 90611, I have the
Here we go.
on that, so please call the witness who's available.
So I'm being rushed to judgment.
No, sir, I'm trying to have an effective and efficient use of all of our time. So please call
which
the witness.
which is respected, but at the same time, being this is my
All
time
right,
to
I'm going to
present my
excuse the
defense.
jury for right now. I'll rise for the jury, please.
Yeah. Jury is being excused. So Brooks can argue with the judge some more. God, judge should just kick him out. Just kick him out now. Be done with him. Send him to the other courtroom.
All right, thank you. Be seated. Mr. Brooks, under 90611, I do have the authority and just my inherent authority over this case to require you to call the next available witness. You, in my opinion, were not entirely cooperative yesterday with the process,
Exactly.
and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, would come in at 4.
You also didn't provide me with that list,
You were advised on the record,
but
sir.
you didn't provide it to me.
Sir, you chose not to write down, so that's on you, not me.
Nah, that's
So
no, you
here's
can't.
the
That's
thing.
a rush to
Erica
judgment.
Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose. If you choose not to call her right now, then I'm releasing her from the subpoena because we have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her.
Yeah,
She's
the
on
re-
your list. She was on the listing as I understand it, the groupings of 3, Tuesday
that you
morning,
understand it.
Tuesday afternoon,
Did you
Wednesday
receive it?
morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here.
Is that
She's ready to
lawful
go.
law?
Just
She's
asking a
your
question.
witness.
I'm just asking the question. Is that lawful law?
I have the
What a
authority
moron.
under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation.
Your Honor,
Of
why is
witnesses.
it always so hard to just say yes or no? Is
Yes,
it lawful
I have
law?
the authority, sir.
I'm not disputing that.
You just
I'm not
disputed
disputing.
that.
I asked the question, is it lawful law?
Sir, I've told you what I believe my authority is. Okay,
You
if you
told
don't
me
want
what
to
you-
recognize it, that's
told
fine.
me
You
your
want to object
authority.
and note it,
You
that's
told me
fine.
your
Your
authority.
objection
I'm
is
not
noted on the
debating
record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly. And then I'm going to have the jury brought in and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I said I had with the
You
last?
said you wanted to raise an
said-
issue with about
What I
Detective
said
Guzman's
was I
testimony.
might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if
Uh,
I mumble something under my breath,
This
somehow
is-
that's audible, but when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
this is why you don't play lawyer. Like,
I heard what I interpreted was when
Holy
you said I
crap.
didn't have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted. and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't, I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses, my subpoenas.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that from
And
the
so then
beginning.
I
Well,
asked.
then you should have asked the prosecution to help you serve your subpoenas then.
I would not give a specific order.
That's why they're telling you to give
I
an
stated that
order
numerous times.
of witnesses.
I have authority to tell you otherwise. You
I
may
did-
not like it. You
I
may
did.
disagree with
It's
it.
not
You
about
have
that.
been-
It's about the rush
You
to
have not been
judgment, Your Honor.
cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I
And-
never
and
asked them to
frankly,
do
any
that.
attorney in this
I never asked them to
situation
do that, Your Honor.
would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They
No,
volunteered.
They offer.
So at the end of the day,
But we expect
if
your
they didn't want to do
cooperation
it,
in that.
yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
No, common courtesy is the stipulation.
okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was gonna go.
No, I was not.
It is
because if
normal
you-
in a trial.
you can't
to call
put the people
witnesses
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is,
That's a rush to judgment.
there's no rush to judgment here. You
Did the
keep
state
saying
did the
that,
state
sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
No, because
It's
they serve their
irrelevant.
own
Did they
subpoenas
have
and know
to
what
do
they're
that?
doing.
They didn't need your assistance to do that.
Did they have to do it?
No, they did
I
not
didn't have to be
do it.
provided with. We're going to call this witness at this time.
But they're
and this witness
able
at this
to
time.
contact
They
their
didn't have to do that,
witnesses
so why should I have
and
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses'
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this.
How
courtroom.
how am I controlling what's happening? I'm the one shackled to the table with
So here's the
with a shock
situation.
device
It is
on my ankles.
9:50.
I'm trying to control anything.
I'm
I
having
just
to-
want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If
You-
I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to me
because
how that's
the
fair.
process that it has been set up to frankly help you. get
No,
the
it's not
witnesses
helping me by
to
it's helping
court.
the state
And no,
by being able to say, if we know the time and we know
You
the
did
person
not-
and
I
we know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That
I
was the
asked you
whole aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. There was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You
Okay.
did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list.
Yesterday,
It's not my fault.
I'm very.
It's not my fault they
expressly-
wasn't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm gonna stand my ground on this.
I'm gonna
Okay,
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her
fair.
When the jury comes back.
The
out,
court has been
and
nothing but
releasing
fair
her
to
from the
you.
subpoena
You can't do that.
for your
Where's
lack
the
of
lawful law?
cooperation,
Where's the lawful law? I have the right to
You have to
witnesses,
cooperate with this process.
but I
sir.
also have the Sixth Amendment
Well,
right.
We have a witness available for you to call. I can require
It's
you
not
to
the
call
witness
her
that
right
should have
now.
been called at this time, Your Honor.
It is based on the list that you provided and
That
in
didn't
the
have a
order.
time. That didn't have a time or of
I'm not going to
or
play
order.
this game with you,
It's
sir.
not no game.
It
That's what
was-
you don't
it
seem
is
to
a game
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take
I
this as a
asked-
game. That's what
Let me explain
nobody.
this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You
you
think that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor.
Yes, it is.
Nothing about this is a joke.
I never.
That's
said
what
it
y'all
was a
don't
joke,
understand.
Kick him out.
But there's
It is
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game.
I never said it was a
What
joke.
type of statement is that?
Mr.
Your life is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
I
I
understand.
think, Your Honor, with all due respect, I think you
So
should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
And he's still going, even when they muted his mic. So, 5-minute break, as you heard. So, what are we all thinking in chat so far? Well, I definitely think he needs to go. Like, nobody else will be able to yell at the judge like that and just get away with it. And I know some people are saying hold him in contempt, but at the same time, there is a good point that it's that if she holds him in contempt, then that just further delays the trial. And there's really no point in holding him in contempt when he's already in custody. So I have a feeling that when they come back from this break, he's probably not going to call the witness, which, to my understanding, is his ex-girlfriend, the one he's accused of domestic violence on. And hello, and it's Deanna. I'm sorry, I'm horrible with names, but hello and welcome. Just going through the chat. In my opinion, the judge is doing everything she can to keep a mistrial from happening. Yep, and she's also doing everything she can to try and avoid a valid basis for appeal for him. I'm not sure why he is triggered on which witness is called at what time. Exactly. Like, the thing is, though, he had the option to file his subpoenas by himself, but the issue is he's having the prosecution help him serve his subpoenas. So, which is why they wanted a list of which order that witnesses would be called. If he didn't want that to happen, then he should have filed his own subpoenas himself. Just call me Beef. All right, Beef. I've been binge watching all your videos. Well, I hope you've been enjoying them, and I appreciate your support. I am seeing into the future and imagine the sentencing with the coward narcissistic bitch having duct tape over his mouth, and the judge tells him he's a selfish prick with no empathy. Well, somebody said it in the chat earlier that they couldn't wait for sentencing so the judge can really tell him how she feels about him. And that's going to be awesome. I am so looking forward to that. He wants the witnesses in a certain order to manipulate the case. Oh, I don't doubt that at all. I really don't. Let's see. Just put the audio back on the court stream back up so we don't miss anything. He won't call her and the judge will fold. Well, there's been a couple of times throughout the trial where she has stood her ground a bit. I mean, she set him out a couple of times. And yesterday, she literally told him to sit down as he was yelling, "Are you axing or telling me?" And yes, I said axing intentionally, which that's a whole other pet peeve of mine, just saying. He thinks he's going to have some big gotcha moment. He doesn't realize he's not smart enough to do this. Nope, not smart at all. I think the judge has been doing a good job. I mean, she's not in an easy situation here. She has to make sure all of his rights are being preserved, and that everything's going by the book, while at the same time trying to avoid any mistrials or any valid basis for any type of appeal he could potentially file. The judge is amazing, but a little too lenient. That's a fair statement to say. I mean, like this morning, the very start of the day, she should have kicked him out. I will say that. When they come back, I bet you he's still going to be trying to argue nonsensically. He won't call the witness. Then he'll get mad when the judge excuses her from the subpoena. So yeah, I think they said this was only going to be about a 5-minute break, which it does feel like that, but that's the only real downside about doing these live reactions instead of doing it after the day. At least if we were doing this after the trial was already done for the day, we could just skip through the break. So yeah. Just seeing if I missed anything in the chat. I hope everyone is enjoying the stream, and if you are, do not forget to hit the thumbs up button. Just helps out the channel, helps the channel grow, helps the YouTube algorithm. Really wasn't sure if I was going to do this stream today, but woke up this morning and I was like, hey, may as well. Because we have been discussing this case every day on Discord, like live discussing throughout the trial. So I'm not sure if I'm going to do the full day or just the morning session. We'll see, but if I don't do, but if I'm not streaming the entire trial today, we will definitely be discussing it on the Discord server, which I will put a command in chat right now. And if you want to join the Discord, feel free. We have a lot of fun and hang out and talk about all types of things. And now it's just basically a waiting game, waiting for them to come back. I would play a video from I do have some highlights lined up from yesterday and earlier today, but they said it was only going to be a 5-minute break, and obviously we don't want to miss anything live, so right now, in a way, we're just stalling for time, so to speak. Who else wishes they had a remote control in his shock cuffs? Well, I bet you whoever has that control, I mean, I bet we all wish we had it, but whoever does have it in the courtroom, which I'm guessing is one of the bailiffs, I bet he's wishing he could just press it. And the other thing I'm just thinking right now is that the jury must be pissed because most of the time they spend more time out of the courtroom than they do in it. Well, at least that's just how it seems. Like, because he doesn't want to call his witness, which forces the break. And they've been sitting in that jury room now for probably 20, 25 minutes, if I had to guess. Like, the jury has lives too. They have things. They want to get this trial done with. I think he may accidentally push the button. That would kind of be awesome. The sole witness likely to favor him is his mother. He told her he would delay the trial. Yep, I do remember that being brought up, that he said that to his mother, which is why he wants her to testify, basically. So if I had to guess, they'll hopefully be coming back any moment now. He will probably still be acting up. Oh, no doubt in my mind. I'm expecting him to act up. Judge is probably taking his Xanax and Shoy. The jury is sure getting a good workout, up and down, leaving the courtroom. Yes, they are. And I know a lot of this time, like, he's argumentative in front of the jury. While the jury's there, like earlier when the witness was still on the stand, and he started arguing, like, the jury is seeing a lot of this, and that's not going to do him any favors. In my opinion, no, they're not. At least, not for him, at least. They are not helping him whatsoever. Hell, the witness Brooks called yesterday that he questioned for over an hour, that witness may as well have been a witness for the prosecution. Because that witness literally helped the prosecution. And that guy, he hated Brooks. If you haven't seen that testimony yet, I mean, I would recommend going back and watching it later, because it does get a bit testy in times between Brooks and that witness. Oh, yes, he did take his shirt off. It was the very beginning of the trial. The judge was reading all the jury instructions, like how every trial begins. And he was in the other courtroom. I forgot, he was mad about something. So he was sent out to the other courtroom, and he was wearing jailhouse clothing. He took off his shirt, kept waving around the objection sign. That was a sight to see right there. Like, it was right at the very beginning of the trial, if I recall correctly. There's a video of him driving the car through the parade route. How does he think he's going to get away with this? You know, I don't know. In his mind, he thinks for some reason he can. Like, his defense could be maybe that he did, he was doing it at the time. Oh, here we go.
Appearances are as they were before. I would just note Attorney Opper's not at the table, but I presume she'll be back shortly. I will be advising the clerk to have the jurors brought out. And then I'll ask you, sir, to call the defense next witness.
Can we address subject matter jurisdiction? It still has to be.
Of course, subject matter jurisdiction.
So your objection is noted.
Is the audio on?
Your objection is noted for the record.
Is the audio on?
Yes, it's on, sir.
And let me guys know if you can hear the court stream all right.
Subject matter jurisdiction that has yet to be proven for the record.
For the record, I have addressed it.
No, you haven't
And
proven it
here's
for
it
the
written.
record.
And your objection's noted for the
Have you
record.
proven subject matter jurisdiction for the record? Have you proven it? Has the prosecution proven it?
Oh, okay. Email that to her and print it out.
So that's your judicial determination that you don't have to answer that, Your Honor, being a public servant?
I was talking to my clerk. I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that.
If they didn't have jurisdiction, the trial would not be taking place right now.
Thank you, everyone. Please be seated. The defense may call its next witness, please.
You want to say, I'm trying to make sure I got the paperwork since I'm being rushed to judgment.
I just put it up all the way that it can go, so hopefully that's a little better.
Oh, there you go. All right.
Go ahead.
Defense calls Erica Patterson.
Great, thank you. We'll have her brought in.
Since I'm being rushed to judgment.
Oh, we actually called her. This is going to be good. And he's already in a pissy attitude, so I expect some fireworks here. That would be epic. And they should.
Good morning, Ms. Patterson. If you would please make your way to the witness stand, which is on my right. You may recall it's upper riser. When you get there, please remain standing. Raise your right hand, and my coach, Teresa, who's across from you and on my left, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Thank you. Please be seated. First thing I will ask you to do is to state your first and last names for the record.
Erica Patterson.
Thank you. Go ahead, your witness.
Oh, you wasn't spelling the name?
I believe it's on the record from previously, but go ahead. You can spell your first and last names, please.
ErikaPatterson.
Just 1 second, Your Honor. I'm trying to find some relevant paperwork here.
God, he should already be prepared. By the time the witness takes a stand, he should be prepared to question her. This is just another stall tactic. All he's doing is stalling, and it's ridiculous. And the judge should tell him, like, you gotta be ready to go. Like,
I'm sorry about that. 1 second. I'm trying to find this paperwork. Just had it on the table.
cue the Jeopardy music.
When you're ready. Did you print that off for me? Did you email? Did you stop?
I'm just gonna start the questioning. I'm not seeming to find paperwork that I just had on the table for some reason, odd reason.
Those are just all of his, all like the reports and stuff. At least that's what I'm thinking in regards to
Good
the
morning, Ms.
incident.
Patterson.
Good morning.
So what do you do for a living?
I have my CNA certificate.
I'm gonna direct your attention to the evening of November 21st, 2021. Do you recall what you were doing that evening?
I was hanging out with my friend Corey at Frame Park. I had spoken to you, Mr. Darrell Brooks. You came out there at Frame Park and met me after Miss Corey separated from me with her friend. Me and you got into an argument.
Whoa. Pursuant to the question,
I am answering your question.
I was referring to the judge.
I was hanging out
I
with
think
Miss
I kind of
Corey.
got a little ahead of.
Oh my god. He doesn't like her answer, so
I'll let
he's
you
trying to strike it.
interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question.
Sure.
What were you doing the evening of November 21st, 2021, before linking up with the alleged defendant?
Hanging with my roommate at the time at Frame Park.
And what were you and your roommate doing?
I'll object. We covered this ground during her testimony previously.
Objection. And grounds for, I object to that and grounds for the objection on behalf of the state.
Ms. Brooks, we did cover many of these topics previously, so if there's new topics, please go to those. I'll give you a little bit of leeway to lay some foundation, but go ahead, ask your question.
That's
The
what the,
objection is from the state is overruled. Do you remember the question?
You asked me what we were doing at the park with Corey? Is that your question?
yes.
We were drinking. I was drinking Mike's Hard beverage.
Do you recall around what time of the evening it was when you and your roommate arrived at the park?
I do not remember. We left where we were staying a little around afternoon. A little bit around afternoon.
Yeah, it has been difficult, but we all
Do you
know
recall?
he's a disgusting a-hole, so to speak.
Do you
He's
recall
gonna get what's
having,
coming to
any
him.
phone interactions during that time when you and your roommate were at the park?
Phone interactions, yes.
Do you recall who they were with?
You.
What do you mean by you?
Darrell Brooks.
Is Is that usually the name you refer to the alleged defendant by?
Nope.
And also remember, most prisoners, from what I've heard, they don't like child killers and mass
Would it be
murderers.
fair to say that
He won't have fun in
during
prison.
those, phone interactions, there was a talk of you guys meeting up? Would that be fair to say?
Yes.
Do you recall, to the best of your recollection, what time that would have been at?
No, I don't remember. It was throughout the day.
I'm sorry, are you making references to the phone conversations being throughout the day?
Yes.
And so at some point, would it be fair to say that you did meet up with the alleged defendant?
Yes.
Do you recall what time that was?
I just told you no.
Do you recall if you were still at the park during that time or had you moved locations?
Still at the park.
And was your roommate still present with you at that time?
No, she left. We went separate ways. I stayed at the park and she went her other way with her friend,
Do you recall who that friend was?
Nick.
I'm assuming, or let me back that up. Would it be fair to say that at some point during the meetup with the alleged defendant, things got a little chaotic? That'd be fair to say?
Yes.
I agree. This is difficult to watch. And you know, the sad, pathetic thing is, Brooks is loving every second of this. He's having fun right now. And
do
it's
you recall
disgusting.
if at that point you were still at the park?
When we met up,
Yes.
well, we were at the park for a second, then we drove around.
Where did you drive to?
Around, then me and you, Mr. Brooks, were arguing in the car. We went up this is a street, it's like a hill. Went up there, and then me and you got into an altercation. I got out of the car, walked back towards Frame Park.
Well, wait, again.
Hold on, she's answering
Okay.
your question.
Um,
You asked her where you drove from. Go ahead.
What?
Finish.
yes, ma'am. And then I was walking down the street, and I left your car. And that's when you followed me, and I walked back towards Frame Park. And you were following me.
Made reference to walk back to Frame Park.
I don't know the exact street name. It was I walked back down the hill. I don't know the exact street name.
Did you at any time, sorry, did you at any time during your travels back to Frame Park, did you at any time notice that there was something going on in the area?
No. When I got to Frame, I was too worried about walking back to Frame Park. When I got to Frame Park after I left it, that's when I realized there's something going on.
Yep, it absolutely does hurt his BS defense. Like, there's no good reason for him to have her as a witness.
And did you ever arrive
It only
back at
hurts
Frank Park?
him.
Yes,
And what did you do when you arrived back at Frank Park?
I called my friend Corey and told her that me and Mr. Brooks got into an altercation. Mr. Brooks was following me. I went back to the SUV, the car, and you argued with me somewhere. I walked back across the street, and by that time, Miss Corey had already walked towards us to meet up with me.
You made reference to you calling your friends.
Mhm.
Do you recall? Well, let me back up a little bit. Did you call your friend Corey or the friend that she had left you to hang out with?
Corey's phone, I kept calling her phone kept going to voicemail, and I called Nick's phone. He put Corey on the phone. I said Darrell Brooks had just hit me.
I'll be right back.
I'm going to back up a little bit, if I may, to the day prior, November 20th of 2021. Do you recall what you were doing that day?
Well, where I was staying at the shelter at first, I was arguing still with Mr. Brooks all throughout the day. Me and Corey had left, and Corey and I stepped away, and I went back to Frame Park. On the Frame Park, that's where I met you at. Me and you also got into argument that day, but we didn't drive around. We're at the Frame Park.
So you're saying that you and the alleged defendant were together the day of November 20th, 2021?
Yes,
Do you recall around what time that was?
I do not remember.
And you stated you were briefly with your friend Corey that day?
Yeah, but she went a whole different direction. She didn't come to Frame Park with me. She turned on a whole different street right before Frame Park.
Do you recall at any time on November 21st of 2021 being interviewed by a Detective Guth?
Yep,
And do you recall giving a recorded report at that time?
I don't remember.
Do you recall if you had given Detective Goof all the details of the alleged incident on November 20th of 2021?
I didn't give him all the details, but I did the next day when I seen him.
He is so pathetic. Oh my god, ask a freaking question, dude. Like,
Funny. Were you aware that it was reported there was in fact no incident on November 20th, 2021?
That's not true.
Objection, move to strike the answer and the question.
Grounds.
Lack of personal knowledge, hearsay.
Sustained. I'll strike the question and the answer. The reason stated, sir, rephrase, or
So can I show the witness the same paperwork that I attempted to show?
no.
And why not?
Not relevant.
How's it not relevant when that was just testified to? Wouldn't that be opening the door?
No. Next question.
I completely agree with that.
Any reason why?
He hasn't asked a single question that has helped his case whatsoever.
It would be
Like,
reported no
all
incident
the
happened on November 20th of 2021?
all these witnesses
Grounds.
are helping the
That's
prosecution.
not in evidence. Sustained.
In his delusional,
Grounds for
messed up
sustained.
mind, he thinks he's winning right now.
The record speaks for itself.
So upon speaking to Detective Goof during the first interview, do you recall why you were not forthright with information?
It wasn't that I was not forthright, I just didn't tell him everything right away.
Why not?
I don't know, Mr. Brooks.
When speaking with a law enforcement officer, would it be fair to say that you should be truthful and honest?
I was very truthful. I just didn't tell him everything at once. Told him the next day, Mr. Brooks.
And in the alleged incident on November 20th of 2021, were you injured?
No. Well, you did hit me a little, like a little.
Were you injured?
No, I didn't have any marks on me. Is that what you're asking?
Hey, Emily M. Happy
So where were
Friday.
you?
I hope you're doing
I
well.
meant it.
Objection. Stacy,
We are watching the Darrell Brooks trial.
I believe the witness understood the question. She answered it. It may stand.
Did your roommate observe any injuries from the alleged incident on November 20th, 2021?
She knew about it, but there's nothing visible on my face.
Do you know if your roommate had spoken with law enforcement about these alleged incidents
I
from
don't know.
November 20th of 2021 and November 21st of 2021?
I don't know.
Did she ever tell you yourself that she was interviewed by any law enforcement?
I don't remember.
One second.
Yep, and in his mind, he thinks that it's a great idea to have her as the witness. A narcissist's time are what? Wasters, because only their time
So what
matters.
time did you meet up
Exactly.
with the alleged defendant on November 20th, 2021?
I don't remember.
Oh, we all do. And like we were
Morning
saying
time.
earlier, he
Afternoon.
loves every second of this.
I didn't hear that.
Afternoon.
And what were you doing prior to the alleged meeting up with the alleged defendant?
Objection,
Grounds.
asked and answered.
Sustained.
Grounds for the sustain.
Asked and answered.
When?
Next question, please.
When was it answered? So to the best of your recollection, you can't recall why an alleged incident on November 20th of 2021 was reported to never happen.
Objection,
Grounds.
same reasons as the previous objections.
Since facts not in evidence, this characterizes her prior testimony and irrelevant.
I object to that respectfully and
Next
ask for a
question.
legal finding of fact and a legal reconsideration of that ruling, Your Honor.
Denied.
Now he's going to
Noted
keep
for the
asking
record,
the
next
same
question,
question
please.
over and over
I'm
again.
trying to figure out
Watch.
how
Calling
something got
it.
pulled out of thin air.
Either there, he's going to ask stupid questions like, who's the plaintiff?
So it would be fair to say that you have a child in common with the alleged defendant. Would that be fair to say?
Yes,
Yeah, is that the only child in common?
yes.
You have any other children?
Objection,
It has
Grounds.
nothing to do with the case. Sorry. I'm
Hold
sorry,
on,
Your
there's
Honor.
been an objection. Not relevant. Sustained.
Grounds for the sustain?
The record speaks for itself. Next question.
What was the record speaking for itself? I didn't hear it.
Not relevant.
How is it not relevant?
Next question, please.
How is it not relevant?
Because it's not. Her having other children that she didn't have with you is not relevant to the case whatsoever. Man, he makes my blood pressure go up, I think. Like, the stupidity is incredible.
The child that you have in common with the alleged defendant,
He doesn't consent to being called Darrell Brooks.
how old is that child?
15,
Do you keep regular contact with that child?
off and on.
Describe what you mean by off and on.
I'll object,
Grounds.
this is not relevant.
Not relevant. Sustained.
Grounds.
It's not relevant, sir.
She answered it.
Next question, please.
And the child in common that you have with the alleged defendant, does that child live with you?
No.
Objection,
Grounds.
relevance.
Grounds.
Sustained, not relevant. You don't have to answer that.
Do any of your children live with you?
Objection,
Grounds.
relevance.
Sustained.
Grounds for the sustain?
Not relevant.
That goes to the credibility, Your Honor, so how is it not relevant?
The objection has been sustained.
For relevancy. I object to that and would like to inform you that I intend to appeal that decision unless you want to give a legal reconsideration.
Good for you.
Noted for the
Your
record,
appeal is gonna
Director
be
Attention
laughed
906.16. And the basis for the objection being sustained is it does not fall within the categories listed. Next question.
It's just his word salad.
Is that lawful law?
Of course, he is the defendant.
Next question, please, sir.
I'm getting there. This is lawful law.
Oh my God, lawful law again.
Wisconsin State Statute 906.16.
That doesn't answer my question, but okay.
You know, he says he's being respectful, but all he does is argue with everyone, talks under his breath, and he's just an a-hole. Like, the more I watch of him, the more angry and unlikable, as if he was likable already, but the
Where did
more
you meet the
unlikable
alleged
he
defendant?
gets.
Reno, Nevada,
How long have you known the alleged defendant?
16 years.
You made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No, I don't remember.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming that would mean no contact at all via phone or anything like that.
No.
I'm sorry you had to go through that.
I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state. The bailiff will take them. That's not proper procedure, sir.
Of course, and it looked like pictures of his kids.
I'm gonna object to those being shown as a witness. They have no relevance whatsoever to this trial.
Yes, they do. And I'm getting to how they have relevance.
They've also never been disclosed to the state before this moment.
Sustained.
Sustain why?
Not relevant.
They are relevant. It creates foundation.
You're using words, but you don't know what
Take
those
the issue
words
off at the presence of
mean.
The jury, at the conclusion of the
Oh my
witness,
God.
we bring the witness back in, but next question, please.
And these need to be offered into
100%
evidence as well.
agree, Beeve, but he
You
loves
stated
every
that
moment of
There's
this.
been no contact. How would the alleged defendant obtain photographs from you if there's been no contact?
Objection.
Grounds.
Assumes the fact, not the evidence.
Grounds.
Sustained. Assumes facts not in evidence, not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and
it's
at
facts.
this point
I
in
got
time,
Here we
facts
go.
here.
after
Facts.
the alleged.
He's gonna start arguing with the
date of
judge
violation
again.
Here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, that the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
You are the defendant.
I'm gonna excuse the jury.
Here we go.
I'll rise for the jury.
At the rate we're going, there's no way he's going to get through the witnesses he has planned for today. Start, stop, start, stop. It's ridiculous. He's turning it into a freaking circus, and he's loving every minute of this.
Think you be seated?
That's awful funny. Your Honor, I find it.
Hold on. All right, sir, I'm gonna let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
on, hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to
It's
her testimony.
relevant because it was testified to.
Thanks for staying up late, and I'm glad you're
First time
enjoying the
testifying,
stream, Linda.
And then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak
Do
and
you
have
want
contact?
to open up the door to the other act's evidence of?
That's
you
not
using-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Kacey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I've been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or
I
why she
didn't
wouldn't
question
have
her about that.
contact or
I
not,
didn't
you are
question her about
opening
that.
the door to that testimony. All of
How
my
does-
rulings have
how
been
does-
made to prevent
how
what
does
could be
pictures
seen
work?
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial.
It's
But
unfairly
you can
prejudicial.
open the door
Your
to
Honor,
that,
It's
sir.
unfairly prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness
Then
can
have
get on
you
the
turned
stand
that
and lie on the
document
stand.
over to the state?
He's so ridiculous.
Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When
So-
did you receive the
so
document?
what-
Hold on. When did you?
when-
I'm having you make an offer. When did you receive the
Okay,
document?
but that, I just want to stay for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
That's
then,
not true. That's a
no,
misstatement of the
that
of the
is
evidence.
true.
No.
She said it herself.
No, marking an exhibit is not creating an
No,
exhibit.
not marking exhibit. She said
We're
that
not going to go
essentially-
down a tangent, sir.
All right,
I'm going
I'm
to
not gonna
focus
argue
on
with
this,
you,
and I'm
but
going to
it's
give
not
you the
fair.
opportunity
It's not
to make
fair.
a record.
it's not
All right.
fair. It's not fair. Your Honor.
When did you receive this document that you claim was sent by this witness?
It's not claimed. It's for a fact.
Sir, it hasn't been established yet. I need to make a
So
record.
do y'all want
I
the
wanna
letter?
see
Y'all want
the
the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna
so now
know
I gotta
when you
bring that in.
received
Now
it.
I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can do it, no problem.
It's not, sir, there are proper procedures.
'Cause you're not
for
doing
why
it
you make a
properly.
record. If I don't-
Exactly.
If you don't make a record,
So
then
what?
I can't make a
It
ruling.
threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks,
Come on, man. Stop.
when you
Stop
aren't
Stop
even
it.
letting
You're a
me
public
ask the
servant, Your Honor.
questions.
I respect your courtroom. I
You do-
respect you. You're a public servant.
No, you
though.
don't.
Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Patterson, please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm gonna make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. the
And what
state-
happened to that paper? Because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So
things.
who took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly,
Okay,
sir.
whatever.
So you're doing it once again.
Whatever. Just make your record.
Wow. He is so
The document-
disrespectful.
That Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count and they have prosecutorial discretion. And I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My
Your Honor,
guess
Your
is
Honor,
maybe
with all
to
respect-
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. Now all of a sudden I can't.
And now
find it.
you're impugning, though, like somehow you're impugning the integrity of this court,
No,
of
I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make
You
the assumption
made-
that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you
yes,
interrupting
you
me?
may. Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't.
Glad
find
you're
my
enjoying the
documents, I
stream.
don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say you.
implied it.
That's what
sir.
you're
Did I say
implying.
that?
You
I
said
never
your
You stated it
papers were
implicitly.
missing.
I never asked the bailiffs, hey, did any one of you touch my table?
Oh
I
my
never said
God.
that to them. I just said, I can't find my paper, which is the truth.
And the
I'm
way
looking
that
down.
you said it, like,
I didn't point anyone
With a-
out
with-
though.
and like,
I
well,
don't
that's
think that
kind
that's
of
fair.
interesting.
I don't
I don't
think that
have a
that's fair to
document that was
assume.
just on my table. That is what you said.
That's
words
what
to
I
that
said, but I
effect.
did not point the finger at anyone.
So
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given,
I can see if I came in and said, hey, one of you moved something off my table, or if I would have directed that towards the state, or if I would have directed that towards the clerks or something like that, then that would be more of a validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time I can't say every time because that would be an absolute, but many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing.
She has had
perhaps even to
enough of
stall
them.
and to delay.
I'm sorry
That's
you
my
feel that way.
that I'm making a rule. You're doing it again.
I mean, because it has no validity.
Wow.
So
Kick him out.
I am trying to make a record outside the presence of the jury about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right. Then there's the statute on bias, 90616. All right. And none of the questions, as I heard them, went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs. I think, and you can clarify the record momentarily when I'm done, that you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters actually over a period of time. It wasn't, I referred to this one because this one had the pictures. But
and why do you believe
one,
it was from
to
Ms.
answer your
Patterson?
question, to answer your question with clarity,
Thank you. Does it have a date on it? The letter?
no, I didn't bring the letter, I brought the pictures. Because I thought, from my interpretation, I thought showing the pictures would
I
be
wouldn't
okay.
be
How do
surprised.
how do
At
I get-
least that's what he wants to do.
So my mind was saying, show the pictures.
But I don't think the judge will let it go that far.
The witness
We need the
knows that
letter.
they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility before this jury?
It goes to the credibility because she's put on this facade of being so afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, oh, I wonder how you're doing. And oh, this and this and that.
I
Oh,
don't think
you know,
she's
I still
ever
love
said
you.
she was
Oh,
afraid. I
mhm.
think that was the officers who may have stated that, but I don't believe she
But
ever said that. She specifically said today, when you asked her, why did you, it was either why did you go back or why did you have, I'll look at my notes. And she
It was
said, I
why
don't know.
it was why weren't you forthright with all the details? That was the question.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate to
Honor.
her credibility before the jury?
Who else could these pictures be from?
I'm going to ask you point blank. Did you get a letter that's signed from her?
I got, what do you mean signed? No
How
one
do you know?
signs letters.
What's your why do you have a belief that they are from her?
I have multiple letters from her.
You're not answering my question. Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you-
content
are you
of the
kidding me?
letter? No, I'm not kidding you. I need to make a record.
Wow.
So you're
Like,
making a statement.
he's becoming
that
more
this
and more
letter comes from her and
disrespectful
that's
by the
irrelevant to her
second.
credibility.
Your Honor, I'm gonna go out on the limb here.
And I'm asking you why you hold that opinion.
I'm gonna go out on the limb here and assume, which I know is true, you've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail. No one is gonna when you
You're
say
not
to me,
answering my
when you
question,
say to me,
sir. What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? Could be your mom, could be, I'm just saying,
why
could be
was
anybody
somebody?
else.
This is,
You got to answer my question. It's
Your
called an
Honor,
offer of
this-
proof.
but you still got to understand why this is mind-boggling to me. Like, how I got a child with this woman. Why would I not know her handwriting?
But you have to
Why
lay
would
a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her, not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child. I'm trying to I need to know. It's called an offer of proof.
Are you serious?
What do you believe? Why do you believe they're from her? I am serious. I need you to
Because they're
answer.
from her.
But you're assuming.
Also, because
How
he
else am I
likes to
supposed
stall.
answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term
bottom
or
line is I
something?
need the letter. So if you're gonna question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not gonna allow any questioning without having that letter.
So
The
what
state
about-
has the ability to question you about that or question this witness and to look at the veracity of what your claims are here. So I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with
So-
you in court?
I just said no. How many
Okay.
times I got to say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much or you answer quietly. And I'm taking notes and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
In a
that just
quiet
fine.
courtroom,
And
yes, we can hear it very
and
clearly.
everybody assumes that it has to be disparaging. Or,
Once again, you're doing this tactic. where you
because
try to
it's not a
go
tactic,
off
it's
of what
facts.
we're talking
It's
about
facts.
to some other reason.
It's facts. Because
some
I
other
find
thing.
it hard to believe that
I'm gonna
all
let
of
the
a sudden
state.
nobody hears what I say.
I'm gonna let the
Come on,
state
man,
make a
stop.
record of why they
Stop.
believe it's objectionable because I haven't let them do that. I've given you multiple opportunities to tell me why you
So
believe
I
it's.
didn't get these pictures from nobody else. Why was
The
somebody
record will
else
reflect you have two pictures that you believe were from this witness.
that I know is from
No, that you believe.
that I know?
All right, I'll ask the state their position on all of this.
My position, Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before. Two, because we have reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state.
He's about to
make
have a
their argument
meltdown. I
without
can tell.
interruption, sir.
That's a lie.
He's about to go ballistic.
three, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all, it doesn't make her an incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada. And for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's, I
Furthermore,
object to that,
I'm not.
because
done.
that's a lie.
Let
Because
him
at the end
finish.
of the day,
Let
if
him
we
finish.
gonna open the door
Mr.
on that, no,
Brooks.
since he wanna make a record and not be
Here,
accurate, so
like-
let's be accurate all on the record since you think
Kick
you know
him
so
out.
much.
Once
So we
again,
can
Mr.
open the
Brooks
door
is
on,
being
we can open the door
loud,
on how old she told me
disrespectful,
she was when we met.
interrupting.
We can ask
He's-
that
He
question.
is
Wow.
being over the
Did you
top,
ask that?
animated
Did you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No,
finish.
that's not, I'm not gonna sit here and let somebody be inaccurate on the record and lie on the record.
Right, under Illinois versus Allen, I've warned him repeatedly, he's being removed from the courtroom.
He's being kicked
And you know
out.
what? Let me dial that back. We're just gonna take an early lunch, 1 hour, we'll
Aw.
be back. And, unless he brings that letter, and he
Don't
can
sit
show
there and try
it
to
is
think he knows what's
inadmissible,
going
she will
on.
not be questioned, and under 90611, I will
Then you gonna
declare the
talk about where my kids
cross-examination.
live. You don't know where,
closed.
you don't know where, what
Thank
happened
you,
at
we're
the
in
time
recess,
all this
1
happened,
hour.
bruh. Get your facts straight. So let's open the door on all of it then, so we can get all of it on the record.
He's still
Since you think you
going.
know so much. Did you know she said she was 18 when I met her? Did you know that?
Wow. And they finally muted the mic. Just wow. Judge should have been firm, I think. She said that she was going to remove him to the other courtroom, but then said they're taking an early lunch. I think he should have been removed to the other courtroom. So it's lunch now, the lunch break. They said for an hour. I can bring up some highlights from yesterday that I didn't showcase here on the channel because I didn't stream yesterday. Go Judge. Time for taser. Time for the taser cavity search. All right, and before we go any further, I just want to give a shout out to Bieber for the $6.99 super chat. Thanks for the great stream and not talking over everything. Great members here too. Thank you very much for the super chat. I know that came in a little while ago, but I didn't want to interrupt what was happening in court. So thank you for the super chat. And I think what we'll do now during the lunch break, I do have some videos to pull up, or to bring up, rather, from his outbursts yesterday. So, because they're going to be at lunch for an hour, so we may as well just watch them. Just going to bring those up if I can find them. Just bear with me for a moment. All right. So yeah, that's what we're going to do. Let me bring up, and I'll keep the stream going. So the live court stream on my end in the background, so we won't miss anything. But let me just bring up his rant from yesterday and the prosecution's response to it, since we have some time to kill. Share screen. All right. So this is from yesterday, and I'll start playing the video while I do something in the background. So this is from yesterday when a witness was on the stand and Brooks loses it.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Kacey.
Objection, I don't consent to being called that name. Yeah,
Noted.
I
Do you
got
have
a
any
question.
questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That
Sustained.
was a question. When was
Sustained.
this
As to the
video
form
made
of
an
the
exhibit?
question,
When was this video made an exhibit? That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
Sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking, when did he see the video? I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Kacey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I'm
It would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same.
See, and in this situation, he's losing it now because he thinks the prosecution is laughing at him. Ugh, so much unnecessary drama that he's caused, so to speak. I'm just going through the comments because I've been trying to keep up with them, but I just want to make sure I didn't miss anything. This is such an awesome judge. She doesn't put up with crap. I agree with that. And yeah, she's trying to prevent a mistrial. Yeah, this was about the music video. He was mad because the prosecution was able to play it, and the reason he went off because he was just angry about that.
Parties to avoid commentary.
Okay, well, can
and
you do that,
gestures
please,
and
and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to
I'm
be
with you.
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Kacey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained
it
as
was
to the
not
form
brought
of
up
the
in
question
the
assumes
testimony.
facts not in evidence.
If you had seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning something that you had viewed numerous times before?
I'll say with my
Objection, objection, compound, asked and answered. This statement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained as to the form of the question.
This is mind-boggling. This is mind-boggling.
And there he goes again, talking underneath his breath. It's mind-boggling. You know what's mind-boggling, Mr. Brooks, or whatever the hell you want to be called, because you do not consent to being called that name? Your behavior during This entire freaking trial has been mind-boggling. You have been disruptive, rude, arrogant, and you're having fun with it. And you think you can do whatever you want, but in reality, you can't. That's mind-boggling to me that you think that way. Hey, P. Barnes. Good to see you. I hope you're doing well, and happy Friday. Hey, Mark Baggett. I have been watching the live drama, the 1 hour lunch, and man, he's digging a hole for himself. The judge is doing a great job and not letting him have much to appeal on. Yep, we've been watching it live too. We're just, in the meantime, since it is lunch, playing some highlights from yesterday to basically to kill time, I guess. But yeah, his behavior, and he is digging a hole for himself. I completely agree. Every witness he's called so far has not helped him whatsoever. Every witness has really been against him and is just hurting himself more. Also, I want to thank all of you guys for hanging out with me today. I really do appreciate it. I'm pretty sure a few other people are streaming this trial as well, so other people within the community, I mean, but I appreciate all of you just hanging out. All right, let's get back to this video.
Can you clarify again why you viewed the video this morning?
Objection asked and answered.
Sustained.
So you're gonna sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
Thank you.
This is mind boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair. Hide things from the jury.
Oh yeah, he thinks they're hiding things from the jury now. And this is where it starts to really get interesting and heated. But my favorite part that we're going to be watching in a little bit is the prosecution's response and the judge's response.
Jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked. I see what you people are trying to do. It's not right. It's not fair and it's not right.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being.
I did hear, I think he has a shocking device on his leg, I believe. That's what he's wearing, because he made reference to it a few times. Yes, I don't know what they're called, but they basically have the ability to tase him, basically. Just going through chat. All right.
And called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to make a record. So just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
It's like deal with the toddler, except the toddler.
Right, based upon the offer
behaves
of proof
better.
provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated I
That's
would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time,
I
sir.
have not obtained that.
Um,
Right now, that was my first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the issue.
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there's absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Kacey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Kacey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that, and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Kacey through his knowledge of it and the identification by him of you in it. Because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists. And that is my finding as it
What do you
relates to
mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was, how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can make
didn't
an
have
offer of
anything to
proof
do
on
with.
that because obviously they marked it as an exhibit.
But
They
with
had
all
it. So
respect,
go
Your Honor,
ahead,
you're
Attorney Opera.
mischaracterizing what I.
Oops, sorry, I forgot to unmute. I'm doing good. How are you doing, my friend? Gotta love watching Brooks make a fool of himself. But you know, it's like I said before, what's being forgotten in all of this is all the victims he killed and injured. It's being forgotten because he wants to make a mockery of the court. Hell, even yesterday, as we're seeing, like, his behavior has gotten more and more aggressive each and every day.
What I said, and that the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit? That
Attorney
was
Opera,
the
go ahead
issue.
and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Kacey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing that-
didn't say
Hold
what it
on,
was.
sir, stop interrupting. We have to make a record of it. You've
They make the record clear.
interrupted multiple times. I've been abundantly
Make
patient
the record clear.
with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to
me.
be quiet?
Stop rolling your eyes at
Are
me.
you?
Stop
I'm looking
mumbling.
right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet, or are you telling me to be quiet?
Go ahead, Attorney Opper.
Thank you, Your
I'm
Honor.
gonna take that
And
as
just
asking.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's
Here we go.
authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Kacey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that We came up with the video, which Detective Kacey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV.
He doesn't understand, overstand, or stand under. Just saying. I remember this. After all she says, Brooks says, I object to that. Oh my God.
However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
That was my favorite part of the entire trial so far. Round of applause for the prosecution to say basically what everyone has been thinking. Yep, the prosecution was tired of his BS. And now the judge even has enough of him. So let's see the judge's response.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling.
Oh my God. After all that, he says, I object to that. Oh my God. It's like the saying goes, he who represents himself has a fool for a client. And he is absolutely a fool. No, I don't believe so. Nope. And I'm going to make a judgment and say, no, that is not frowned upon, Beaver. And just so you guys know, I am keeping an eye out on the live stream from today, so we won't miss anything when they come back, which probably will be around 1-ish, I would have to think, or a little after that. Eastern time, I'm talking. But yeah, let's keep watching this.
Doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination. So the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Kacey, what is your offer of proof as to why I should allow Detective Kacey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Kacey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't know specifically what you're talking about,
There's a reference made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an exhibit.
She's been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir,
say
but I've observed.
He says he's not an idiot. Well, that could be argued upon. Hey, Patricia Bradshaw, good to see you and happy Friday. Hope you're doing well. We've been watching the Darrell Brooks trial, but it's currently on a lunch break, so we are watching some highlights of the trial so far. Oh, well, the judge has asked him, what does he want to be called? And he won't respond. So the last time it was brought up in court, he said that he wasn't sure yet if he was going to testify. If he was smart, he wouldn't testify because all it's going to do is completely hurt himself, because if he does decide to do that, then the prosecution has the right to cross-examine him. Now, as a spectator, I would love to see that happen. But if he had any brain cells left in his head at all, he would not testify.
Say you, Your Honor.
No. What I've observed is
listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time. I didn't
need
say
specific
anything. I didn't say
instances, sir,
anything
because
about
I
it.
have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I
involved
haven't
with that?
noticed that other than the one thing you pointed out.
Well, we
today,
have
which
we
then-
have cameras. That's what the
Mr.
cameras are
Brooks,
for.
let's refocus our attention on what we're here for, and that's
Okay,
this
then
trial.
I take
And
that
do
as
you have
I
anything you
take
want to
that
put on the
as-
record?
I'm putting.
That is a fair statement. I mean, he knows exactly what he's doing. And I don't know, someone taught him the sovereign citizen crap in jail, or he found it somehow, researching it. But he's making himself out to look like he's an idiot. He's a victim. They will crucify him on cross. I really hope so. Me too. That's why I want him to testify. That would truly be a sight to see.
Putting it on the record
As
if I
it
get a
no,
chance.
you need to let me finish. As it relates to the video and my decision to admit
She
it.
just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over to
made it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm
What
not
do
aware
I
of
need
any.
legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying that
exhibit.
she can
She did
pull
not make it
anything
up.
out of her suitcase.
So that's a figure of
During-
speech.
Okay, so what is
Alright.
it implying to? What would that be implying to?
As
How would
attorney,
anyone?
all
How
right,
would
I'm
anyone in
moving
my
on
position?
because you're not
How
providing me
would-
with any
How would
legal
any?
basis.
I didn't even
for
finish.
me
You
to-
you told me that I can make the record. I'm attempting to
Sir,
make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said that
anything-
you didn't even let me
You're not
finish.
letting me
You
finish.
didn't let me finish either, Your Honor.
Because you're not providing.
A freaking toddler behaves better than Darrell Brooks. Like seriously. Like, this is what you signed up for, dude. You kept saying, I want to represent myself. I want to represent myself. Then you should know what the hell is going on. Like, this is what happens when you decide to play lawyer and have no idea what you're doing.
Me,
But
you're
how
gonna
do you
rant,
know I
you're
wouldn't get to
providing
that if I
commentary,
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal
There
basis.
should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes, you are. That's what a real lawyer does. He's clueless. The man is freaking clueless.
Yes,
That's ridiculous.
you're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I
Mr.
supposed
Brooks,
to do that?
the bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're
discovery.
not talking
There's
about opening no doors. We're
absolutely
talking
no-
about being fair.
There's
Because
absolutely
if I
no
would've did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
With
by
all
that
due
exhibit.
respect, if I had
Right.
done that,
I am going to move on.
if
from
I had
this
done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down and
I don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please.
you mean? I'm asking, what do you
Mr.
mean?
Brooks, you continue to
That is
come
not,
at me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking?
I don't need
do
to
that?
ask, I'm telling you.
I love how he just goes quiet there.
Thank you.
Like,
There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Kacey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Kacey about speaking with Dawn Woods, his mother, and about a time in August. And there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Kacey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Kacey about either one of these two topics is my first question.
Okay, why was it an issue with me bringing it?
Mr. Brooks, I'm only going to ask you one more time, and if you
I'm
don't
saying,
answer
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I don't
a
like
yes or
I don't
no.
like your tone and the way you're talking to me.
the audacity to say that to the judge. I don't like the tone you have with me. Like, who the hell do you think you are? Like, you're the murderer that killed 6 people, injured 62 others during a freaking Christmas parade. So, you know what? And we don't like the fact that you did that. So, screw off, Brooks. Like, really? Blood pressure, man. It's like, really? For him to say that? Like, I don't like your tone. Screw off. Seriously. I'm curious if he would argue with a male judge like this. Probably not. I say no. I mean, because it's clear he doesn't respect women. So, I mean, I doubt he would do this with a male judge. Yep. Sorry about that. Like, blood pressure went up 160 with that last statement. Just going through the chat, see if I missed anything. All right.
I don't
Mr. Brooks,
appreciate it.
sit down. I don't care if you
Nah,
don't like my
I'm
tone,
not
but
gonna-
you've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's not
Stop
accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to
other
the-
courtroom
Let's talk to each
now.
other like adults then,
Mr.
because
Brooks,
I've never.
You're not acting like an adult. You're acting like a little child having a temper tantrum because he can't get the toy he wants at the store. Like, that's how you're acting, Brooks. He's a narcissist POS, can't stand anyone treating him the way he treats others. Exactly. He thinks he can do whatever he wants. Excuse me. He thinks he can do whatever he wants, but then when someone says no and he doesn't like it, he goes off and acts like a little child. He doesn't know how to talk like an adult. Exactly. Yeah, I killed 6 strangers and ran over a bunch of others, but Judge, you were mean to me. Stomps on foot, shakes fist at the sky. That's exactly what he's doing. Put him in timeout. The judge has done that a couple of times. And I think if he keeps going when they come back from the break, I think she will put him in timeout again.
I told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Kacey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
giving
to
that
understand. If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Thank you,
what I'm
everyone.
supposed to answer if I don't understand?
All right, so that's what happened yesterday. Then a little bit after that, he decided to give his opening statement. I think we still have a bit more time, so let me just bring that up. Just get it queued up here. Bear with me for a moment. Again, I hope everyone is enjoying the stream, and if you haven't already, please consider liking the video, liking it, sharing it, and all that stuff. Let's play this video. And while this video plays, I'm going to take a quick break, but I will be right back.
The defendant will now make an opening statement. The purpose of an opening statement is to give the defendant an opportunity to tell you what he expects the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
Obviously, I don't have any rehearsed or well prepared speech, so I'm just gonna speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year, there's only truly been one side told of this story. And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, and finally everyone getting a chance to get the full story. You won't hear me try to argue facts. The fact is that this incident was tragic, very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing on both sides. And when I'm confident that the evidence will show, sorry, I'm getting a little emotional. When I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. And this incident was never even thought about. it's easy to I'm sorry. Just need a second. Think it's easy to look at the magnitude of something like this and form opinions. I think it's easy to disregard a lot of factors. And I think in reference to what I stated earlier, it's easy to forget the other side of the coin.
All right, I'm back. Sorry about that. As you can see, he's already started with the waterworks. Like, and I said this on the Discord yesterday. He didn't say anything in this opening statement about how he was going to prove his innocence or prove that, I don't know, or prove that it wasn't him doing it. This seemed more like a sentencing speech, kind of. Just going through the chat, see if I missed anything. Isn't this admitted that he did it? Sure seems like that, but it's actually his opening statement. Honestly, I would not be surprised if he was. Either that or he should have been an actor. Because I don't know about you guys, but I'm not buying this fake crying stuff. Like, I'm really not. I'm not buying any of it. Because about 10 minutes after this opening speech, he just goes back to the way he was. So it's ridiculous. Also, I'm still keeping my eye on the live stream. They're still on break. Promise we'll do our best to not miss anything when they come back live. But anyway, let's get back to his opening statement.
There's been a lot of suffering involved in this incident. A lot.
Yeah, that you caused.
Obviously, with the families. With the community. And even the alleged defendant's family as well. There's been a lot of suffering.
In my opinion, I don't. Like, I don't know, it seems like he's forcing himself to cry. I don't know, it's a tough call, but just my opinion. I think he's forcing himself to cry to try and make himself look somewhat good in front of this jury.
A lot of misunderstanding. And I just want you to keep in mind everything that will be presented in its totality. Keep in mind. The power that you have. I believe that shouldn't escape your knowledge. This has been a long process for everybody. And what I believe is when it's time for you to make your decision, all of you, I believe that, and I pray that it's the right decision. That all the factors are weighed. There's been a lot of words thrown out there about the alleged. A lot of speculation, a lot of ridicule.
Understandable. Don't worry. We should be back live any minute, I would guess, with the live
Words
trial.
like demon. Words like monster.
Those words perfectly describe you. Demon and monster, which you are.
I know a lot of the time I've been before you see me with this mask on. Yeah, I've had my reasons for that. But I feel now is the time to, it's important that you see me for who I am. No mask, for who I am. I think this is the moment for that. I pray that your eyes.
Oh, it absolutely was. I mean, and when he comes back from break, I have a feeling he's going to keep it up, Calvina. Like, the dude's an idiot. He acts like a little child, and he's never going to get it.
As the ears remain as open as possible. I understand that you alone decide this case, this matter. The power is in your hands. All of you. To determine for yourselves what truth is. Thank you.
Thank you, sir.
And that was his BS opening statement. I didn't buy it at all. I still don't buy it. Rewatching it, it's all for show. It's all an act. No sympathy on my part, on my end rather, whatsoever. Did you notice he starts on subject matter jurisdiction crap as the jury is entering the courtroom every time? Yep, he does. He starts that every time, thinking that it's gonna somehow get overturned every time, even though it won't. I think we're coming back, so let me bring the trial back up on screen. Can hear audio, so I'm guessing they're coming back any moment now. He talks about unfair when the jury is in the room. Yep. I don't know. I don't know what he's trying to do. Like, is he trying to get the jury to think that this isn't a fair trial for him, or what? Like, yeah, and it does. It's kind of sounds like a speech that you would give right before you were about to get sentenced for 6 life murders. I mean, 6 life sentences for 6 murders that you did, not mentioning killing 62 others. That's the kind of speech it sounded like to me. I'd kind of like the judge to troll Darrell Brooks a bit and ask him what subject matter jurisdiction is, and convince the judge she does not have subject matter jurisdiction. Yeah, that's the other thing too. You're right, PJC. He loves to show them the Bible. Which I don't know what he's trying to do with the Bible, but I don't know what he's trying to show the jury with that, but he believes in God, that he's really a good person maybe, but if I had to guess, the jury is done with his BS. So hopefully this trial starts back up any minute. It's been about an hour now. As you can hear, we do have sound in the courtroom, so now it's just a waiting game, I guess.
What time is it, man? Anybody?
Yeah, I think you're right, Payson. You can hear him. What time is it? What do you have? Somewhere to be, Brooks? Like, he also says, I don't dispute the facts in the charging documents. He admits he's guilty and he doesn't say that in front of the jury, but it's the judge who sentences him. That's exactly right. I mean, this is all basically academic at this point. I'm not sure if that's the right word, but this basically is happening right now because by law this trial has to. We all know he's guilty, but this trial is just going on because he pleaded not guilty, even though we all know he did it. It's all fundamentals. It's all basically just going through the motion, basically. And you know what? It is just a little bit past 1 o'clock here on the East Coast, so I am going to enjoy a Bud Light. Because it's a Friday afternoon and I'm watching an idiot make a fool of himself. Cheers. The Constitution gives him the right to the trial. He is making it a shit show, which I do 100% agree with that. But we like the Constitution, so we have to deal with it. I mean, it does sound like they're getting ready to start back up, so should be any moment now. Kind of feel like a frauditor, kind of airing dead air.
The record should reflect 12:10. I do have Mr. Brooks in the other courtroom so that I could make an adequate record without interruption. We are on day 15 of trial, and today has been a rough morning to say the least. We are in the stage of this trial where Mr. Brooks has the right to present relevant and probative evidence and to call witnesses.
Also, the audio is coming from the echo, I should say, is coming from the court stream itself. It's not on my end.
From my perspective, disagreement with how I yesterday and in the days
He's already in the
preceding that,
timeout room.
set up what I thought was a very reasonable way for witnesses to be called into this courtroom on his behalf. Going back to when the state offered to, excuse me, serve subpoenas on his behalf and talk with or coordinate with these witnesses to come into court. And yesterday, I wanted to narrow things down a bit as
That's on the court's stream. There's nothing I can do about that. That's on their end. That's on the court's end. There's nothing I can do about that. Sorry.
Presentation of evidence and exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. And let me just back up a moment, because I think it's worth putting into the record once again the full language of 906.11, which is entitled Mode and Order of Interrogation and Presentation. Number 1, control by judge. The judge shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following. Make the interrogation and presentation effective for the ascertainment of truth. Avoid needless consumption of time. Protect witnesses from harassment or undue embarrassment. The next section, a witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to not testified to on direct examination. The next section, leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And then the next part talks about civil cases would not be applicable in a criminal case. So that is a statute that guides what I do, not just in this case, but in every case that comes before me for trial or even a motion hearing. And in my almost 11 years on the bench, I've presided over dozens and dozens of cases that have gone to trial. To say that this has been the most challenging of my career would be an understatement. I've done my best, I believe, to be fair, to be unbiased, to protect the rights of not only Mr. Brooks as it relates to this trial, but those of witnesses, those of the victims, and of course, last but not least, the jurors.
Yeah, I just checked with the other court streams of this, and they're all having the same echo. So sorry, everyone, but there's nothing I can do about it. It's on their side, the courtroom, the courthouse.
It is true. I did not do my usual practice of asking if there were any preliminary issues that the parties wanted to address. In my mind, I wanted to get to the witnesses. We are at that stage. I knew there were a number of witnesses to be called, and I wanted to ensure that it was done effectively for all of the reasons that are stated in 906.11. And I thought it was reasonable at the time to simply take up issues dealing with legal matters at a break. That's why I brought the jury in. During the jury coming in, Mr. Brooks continued to talk, make statements. The record speaks for itself. I'm not going to, frankly, I couldn't tell you everything that was said at that time. At this point, I think it's important to note, though, it's the tone, the demeanor, the decorum, or frankly, the lack thereof for many days on end throughout this trial. It has become apparent that when the jury comes into this courtroom and leaves this courtroom, that Mr. Brooks makes disparaging remarks about the integrity of this court, of these proceedings, and of other parties in the courtroom. He repeatedly references things such as subject matter jurisdiction, which there is a written decision.
Yeah, I think so too.
That I have filed in this case.
Brooks isn't wearing any
It is
headphones,
very clear.
so that's why there's an
This
echo.
court has subject matter jurisdiction over this case. This is not a civil case. This is not a case in federal court, for example, where subject matter jurisdiction sometimes becomes an issue for things like whether there's a federal question that's involved. Every now and again in a criminal case, subject matter jurisdiction is a type of issue that comes up, but not under the circumstances here. I'm not going to rehash everything that's in my decision. I stand by that decision. The record has been made abundantly clear that Mr. Brooks does not believe this court has jurisdiction. His objections have been noted, well documented by the record that's being taken down. I know from my experience, not only as a judge, but as a litigator, that once that objection is made, it's preserved. I even stated at one point, I think there's a standing objection. I will note that for the record. Mr. Brooks continues, in my opinion, to bring this issue up in front of the jury to distract, to delay, and to call into question the integrity of these proceedings. Frankly, maybe to create an issue on appeal if he is convicted.
That's exactly what he's doing, I think. I think the judge is dead on here. She's exactly right.
This way. He is not in this courtroom presently because on day 15 of this trial, and specifically this morning, right, we have a history of disruptions, delay, interruptions, disrespectful behavior, the common courtesy, I think that just as a human being, we all would expect have not been followed. It's evidently made, let me restate that. It is evident to this court that when there is a ruling that Mr. Brooks disagrees with, whether it be an evidentiary ruling, whether it be on subject matter jurisdiction, whatever it may be, that he has a pattern now of directly confronting the court, asking for, is that verified law? Can you prove that? Is that an actual law? He starts debating the topic once again, or he will even try to further turn us away from that by bringing up another topic. For example, just today, when the issue came up about this letter that he claims was sent to him by Erica Patterson, and I asked repeatedly for an offer of proof rather than answer the question directly, Mr. Brooks instead started talking about an exhibit the state offered into evidence yesterday. And from my perspective, he doesn't address the merits of the issues that are before this court and then tries to divert things down a different path, whether that's to delay, to disrupt, or just simply be discourteous. I think all of those words would be an accurate description of what is happening. That was one piece of, or one objection or series of objections that I actually went off the record. Not off the record. I actually dismissed the jury in order to try to get an offer of proof from Mr. Brooks. And as that exchange went on, it got, from my perspective, he got louder. He got more disrespectful. I think it's fair to say his behavior was volatile, and it's because of that that I called an early lunch. And it's because of all of those things. Even when I attempt to give the warning that he will be removed upon further behavior, he immediately interrupts and says, "Are you holding me in contempt?" A very clear indication to this court that he is attempting and trying and actually disrupting the proceedings so that I can't make an accurate record. Like I said, it's challenging. That is why he is in the other courtroom muted, so that I can make the record. And I will confirm with my clerk and the bailiffs. I should have done this at the beginning, but I believe, thank you, my clerk did confirm that they can see, they can hear, we can see as well. it is this court's opinion that Mr. Brooks is blatantly pushing the limits of what I have tried to establish in terms of when to call witnesses, how to call witnesses. He pushes the limits on asking questions that are not probative, that are not relevant, or that directly contravene a prior ruling by this court related to other acts evidence. That ruling that I made was to the benefit of Darrell Brooks, not the state, Darrell Brooks, the defendant. There have been multiple witnesses who have themselves stopped, basically looked at me and, can I answer that question? Basically, is there nonverbal communication to me? Or some have actually said, I don't think I can answer that. There have been other witnesses where I've stopped them from answering so as not to bring in the other acts evidence. The most recent of which occurred this morning with Erica Patterson and the repeated questions to her related to either information she did or didn't give the detective when the detective spoke to her on two separate occasions. There's been other questions throughout the trial to, I believe, to Detective Guth directly and other witnesses who had information about why that may have been the case. But this witness, I think, has been very, very careful to not run afoul of the court's prior ruling.
I agree with that. I
leads
think it
to
is a prop.
The evidence claimed by Mr. Brooks that he has related to a letter and photographs. As I indicated before the break, I've looked at both 906-16 and 906-08. Those are generally two of the statutes dealing with character evidence. That would be 906-08, 906-16 deals with bias. From my perspective, the questions that were actually asked and answered about do we have a child together? Well, he didn't ask it quite that way. I'm summarizing, but regarding their common child, regarding whether he sees the child on or off, where they met, things of that nature, are solely to attack her character,
Well,
as a mother.
that's the
Just
nice thing
fully
with him in the other room. She can just mute him again,
The
though.
only character evidence that would remotely be allowed
Yeah,
under,
you're probably
at least
right,
for a
Shaughn.
witness under these circumstances, would be character for truthfulness, which would not even be from this witness. It's typically another witness comes in and testifies to that, and only about opinion evidence, their opinion of the person's character for truthfulness. Under bias, 906-16, I didn't see where it also related to her credibility. It says, for the purpose of attacking the credibility of a witness, evidence of bias, prejudice, or interest of the witness for or against any party to the case is admissible. Again, simply attacking her on her motherhood. That's my perspective. I did not receive the answer to the repeated questions I asked regarding the offer of proof and this letter that he claims was sent by Erica Patterson, and then the photos. The issue as it relates to this witness is a single charge in the case. It is a battery charge with a date of violation that is alleged to be November 21 of 2021. To allow Mr. Brooks to ask the witness about contact after that point in time is not relevant. He has not given me any reason as to why it's relevant. The state also, I think, rightly points out that if those questions were to be answered by Erica Patterson and other questions along those lines that were questions that were objected to by the state and that I sustained, Mr. Brooks would open the door to what only could be described as very damaging evidence against him related to the other acts evidence, related to whether he has a relationship with the children or not. And frankly, a topic I am not going to open the door to. I'm not going to allow. It's a side issue. It is not relevant. It is not probative. But certainly one could argue, based upon the questions, topics that the door could be opened to.
Also, I love how he has his
It is
mask
my
back on.
duty
Like,
as the judge
what's the
assigned to
point of
this
wearing the
case to
mask? You've
ensure
already shown
that the
you
trial
don't need it.
is fair, that relevant and probative evidence comes in, and that it is done so in a way that's effective and efficient for the presentation of evidence, including the testimony of witnesses. And so I'm not going to allow questions related to the children in common or child in common, at least any further, between Mr. Brooks and Ms. Patterson, when they met, how they met, the nature of their relationship now, whether there's been any contact between them since he was arrested and going forward. Because nothing that I've been presented with would suggest it relates not only to relevant and probative information, but even to her credibility as a witness. I will give Mr. Brooks a final opportunity to make an offer of proof as to why he believes my decision is wrong.
Yeah,
That
but he
needs
hasn't
to
worn it though
include,
all morning. He hasn't been
why
wearing the
an
mask
offer of proof
all
as
morning,
to
or since
why he believes
most of
this
yesterday
letter
either.
is from Erica Patterson and why it's relevant to the issues in this case. Because he came in to the courtroom this afternoon and is not in here, but in an adjacent courtroom, I want to make some additional findings as well and kind of just tie up a few loose ends for the record. As the court, the Supreme Court in Illinois versus Allen stated, it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country.
Nope, the judge put him in
A flagrant
timeout, in the
disregard
timeout
courtroom
room.
of elementary standards of proper
And
conduct
welcome back,
should
by the
not
way.
and cannot be tolerated. Trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. This court has utilized an adjacent courtroom with superior audio and video capabilities that I believe are the functional equivalent of being present in this courtroom. Mr. Brooks's behavior today alone was disruptive. I would absolutely characterize it as stubbornly defiant. It was interruptive, and it certainly aggravates the proper administration of the criminal justice system, of this trial. There was nothing dignified about it. There was nothing orderly about it. I would remind him once again of SCR chapter 62, which are the basic expectations of courtesy and decorum in the courts in the state of Wisconsin. I'd remind him of the golden rule. Do unto others as you would have them do unto you. Be respectful. Be kind. Give these proceedings the due respect
Have a safe drive,
they deserve
Catalina. Thank you for hanging out.
for himself. I do not believe he even shows respect for that. I'm not looking for any further input on the issue of removal or any further record. I wanted to make that record without interruption, which is why Mr. Brooks was in the other courtroom. When we come back to this courtroom, I will ask Mr. Brooks for an offer of proof. He will be brought in. So we'll go off the
Oh,
record for
boy.
that momentarily. An offer of
They're
proof,
letting
if he
him
wishes
back
to do
in.
that,
Oh,
related to,
no.
the
Get your
letter
popcorn
for
ready.
questioning. I also want an offer of proof as to what probative and relevant information Ms. Patterson will be testifying to based on his direct examination. This is a witness who was called by the state initially. This is a witness where Mr. Brooks had a full and fair opportunity to cross-examine her on a prior date. He was allowed to call her himself. The vast majority of the testimony today has been a rehashing and a representation of her testimony from the other day. I'd have to look at my notes for the date. October what? October 7th, I believe she was the third witness. We did not glean anything new, probative, or relevant through the course of the questioning today. Because he's had a full and fair opportunity to already cross-examine her, because he's had a significant amount of time this morning to question her, I will require that offer of proof, and then I will make a decision whether any more questions will be asked of the witness. At this point in time, does the state anticipate any cross of Ms. Patterson? But I'm going to ask that when we come back, when everyone is here. With that, I am going to take a very short recess to have Mr. Brooks brought back into this courtroom so that we can continue with testimony and evidence. Thank you.
Well, get ready for a train wreck. That's all I have to say. I think he should stay in the other room for the rest of the day. I agree, but I do understand why the judges keeps bringing him back. It's because basically, so he can't complain on appeal that he didn't have a fair trial, that he was sent into the other room. He wasn't allowed to question his witnesses in person. So I kind of get why the judge is letting him come back, even though we don't necessarily like it. But I mean, the judge is doing everything to prevent a mistrial or a valid appeal. Welcome back, Beaver. You haven't missed much. The judge just made some rulings basically saying that Brooks was not going to abuse Erica if she comes back on the stand. And during that entire ruling the judge just made, Brooks was in the timeout room. And now Brooks is being brought back over to the main courtroom. So, should only be a brief break here. Yep, the judge handled that very well, in my opinion. But now I have a feeling it's going to be, I don't know, best way to put it. Trying to think of the word. Let's just say, I don't think Brooks is going to last long back in the main courtroom. if he decides to start rambling like he's been doing. And you got to remember, there are a bunch of witnesses that are there that, of course, are not going to get to today because of him, unless they stay very late and get through all of them. Was he only called 2 witnesses today? I think, I don't know, I think he had a list of like 6, 7, or 8 witnesses. Yeah, dumpster fire would be a good word. He's going to turn this into a dumpster fire, I think. And that's exactly what she's doing. I mean, what he's doing. He's re-victimizing her. It's what abusers do. When they came back from lunch, had the judge already put Darrell in the timeout room? Or did he come back to... Oh, right from lunch, he was in the timeout room, like automatically. When they came back, he was already in the timeout room. There's no way this trial... I thought I read that they want this trial to be over by next week. And at the rate it's going, because of all these interruptions, there's absolutely no way. At least I don't see how that's going to happen. It's not going to end by next week. He will come in, argue with the judge for an hour, and then get kicked out again. I never understand why she lets him do this every day. I get it. I mean, the judge is in a tough position. She's doing everything to preserve his rights while also maintaining the decorum of the courtroom. It sounds like they're coming back. Yep.
Back on the record, I've been advised that Mr. Brooks does not want to come over to the main courtroom. Mr. Brooks, I'm advising you, you are invited back to this courtroom.
He doesn't want to come back.
It's my sincere hope that you want to come back here. I see you're reading something, but we are at the point in this trial where you have a witness still on the stand, obviously figuratively at the moment, not literally. I'm going to ask you if you are ready to answer my questions from previously and also to let me know.
And thank you, Salicus. I'm sorry, I'm awful at names, I know, but thank you very much for the $10 super chat. I appreciate it. Thank you very much.
I've been advised he can hear and see. Mr. Brooks, we are on the record. I'll go through the topics one by one. You are in the other courtroom. You are invited back here. Would you like to come back here? Yes or no?
Of course, he has no idea what the
audio
hell's
is on.
happening.
Would you like to come back to this courtroom, sir?
You're unmuted. So I'm finally unmuted.
You've been unmuted for a while since I came back on. My understanding, sir, is you'd like to be in that other courtroom. Is that true? Record to reflect, he's putting on the headphones.
What's going on?
Mr. Brooks?
Exactly,
Inviting you
Frank.
back
It's all to delay
to the
again.
courtroom. My understanding from a relay of information from the bailiffs is that you don't want to come back here.
I ain't say nothing.
All right, are you ready to come back then?
Not if I'm just gonna get held in contempt again.
I didn't hold you in contempt
He's not,
Then
you're
why am
not
I
held
even
in
over here?
contempt.
so that I could make a ruling and make a record without an interruption. pursuant to my authority in Illinois versus Allen.
So did you make your record?
I did.
Am I ever gonna get a chance to make the record without being interrupted?
Mr. Brooks, I'm asking you, the first question is, do you want to come back into this courtroom?
Not if you're gonna hold me in contempt.
Sir, I
I
need
don't
to
wanna
continue with the trial.
I don't
So
wanna
if you
keep being
don't
held in
answer yes or
contempt.
no, then I will presume you want to be in that courtroom, and you'll, by your conduct, waive your right to be in this courtroom.
I'm waiting for
By
it.
what conduct? I didn't consent to
By
being held in
failing
contempt.
to answer my question, sir. So I'll ask you again.
Are you gonna hold me in contempt? I don't wanna be held in contempt.
I will ask you again, sir. Would you like to come back to this courtroom?
I'm supposed to be in there anyway.
So twice now I've asked him, he has not answered a yes or no. Mr. Brooks, I'll ask you a third time. Would you like to come back into this courtroom?
Yes, if you're not gonna hold me in contempt.
Given his yes, I will close the courtroom. He'll be brought over, and then we'll continue when he comes into this courtroom. Thank you.
And for the record, I do not consent to being called that name.
He always has to have the last word. Like,
Yeah, I'm always muted. I don't know why she think I can hear everything she's saying perfectly clear without the headphones. Oh, that's a trick to help hold everything up too, right?
he's still running his mouth. They forgot. Yeah, they forget to mute the mics.
You know, but hold me in contempt, man. I might as well stay over here.
You're not in contempt, you idiot. You've never been held in contempt. Oh, they finally muted it. Oh, that was great. So now he may or may not go back over to the courtroom again. Probably cause some more delays. I agree, Jamie. He literally is a child, but in all fairness, a child behaves much better than him. It's one of those words you read and heard, but not at the same time. And I'm sorry if I butcher names. Like, ever since I was a kid, I've been terrible with names. Try not to do it, and I don't do it intentionally. How about we call him Karen? That's a good name for him. Like, I'm actually surprised he hasn't asked to speak to the judge's manager or get a supervisor. Because that's something Karens and Sausage do. I want the manager. You need to get me your supervisor. It's all. He's doing all of this to stall. And I'm pretty sure I said this towards the beginning of the stream. The jury has been out of the courtroom longer than they've actually been in it. I mean, literally, they've been sitting in the jury room or at lunch longer than they've actually been in the courtroom listening to evidence and testimony. This judge is the chief judge. She is the manager. Exactly. I was only trying to be helpful. You don't need to apologize. We appreciate the stream. And I appreciate every single one of you being here today. Didn't really plan on doing this stream last night, but then I woke up this morning and I was like, what the hell? I've been watching it since day one, so may as well do may as well do a court stream on a Friday morning and now afternoon. Oh God, don't even get me started with math. Math was one of my weakest subjects in school. Yet somehow though, I was able to pass physics with a B plus in my senior year of high school, even though that requires a lot of math. And I was terrible at it, so we all have our strengths and weaknesses. He spelled out his name in an interview room video. Yep, but of course he's going to say now that wasn't him. He's not the person. He's the third party intervener. He does not consent to being called that name. I don't know. I think I've been watching too much of this trial because last night I had a strange dream about this trial and Brooks running his mouth and getting kicked out again. Like it's literally gotten to the point where I'm having dreams about this trial. I have learning disabilities, including math. I also passed physics with a B, and I don't remember a lot of it. Yeah, I had some learning disabilities too, and I was always good with like writing, writing out essays and history and basically every other subject in school, but when it comes to math, I'm just like terrible at it. You mispronounced nightmares. I've had students who acted exactly like this. They were 6, 7, 8, or 9.
Record, it's 12:48.
Here we go again.
All right, let's take up the issue of the letter and the photographs and your offer of proof, sir, if you have one.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof
We
to
go
provide,
past all
sir?
that. We
Oh, you
go
can
past
tell
all that.
he's in a
I don't need to
pissy
ask you
mood.
questions. It's too much of an issue. It's too much of a problem.
Mr. Brooks, I'm going to ask you for a third time. Do you have an offer of proof
I
related
just
to
said
the
no.
route?
I just said no. I just said that.
All right,
Wow.
thank you. Then based upon there being no offer of proof, then my decision stands. As to the continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left.
Same.
It's almost done.
What topics generally were you going to question her about?
I guess I'll have to look in here because so much that happened since over the past hour and a half or so. I can tell you one thing. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I'm not sure why. He keeps doing that.
What do you mean
He
by
did that yesterday as well.
direct? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well, Mr. Brooks, this is your opportunity to present relevant and probative evidence. But under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
Topics that you haven't already covered.
What, to pursuant to the police report or something? Is that what you're asking? I don't understand.
I'm asking you. I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you say it related to topics, right?
You can just give me the topics. I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions. That's why I'm saying it was only,
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here.
Do
Possibly
you
is.
do you see a written statement with her signature
I will
on it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson? It's my understanding Detective Guth spoke to her on both occasions. Is that right?
Yes, with Detective Barrett with him on the first occasion. Detective Barrett wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir? Do you want to question her about, so I know with specificity?
Yep, it's what he does. It's what he does best, is delays.
How many officers did reports? Because it seemed like it's more than just two. At least from this paperwork is more than two.
May I have Abiel show me what Mr. Brooks is referring to? I can maybe help him try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. At the statute.
So I've got pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department incident number 21-047533. This is one of the two reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what about that report do you want to question Ms. Patterson?
That's the thing, though. He isn't prepared. He has no clue what he's
And I just
doing.
stated 3 times, I would have to read a little bit of this to form the questions.
Under my authority, under 906.11, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to question her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand what you mean by closed.
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that you would testify to about what's in that report.
how do I, first of all, the report isn't even in order. So I would have to essentially read at least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out. The jury will come out and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for?
I
then
have
if
to do
can't-
that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you
Lawful
start interrupting
law.
me when the jury comes out or make any commentary, you will be removed to the other courtroom and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your
So I
right
might
to
as
be
well just, I might as
present.
well have just
No
stayed
such
over there.
contempt finding.
I might as well have just stayed over there then if I was
Mr.
gonna get held
Brooks,
in contempt.
that decision is for you and you alone to make, and it is based on your conduct. If you're gonna
Just take me over
continue,
there. Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did.
You're-
You're
Such a
attempting to hold me in
child.
contempt. That's what that is.
No, that's not contempt.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt?
I'm
That's
gonna
the-
keep
that's
you
the
in
whole-
here because
that's the
there's-
whole
you're
reason
gonna
I
need
didn't
to
wanna
call the
come-
next witness, and I'm gonna need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive
Well, then
outbursts
remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I want
Obviously
you
you
in this
do.
courtroom.
Obviously you do. You brought it up before we can even get to.
All right, Mr. Brooks has forfeited his right to be present in this courtroom for the remainder of this witness. Even
So
though it will be
did I
short,
actually forfeit that right?
you have forfeited your right to be present. That
And
is
how
the-
did I forfeit that right, Your Honor?
All right, we're going off the record so that he can be removed to the other courtroom and he can call his next witness after we complete with Ms. Patterson and giving the state an opportunity from the neighboring courtroom. And once you can promise to this court that you will abide by the rules of decorum and civility, and if you're willing to conduct yourself consistently within that, then I will allow you to come back over.
So why am I being held in contempt now?
I'm not holding you in
Then
contempt.
what did I do?
All right, I'm gonna step off. You've interrupted repeatedly. I'm gonna step off.
What a little child. At this point, just keep him over there, because keep him in the other courtroom because it's clear he's going to act up repeatedly. And all this is doing is, again, delaying the trial because now they have to move him all the way back over there. It usually takes about 5 or 6 minutes. And yeah, the volume on the court stream is as loud as it goes, so I have it up as loud as it can go, and I'm not sure why I sound a little loud, but I apologize. You know why? I might sound loud because I'm listening to this in my headphones and it's loud, so maybe I'm just talking a little louder. I'm not sure. But I'll do my best to try and not talk when they're talking in court. This guy is the poster for why you don't represent yourself in court. Exactly. I wanted the judge to tell him he's in timeout. That would have been great. Does the judge have a baseball bat in the neighboring room and a bunch of a-holes in the wall there? Nothing but delay tactics. Just going through, see if I missed any comments. I'm gonna need a nap because I did the math with no pencil and paper. At this rate, 5 witnesses every 2 days. It will be 3 more days after today. If I'm incorrect, give me credit for the effort, please. Yeah, I'm the last person to judge anyone on math skills, so I'll go with what you're saying. I can hear you in the court perfectly fine. Well, that's good. I'm glad it's working then for most people. What did you say to the judge? I had to restart my laptop, darn update. Oh, that I was saying that the judge should just keep him in that other courtroom for the rest of the day because he's just going to keep interrupting repeatedly. And moving them back and forth, all it does is delay things further. You're out of here. I wonder what the jury is thinking at this point. They must be so done with him. It's not even funny. They must be completely done with Brooks. They probably had enough of his antics. Yeah, that's true. He can use that in an appeal. Which sucks because I really wish he could just stay over in the timeout room. Yeah, they already did the lunch break. That was what that entire whole hour break was, so. I haven't been paying much attention to the Guardians. Talking about the baseball team, I believe. I don't know. I haven't been paying much attention to baseball in general since the Red Sox were eliminated before the season was over. Ugh. Jury already made a decision. This is always the time now. I agree. I think the jury has their minds made up already.
Be seated, Madam Clerk. Would you please have the jury brought out and make sure all the monitors are on? You are unmuted, sir. The jury is on its way in. Well, will be shortly.
Why didn't we address subject matter jurisdiction when I was
I will mute you if you do that, sir.
Subject matter
The
jurisdiction.
jury, that's why I asked now before the jury came in.
I addressed that in my opening type remarks and record when we came back on the record today. I already addressed that.
So will it be proven for the record?
They don't have to prove it.
Will I at least be told why I'm held in contempt when I didn't do nothing? Civil or criminal?
That's a misstatement of what I did, sir.
So why am I
I
over
will
here?
advise when the jury's coming in, and if you can't be quiet, you're going to be muted, sir.
You gonna mute me anyway.
Not if you're quiet.
So I gotta be quiet like a little kid?
It's not what I said, sir.
You are a little
You have to
kid.
be
That's what
respectful.
you said.
You have to be respectful of the proceedings.
But nobody has to be respectful to me though.
That's a mischaracterization as well.
So can I say for the record that two of your bailiffs was just making gestures behind my head and I seen it through the TV screen and made me feel uncomfortable?
I agree with that, Linda. He
Jury's
knows
coming
he's
in.
done.
Please rise for the jury.
And here comes
That's
the
not gonna be
jury.
addressed.
Mr. Brooks, I'm muting you. Oh, okay.
That's the federal district. That was
It was later affirmed. Okay.
He's like a broken record, same you know what, over and over again. Yes, he is.
Can I have the preliminary instructions for a second? Oh, sure. You should just keep them. They're nearby. Thank you, everyone. Please be seated. Just for the record, Mr. Brooks is appearing from another courtroom. That should not affect your deliberation or verdicts in any way. At this time, does the state have any questions for this witness? All right, thank you, ma'am. You may step down. Thank you for being here.
He's gonna blow up, watch.
All right, the defense may call its next witness, please.
Let me get, he's gonna refuse
Go
to
ahead,
call
sir. You can call your next
witnesses.
witness.
I thought I was muted.
You're not muted.
So how long am I supposed to stay in here now?
I'm going to excuse the jury.
Here we go
Hopefully have
again.
you back shortly.
Wow.
All rise for the jury, please.
I would be so frustrated if I was on this jury. I'd be like, what are we even doing here? Like, of course he's not going to call a witness. Yep, she just sent the jury back out again. Yes, she did, Beaver.
All right, the jury is no longer in the courtroom. Mr. Brooks, I had the jury leave the courtroom because it appeared to me you wanted to perhaps either ask to come back into the courtroom or make another record of something. Do you want to come back into this courtroom as you call your next witness? You're not muted. You're unmuted.
So what's going on now? Why am I being held in contempt yet again?
The record will reflect that pursuant to Illinois versus
Oh my
Allen,
God,
Mr. Brooks was
I
not
can't.
held in contempt, although that is one of the possible ways for a trial judge to handle a defendant who is stubbornly defiant, disruptive, and contemptuous. That is not the only way in which a judge can address
He wants
a
to be held in
defendant
contempt
that
because
is
it
being
would further
insidious,
delay the trial.
disrespectful, and disruptive.
That's why the
So
judge won't
pursuant
do
to the
it.
authority in Illinois versus Allen, I found that you forfeited your right to be present based upon your conduct. I'd also direct the parties to some persuasive authority from other jurisdictions that are more recent, including People versus Cone from the state of Colorado, 160 P3rd 366. It's a Colorado Court of Appeals from 2007. And then from the state of Washington, from their Supreme Court, State versus Davis, 461 P3rd 1204. That's from 2020. And then I'd remind the parties of the district court decision that was later affirmed from Pennsylvania, U.S. versus Jennings, 855 F. Sup. 1427 from 1994. The finding was, sir, that you forfeited your right to be present based upon your conduct.
Okay, and all those case laws you just cited are pursuant to that.
Sir, I will ask you, would you like to come back into this courtroom as you continue with the calling of witnesses and your next witness?
I thought you was using Illinois versus Allen.
You are welcome to come back into this courtroom, sir.
So why was I removed in the first place then?
I've made my findings. The record will stand. I will ask you one last time. Would you like to come back into this courtroom as you call your next witness?
You're not finna hold me in contempt no more. Not finna do that.
You
Mr.
never
Brooks is not
were in
answering my question
contempt.
directly, so based upon that, I'll advise him that if I will ask one more time and he fails to answer it with a yes or no, I will take that as a no, that he wants to stay in that courtroom.
You can't answer
Mr.
for me.
Brooks?
You can't do that. You can't do that.
Mr. Brooks, I'm advising you that I will, he's interrupting me once again. From
Okay,
the
you
other
talking.
courtroom.
You the one talking right now, so don't do that.
I'm going to
No.
mute him because he's not being respectful and he's just spouting off. So he did not answer my question directly. He has not reclaimed his right to come back into the courtroom because number one, he has not requested it. Number two, he hasn't answered my question about whether he wants to come back in. And number three, he hasn't stated or demonstrated a willingness to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I will give him one more opportunity so that it's abundantly clear on this record that I am honoring his right to be present, and I will unmute him. Sir, would you like to come back into this courtroom as you call your next witness?
Don't try to seem like you're trying to honor my rights now because you haven't.
Okay, he is again not answering the question directly.
Don't try to put on no. Don't.
I'm going to mute him again. As I've noted before, this is a clear method now that Mr. Brooks is employing, that when I have done something that he disagrees with, that he just continues to argue with me and does not answer questions directly. So based upon his continued disruptive behavior, the fact that he will not answer my questions directly, I'll find that he's continuing to forfeit his right to be present in this courtroom. Clearly, the audio and visual technology are working. He's been responding, although not appropriately. He is in that other courtroom. We can see him. He does have the headphones on, and I've confirmed that he can see and hear as well based upon the court personnel that are in the other courtroom. So I'll make another finding that his appearance from the other courtroom is the functional equivalent of him being present in this courtroom. Mr. Brooks, before I unmute you, I am going to advise you, I will ask you to call your next witness. And if I don't get a direct response out of you, I may ask it again. And if you fail to give me a direct response, then you will forfeit your right to call any other witnesses. So I'm going to unmute you.
Wow.
Actually, I need to bring the jury back out.
The judge is so done with
But
him.
before I do that, I will unmute you first and ask you which witness you intend to call so we can at least have that person ready to go and outside the courtroom. Who will be your next witness?
I'm not calling no witness if I gotta be in this other courtroom.
Would you like to come back into this courtroom, sir?
Why was I ever removed? You never answered.
I've
I
made
gotta
a record
answer
of that,
everything.
sir.
I have to answer everything though. Everything you ask me, you expect me to answer. But then when I ask you,
Do it,
questions, you
Judge.
never have to
Shut
answer.
him completely down and end
I
his
just
case.
put on the record that 2 of your bailiffs just made gestures. When I'm looking at them off the reflection of the screen, they're making gestures behind my head that make me feel uncomfortable. I just brought that up on the record. You didn't even address that.
Mr. Brooks, I didn't address it because frankly, you keep interrupting me and then I have to deal with the interruptions and make a record regarding that. So I just saw the captain walk over. I will let security personnel, Captain Dussault, look into that. And if appropriate, he can bring that conduct to my attention. I'd also remind the defendant that at any time you can also ask to be brought over through the bailiffs who are in that courtroom. So to be abundantly fair to you, I will ask one more time, would you like to come back over to this courtroom?
I should have never been removed.
That's not answering my question, sir.
You haven't
Answer the damn
The
question, you
court's not going
idiot.
to answer questions directed at the court by the defendant because they're not relevant or probative at this time, and they're a delay and disruptive tactic.
They're
Mr.
not a
Brooks.
delay and disruptive
Exactly.
tactic. Is that a judicial determination that you
Yes,
make.
it
I'm
is.
going to mute you because we're going off on the judicial determinations. Every decision I make, sir, is by definition a judicial determination. It is on the record. If there is a conviction, you can raise whatever issues you want on appeal if you are convicted. But we don't need to have this back and forth every time to further make the record when the record speaks for itself. You were given plenty of opportunities throughout this trial to make offers of proof, to state your legal reasoning for either an objection or for a question that's being asked or for a whole host of other things. But right now, you're not doing anything legally relevant. You're being disruptive. I would like you to be present. That is always what I want during this case. It certainly, I think, is important, but you can forfeit your right to be present by your conduct, which you have done repeatedly throughout this case. I will advise you that if you are in that courtroom, because I have put you there and you have not reclaimed the right to be present by number one, asking and then expressing a willingness to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, you will remain over there. And it looks like he took his headphones off. So I will. Mr. Brooks, I'm advising you that if you fail to call a witness, you will forfeit your right to present any additional witnesses. And I'm doing this outside the presence of the jury right now for a reason. I need to know from you right now, you are unmuted. Who is your next witness?
She trying to say something to me? Yeah.
Wow, this is the worst I've seen from him out of this entire trial.
What you trying to say?
That was very disrespectful, sir. You chose to take off your headphones. You
Yeah,
choose
because
to
I'm
read.
muted. I'm muted. So why am I gonna have my headphones on and I'm muted?
Well, I would think your headphones help you hear. The
They
muting
do.
is so that I don't have to hear the disruptions.
Okay, well then why should I need to hear what
So
you
let
saying?
me be clear, sir. And
You
you
don't
are
gotta
not,
be clear or nothing. I don't gotta listen to you.
Wow.
I will ask you one last time, sir. Who is your next witness?
First of all, is she talking to me again?
He,
So
this,
we gotta keep doing this little childish stuff, dude. I gotta sit up here and I'm supposed to abide by every single rule, but don't nobody else gotta do that.
the record should
Judicial misconduct.
reflect
This trial
Mr.
might end
Brooks is
today
spouting
if this
off,
keeps up.
making
I think
unsubstantiated
the record can hear me. I think
allegations
they can hear me.
against this court,
Unless I'm
directly
muted.
attacking the integrity of this court and these proceedings, while yet
This court ain't got no
refusing
integrity.
to answer
This court don't have
simple
no
questions. Mr. Brooks, you
That's
are,
not my name. I told you I don't consent to being called that name.
sir, you are hereby advised, this is the last time I will ask this question,
Don't talk
or
to me
you
like
will
that.
forfeit your right to present
Can't do that.
any
Show me
additional
show me
witnesses,
where that's law.
because
Show
you
me
are
where
not
that's law.
cooperating with this process.
Show me that is law. That's all I'm asking. Show me that is lawful law.
Mr. Brooks,
How can,
Oh,
how can
lawful
I
law.
forfeit not being able to have a defense?
Mute him. Shut it
Are you
down.
kidding me?
Shut him down.
all I'm asking is that you conduct yourself with dignity, with decorum, and with respect. I
He
will
doesn't know how
gladly
to
bring
do
you back
that.
into this courtroom so you can present your additional witnesses.
Your
But you
Honor,
need to ask me to come back into this courtroom.
with all due respect, I'm tired of having this back and forth with you every day. It's not my intention to come in here and have this
Oh
these
God,
interactions
the
with you.
echo.
It's not. Regardless to what you may think, regardless to how you may feel, that is not my intention. Okay? I simply do what I do because I do not have the understanding. So if I don't understand something, I'm going to ask a question. I apologize if it makes you feel that I'm intentionally trying to delay the proceedings. If I'm intentionally trying to be disruptive. Because that's not the case. And I feel very disrespected every time the record is made, making it seem like that's what I'm attempting to do. So of course it's gonna frustrate. Of course it's gonna make me a little bit upset. And I just want you to understand that. It seems to me the way I'm interpreting what you're doing, which is your courtroom. That's not it. It's not a dispute. It's not up for debate. You control what's going on in there. That's not a dispute.
Yeah,
But the
the
way
echo
I'm
is on the
interpreting
court's
What
side
you're doing
again.
is that I'm being held
Nothing I can
invalid,
do
and
about
that's how
that.
I'm interpreting. Because one of the three things that's cited in Illinois versus Allen, one of them is being gagged. I haven't been gagged. One of them is held in contempt. If
What's
I'm-
the
if
third,
I'm not
Mr.
under-
Brooks? What's the third?
The third is removed from the courtroom while the trial continues, right? That's the third, right?
And that's what's been done.
Okay, so now where does it say after that having me on a headset or being able to see and hear and all this and this, how is that not prejudicing my defense?
Sir, you can
I
raise
can't
that
even-
issue on
I can't-
appeal.
I can't even-
You
This
can
is
raise
why I
that
say that.
issue on
This
appeal
is why I
if
say
you
that.
are
This is why I say
convicted.
that. This is why I say that though. Because I can't even see. The only thing I can see right now when I'm looking at the TV is you and the process.
Yeah, sorry, there's nothing I can do about the echo. That's the court. Nothing I can do
Fully
about
aware of
that,
that.
guys.
So I'm not fully aware of what's going on in the courtroom. Don't I deserve that right? Don't I deserve that right to be able to see and hear everything that's going on?
If you can conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, the answer then is yes. So I'm not going to have a debate with you about the law. I will ask you again, would you like to come back into this courtroom?
Are you going to kick me out?
Sir, I'm asking the questions right now. Would you like to come back into this courtroom? Yes or no?
Kick me out. Are you gonna kick me out? Are you gonna kick me out?
Sir, it's a yes or no question. Would you like to come
Well,
back
my
into
answer,
this?
well, my answer was based on the reason why I'm answering like that is because the moment I say something, it's gonna get me put out. I don't want to keep hauling this stuff back and forth and back and forth and back and forth and back and forth and back and forth. It makes essentially it wastes time, really. It wastes time, really.
Now he's complaining
well
about
aware of that,
wasting
sir.
time.
That it
Wow.
delays the proceedings.
Yeah, but then it's laid at
Wow.
my feet as if that's my attempt. You think I want to be over here? You think I want to be over here?
Sir, I don't know what you want or don't want at this time. I know that we need to complete this trial and that you have frustrated today more than ever before the ability of this court to do that.
Well, I apologize for you feeling that way, but I'm frustrated too. Nobody seems to take that into account. I'm just as frustrated as everybody. Probably more.
Then I suggest that you conform your conduct to the requirements of courtesy and decorum so that you don't run the risk of forfeiting your right to be present. But that falls on you and you alone, sir.
There is no conduct. I don't understand what you mean by that. I really don't.
Mr. Brooks, you may not understand it. I don't think that's accurate. I think you know exactly what you're doing.
If that's what you think, that's fine.
And you have demonstrated throughout this case that you pay attention to witnesses' testimony, that you make cogent and coherent objections. At times that you have even had evidence suppressed in this case or stricken. That's the word I used during this case. You made an opening statement. You communicate with witnesses. So
Your
you
Honor,
clearly
it's
read,
not
write,
fair.
and
It's
understand
not fair.
English. That's not an issue
not-
here, sir.
It's not fair
Are
to
you
say-
self-represented?
it's not fair to say-
Absolutely. Does that present difficulties and disadvantages? Absolutely. But that takes me back to when you waived your right to counsel. And you did so knowingly, freely, voluntarily, and with a full understanding of the disadvantages and advantages of doing so, meaning advantages of having an attorney, the disadvantages of doing it on your own. And you made a deliberate decision to
Your Honor, that's
represent
not fair.
yourself.
Your Honor,
And
that's
that
not fair.
comes at a risk to you of, yes, at times not fully understanding the law, the rules of evidence, the rules of procedure, but you
That's
do
not
so
fair.
at your peril.
That's not fair. That's not fair to state, Your Honor, because.
So I'm going to do the
Paperwork you gave-
following, since I'm
paperwork
not
you
really
gave-
getting anywhere. I'm going to mute you for the moment. I'm not getting anywhere with him. I would like him to be brought over. And he has a choice to make. He can come back over or he doesn't. Either way, he's going to be asked to call a witness in front of the jury. I will ask him 3 times if he fails to give me a direct answer. And after the 3rd time, I will make the appropriate finding, but I will do that outside the presence of the jury. But we are going to continue. So we'll go off the record and he will come back over here. Thank you. We are in recess until that happens.
Wow.
I mean, just to say something and then get kicked out. Man, I don't know what to tell
He's
her.
not going to go back. I don't think.
No. Because I'm gonna end up having to come back over here. Don't y'all get tired of hauling
Yep.
all this stuff over
You
here?
heard him. He doesn't want to go back.
And I know, as soon as I say something, she's gonna say, take him out. We're gonna stop everything. Take him out. And it's just like, well, damn, I could have stayed over there.
I think that may very well end up happening, Kalina.
Like, what the? Yeah, at this point,
The microphone is still on.
I'm gonna go over there and get sent right back over here. And then when I get over here, it's gonna be the same thing. Oh well, if you tell them you can come back over here, then I go back over there, then I get kicked out again. Then it's the same thing again. Oh well, if you want to tell, it's just like, dude, pick, man. Like obviously, I don't have no say. That's clear. Because when I'm getting kicked out, the first thing I say is what? So why are you holding me in contempt? So that's obviously saying, why am I being kicked out? So if I'm saying, why am I being kicked out? Then obviously I don't want to be kicked out. But then I'm kicked out anyway. And then I get over here and it's just like, okay, I don't want to be over here. But
Gotta love the hot mic.
why got to go back over there?
Ah, they finally turned it off. Is this turn of events unprecedented? What in the world are they gonna do if he continues like this? I'm pretty sure now, full disclosure here, I am in no way, shape, or form an attorney or a lawyer or anything like that, but I think what the judge was saying is that she has the right to basically end his case. Basically, if he refuses to call a witness, she has the right to end his case. I mean, if he doesn't call a witness, I mean, that's all the judge can really do is shut him down completely. And that's what he's going to try to appeal off of. So, I mean, the judge has made it very clear. She has given him multiple opportunities. So, even if he does appeal, it's not going to work out for him. But this behavior from Brooks today is the worst it's ever been. So I'm kind of glad I did live stream this. In that aspect, I'm kind of happy. He knows why he's being kicked out. He knows he's just being stupid. Just going through the chat. Judge needs to stop bluffing and terminate his access to witnesses. Oh, I think that's a very strong possibility of happening. I'm just going to step away for a quick moment, but I will be right back. All right, I'm back. Sorry about that. Hey, Gary, good to see you. Hope you're doing well, my friend. Oh, me too. I think if he keeps this up, I think we'll get the prosecution's closing argument at some point today, maybe within the next couple of minutes, actually. Oh, yeah, just waiting again. It's become a huge waiting game today. Yeah, that's a good question. What would he say at closing? Probably complain about how the court's unfair and that type of stuff, maybe. Even though we all know it isn't. At this juncture, I still believe the best turn of events would be if he were to try and flee out of the court. Oh, but he won't get far, trust me. And plus, he's wearing that like taser device thing. At least that's what he said on one of his legs. So now it's once again a waiting game. For everyone's sanity, this needs to stop. I agree. I mean, he's had outbursts in previous days in court, but not like this. I mean, it's just what a waste of time and money, though. Really. We all know he's guilty, and the taxpayers of Wisconsin have to waste their money on this. So, will there be no victim impact statements? There probably will be. I think the victim impact statements, those come after he's sentenced, though. Yep. This is such a wasted day. Like, and I mean, we heard from the hot mic that he does not want to go back into the courtroom. So, maybe that's what he's fighting about right now. Maybe that's why it's taking so long. I mean, I get it, but it's his right, and he had taken competency tests. At least that's what I heard, and he was declared competent. So it was his right to represent himself, and as we all are seeing, this is a prime example of why you never represent yourself in court. Oh, yeah, an appeals court would laugh at this. They would be like, is this serious? Like, hey, Sydney, or Sindley, good to have a face with the name, Mark. Yeah, I don't know, a lot lately I've been using my face cam a lot more often. This isn't the first time I've shown
That Mr.
my
Brooks
face
is
on
present in
stream.
the courtroom in person and in custody wearing a suit and tie. Actually, his suit coat is off, but he's still wearing a mask. And the jury will be brought out and you'll be asked to call your next witness.
Can't call it that name.
Here
So
we
no.
go.
And we still need to address subject matter jurisdiction before the jury's brought out.
I will not be doing that.
Will it be proven for the record?
It already has
record
gone
stands.
multiple times.
So is that a tacit agreement that you don't have to answer that question, Your Honor?
I make no such agreements with you, sir.
So that means you can answer a question then. Will we be addressing subject matter jurisdiction on the record, and will it be verified and proven? Non-responsive answer is a tacit agreement, Your Honor.
Jury's coming out.
Let's see how long this lasts. He's gonna start arguing about something stupid.
Thank you, everyone. Please be seated. The defense may call its next witness.
Who's here?
Of course, he doesn't know who's here.
Bertram, Hayes, Aldrich, and Lescano are present and ready, Your Honor.
Thank you.
What was the last two?
Aldrich and Lescano.
Let's go with Deanna Aldrich.
Deanna Aldrich? All right, very well.
Yeah, I think you're right, USA. No, it's not a death penalty state. The worst he can get is life in prison. Yeah, he would get 6 life sentences.
I'm sorry, Your Honor, I think she was in the other building, so.
It's all right. Thank you for letting us know. That's true, Gary. Just waiting on the witness is all. Good afternoon, Miss Aldrich. If you would please make your way to the witness stand. It is up by me. It's up a riser. When you get all the way to the witness stand, please remain standing, raise your right hand, and my clerk Teresa, who's on my left and will be across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Come up and have a seat.
Here we go.
The first thing I will ask you to do is to state your first and last names for the record and then spell each.
Okay, Deanna Aldrich, Deanna, last name is Aldrich.
Thank you. Go ahead, sir, your witness.
Good afternoon, Miss Aldrich. Direct your attention. Well, first of all, let me back up a little bit. What do you currently do for a living?
I'm retired.
That's always pretty good. Direct your attention to the evening of November 21 of 2021. Do you recall that evening pretty good?
Yes,
Where were you staying at the time?
I live on Maple Avenue.
Hey, Doug. Good to see you. I hope you're doing well.
During that evening, did you hear anything unusual?
I did.
And do you recall what that was?
I heard a large thumping noise in my neighbor's yard, and when I came out to my porch, I saw a red SUV.
I don't believe so,
Back up a little bit to the thumping noise.
but that would be funny.
Can you describe that thumping noise? Would it just be a thumping? Did it sound like a crash or anything of that nature?
I believe it was like the engine dropping kind of noise.
Okay. And you stated you looked out your patio and saw a red SUV.
I did.
Do you recall how that SUV looked at that time?
It was smashed to smithereens.
Do you recall if the red SUV was still running at the time that you observed it?
Yes,
And at some point, did it cut off?
yes.
And what did you see from that point?
Before I seen it shut off, I seen it go forward in the driveway and then back up like 3 feet. And then someone got out of the car and ran around the bushes to the front of my building.
And who's the someone that you are referring to?
At that time, I didn't have my glasses on, so I could not see clearly.
What do you recall?
As far as
Description
what?
wise, yeah.
Dark hair, possibly white or purple or whatever color shirt, and dark pants.
Do you recall a height?
I think he was probably anywhere between 5'6" and 6 foot. I really couldn't tell because of the angle.
So I'm assuming then your patio is kind of on a upward base type of angle that you would have kind of been looking
I was
sort of
looking
down.
down, yes.
Okay. And the individual you stated ran in what direction at the time that you were observing?
My porch is here, and he ran from the driveway here around to the front of my building.
Did you see where the individual went from that point, or could you not see because of where you were positioned on the patio?
He stopped to, if you were looking at the building, he stopped to the right of the building front.
And the building front, is that a street?
Yes. Not all the way to the street, though.
Okay.
He was in the front yard on the grass.
Did you at any time observe this individual jump over the hood?
I was running in and out of my house, so I did not see because I was trying to find my glasses as I was running in and out.
So is it fair to say you were trying to locate your glasses so you can get a better look at what you were observing?
Yes.
Do you recall if the SUV had any tinted windows?
I do not recall.
Do you recall what time of the evening you heard the loud thumping and then observed the SUV?
I do not recall.
And before that evening, had you ever noticed that SUV before that evening?
No.
Did you speak with any of your neighbors to inquire who the SUV may have belonged to?
No, there was people coming outside from the building that the driveway was, and they were gonna walk up to the vehicle, but they did not because I yelled to them and said, "Don't touch it."
So that kind of would be fair to say that kind of startled them and stopped them in their tracks.
Yeah,
Do you recall how many people there were?
maybe 10.
And at some point, did law enforcement come to your home and interview you about what you observed that evening?
Yes.
And do you know if they? Well, I'm assuming they took a report. Would that be fair to say?
They came up to my apartment and asked me some questions.
Do you recall if they were writing it down or recording it?
Writing it down.
How does he think this is helping him? Like, if anything, it's making him look even worse, as if it wasn't worse for him already.
If you recall, did you ever learn what the loud noises were that you heard before seeing the SUV?
No.
All it's doing is making him look bad. Like, what is he trying to accomplish?
And the street that you observed the individual running toward, do you recall what street that would have been based on the direction?
Arlington Avenue would be right directly in front of that building.
You didn't see the individual run towards Maple Street?
He ran towards Maple Street and came around the bushes directly to the right of my patio, being up high.
Would it be fair to say I'm wasting the court's
The
time?
general direction would have been
Yes, it would be fair to say
street
that,
did you say?
PJC.
Arlington.
Arlington. I apologize. Were you aware that there was a parade going on that evening?
Yes.
Did you attend?
No.
See, an expert attorney would have their questions already pre-planned or written down. This guy's just
After
trying
you,
to think of them.
spoke with the law enforcement officers that evening. Did any more law enforcement officers come back and interview you at any time after that evening?
They did not interview me that evening. They came early the next day on the 22nd.
Oh, I'm sorry. After the 22nd, did any other law enforcement come back out to interview?
No.
Do you recall the name of the officer that interviewed you?
No.
The fact that he's behaving normal now makes his earlier behavior that much more disgusting. It absolutely does. 100% agree. He's just wasting everyone's time.
No further questions at this time.
Thank you. Any cross?
No cross, Your Honor. Thank you.
See, even the prosecution knows that was a waste of time. Like, it's usually not good for you if you're a defendant and the prosecution doesn't have any cross exam. Like, now he's gonna stall some more as usual because he doesn't know which witnesses are what. He is so unprepared. Oh, come on. Call somebody already.
The defense calls Christopher Bertram.
All right, thank you. I presume the state heard that and was assisting. Thank you.
Your Honor, my assistant.
I didn't want to assume. So thank you for
Yes.
verifying that. Looks like this one's a lot closer than before, so that's good. All right, good afternoon, Mr. Bertram. If you would please make your way to the witness stand, which is off to my right. It is up one riser. When you get there, please remain standing, raise your right hand. And my clerk, Teresa, who's on my left and across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
He probably is. Wouldn't be surprised.
First thing I will ask you to do is to state your first and last names for the record.
My first name is Christopher and my last name is Bertram.
Could you spell those, please?
CHRISTOPHER BERTRAM.
Thank you. As long as you sit close to the table, you will not have to lean in. Go ahead, sir, your witness.
Oh, I'm sorry.
Go ahead.
Oh my God. He is
First of all, good afternoon.
so clueless.
What do you currently do for a living?
I do electrical work.
Directing your attention to the evening of November 21st, 2020.
He definitely is young, I will say that.
Do you recall that evening pretty well?
Not very.
Do you recall what you were doing that evening?
Yes.
And what were you doing that evening?
Taking my mother's car to our mechanic friend.
Were you aware of a parade going on that evening?
No.
Around what time were you taking your mom's car to be inspected?
I don't recall.
Do you recall seeing anything that caught your attention that evening?
Yes.
Can you state what that was?
A smashed up red car.
And do you recall where you saw that at?
I believe it is Prospect Court Street.
And at the time you observed this smashed up car, as you say, did you Did you see anyone driving it?
Yes,
And were you able to make a description, sorry, description of who was driving it?
I believe so.
And what do you recall?
I don't recall what I said.
You don't recall what you said or saw?
I don't recall what I exactly said when I gave my statement.
Do you recall what you saw?
No.
This witness isn't helping him
You
either.
made reference to giving the statement. I'm assuming that would be to law enforcement. Is that fair to say?
Yes.
And did they write down? Well, let me back up. How was that interview conducted? Was that an in-person interview over the phone, or?
In person.
And do you recall if the law enforcement officer was writing down what you were telling them or recording?
I don't recall.
Did you observe the vehicle stop at any point in time?
No.
So it was pretty much you just saw it just kind of just rolling past.
Yes.
Did you notice if the vehicle had any tents?
Any what?
Tents, like tinted windows?
No.
Do you recall in your interview with law enforcement? Well, let me back up a little bit. Was your interview with law enforcement the same evening that you saw this vehicle or sometime after?
The same evening.
Do you recall stating during the interview that evening that you observed the driver as a black male with short hair and a short beard?
I don't recall exactly what I said.
Do you recall stating at any time during that interview that evening that you believe you saw the operator of the vehicle reach down and grab something as they were driving past?
Yes.
Did you ever see them? Did you ever see what you believe was being grabbed?
No.
And what did you think at that moment that you saw the operator of this vehicle reach down?
I was unsure.
Do you recall in your interview with law enforcement that evening stating that you thought it was possibly a gun?
Yes.
And where did you observe the vehicle go after it had passed you?
I turned away after it passed me.
Do you recall what the operator of the vehicle was wearing at the time that it? Stating that you thought the operator was wearing a black sweater or jacket as you?
If that is.
Do you recall where your interview with law enforcement that evening took place?
Yes.
And where did it take place?
My house.
And was anyone present with you during your interview with law enforcement that evening?
Yes.
And who was that?
My mother.
And do you recall what agency your interview was conducted by?
Yes.
And would you stay for the jury in the record?
The FBI.
Do you recall stating in your interview that evening with law enforcement that you heard a lot of gunshots?
Yes.
And do you recall I think that's a little bit unfair to say. If you had to estimate where do you think those gunshots were coming from, like vicinity wise?
It sounded from downtown.
And when you say a lot of shots, what would you describe as a lot of shots?
Like a full magazine.
You ain't helping your case, that's for sure. Not sure where you're going for this with this, but it's not helping you.
Do you recall seeing the vehicle that you observed crash into anything?
No.
Do you recall stating in your interview with law enforcement that evening that the vehicle appeared to slow down while traveling down Prospect Court?
Yes.
Exactly. That's exactly what they're thinking. And I do agree, Payson. He should have never fired his attorneys. This is why you never represent yourself in court.
At some time after observing this vehicle, did you call 911?
Yes.
Do you recall around what time you called 911?
No.
Do you recall shortly after seeing this vehicle texting anyone?
Yes.
Do you recall who that was?
My girlfriend.
And what did you tell her?
I don't remember.
Do you recall telling her there's a shooting?
Possibly.
Did you see anyone else in the vehicle?
No.
But you do recall seeing the operator wearing a black sweater.
I don't remember.
Did you observe at any time that evening seeing someone run from the vehicle?
No.
Do you recall why you would have gave a description that evening when initially interviewed by law enforcement?
Because I saw the person in the car.
And how did that person look?
I don't remember.
Grounds?
This answer may stand.
What was the answer?
He said, I don't recall, or I don't remember.
No further questions at this time.
Thank you. Any cross? No. Thank you, sir. You may step down and you are excused.
Look at, he's having fun. He has a grin on his face. He's enjoying
To the
this.
next break, I have something to discuss outside of the presence of the jury that pleases the court.
Do you want to do that now or after your next
We
witness?
can.
All right. I'll address a legal issue and we'll bring the jury.
Oh,
back in when
boy.
we're ready. All rise for the jury, please.
Here we go. What legal issue does he want to talk about? Yeah, that's what I'm
Have a seat, and
thinking.
then we'll just wait for the door to close. Go ahead, Mr. Brooks.
Gonna bring up something stupid.
I'm curious. Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. Are you?
What is he
I'm
asking?
not sure what
Wait.
you're asking me.
Yeah,
I'm
me
asking-
neither.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. I just to be blunt, which I've been since the beginning of this trial, obviously. I see the whole strategy here by the prosecution. I see right through it.
Enlighten
Don't
us.
have any cross-examination
Because you're asking,
because you've already schooled.
you're
schooled the
asking
people,
stupid
get understanding on how to
questions.
answer certain things.
That's why they don't have
That's
cross-exam.
completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any more legal advice further than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived, then
anything
that's,
about that.
all right, then I'm going to bring the jury back out. You're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and
Wow.
coached them.
It's obvious. I'm not stupid.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden-
lay a foundation.
All of a sudden, the
with
Here
state
we
these
go.
witnesses.
all of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this is
and not-
argument.
Come on, man.
That's
This is
because you're
argument on your
asking
part, sir.
stupid
It is
questions.
pure
I just
commentary at
want
this
that on the
point.
record. I see through it.
And your
Nice try,
see-through
but I see through it.
has absolutely no basis in
Yeah,
fact.
I know that's what's being
Kick
done.
them out.
You
Come
could
on, man.
ask
I'm-
these questions, you could
Come on,
ask
man.
these
You got the right
witnesses
one.
certain questions and you're
far,
not.
far from an idiot.
They're your witnesses, sir. If you
So
believe,
so I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for, have they been coached to answer the way they answer?
well,
Because
you can't
I
ask
find-
that, but
I
you can
find
ask
it
them
very
if they've
funny.
met with anyone ahead of
I
their
find it
testimony
very
here
funny.
today,
I find
which
it
you've
very
done
funny.
with other witnesses.
I find it very funny that these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach for
attempt by
something.
you
Oh,
to
I don't.
delay these
I don't recall what
proceedings.
they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach for
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought
man.
out. I'm instructing you to
Come on, man.
avoid the commentary when the jury comes out, or you will
I didn't
forfeit
Well,
say-
he
your right to
lasted a
present.
good 30 minutes.
that there's a issue that we do need to pick up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to run the
disagree.
record back?
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that. Come
this
on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of this
your
to benefit me.
witness
So let's
has
be
a
clear about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for that.
Lescano.
Stop talking.
Yeah, it is. It is shocking he lasted that long.
I'll set for value, return for value this document.
One more interruption and you're Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
explain-
has 7 prior criminal convictions via OWI second from 1997, and OWI third from 1997, and OWI fourth from 2003, criminal trespass to
He's
dwelling from
pissed.
2006.
Right. Like, this man right now is having a stare down. Me scared. And we're taking a break.
Just wow. Put him in the other courtroom again and keep him in there. Yes, it is a punchable face. Oh, he got mad. He punched the table, which I could hear that. He punched the table. Then he's staring at the. Send him back to the freaking timeout room again. See, but hopefully not too long. It's unclear how long the break is going to be. Probably a few minutes. That was succulent. He's doing everything he can to delay this trial, and ultimately it's not going to work. Yep, I heard it too. Like, honestly, I thought he got up. I thought he may have punched like the monitor or something, which I'm surprised he hasn't done yet. What's up, Adam? Good to see you. Been watching an idiot make a fool of himself during trial using sovereign citizen BS as his defense. And now we wait again. I mean, I would play a clip of something that happened earlier, but they didn't say how long this break was going to be, so I don't want to start a clip then end it because they went back live. I would think the judge will. Like, how much more is the judge going to put up with this? Like, all day long, he's been disruptive. Since court started at 9:30 this morning, he's already been kicked out of the courtroom twice. And he's acting ridiculous. He's acting like a little toddler. The last two witnesses the state did not call for a reason. Clearly, Darrell Brooks is mad. He called two people who aren't gonna help him. And being a delusional, narcissistic, sociopathic parasite, he's blaming the state. Yeah, exactly. And those are all great words to describe him. It's all a conspiracy, release him. And for the record, just want to say, this has been my longest live stream ever. Been streaming now for 6 hours with this trial nonsense. And since we've gone this far, we may as well watch it till the rest of the day. So again, thank you all for hanging out with me. I really appreciate it. If you haven't clicked that like button, be sure to do so and share the stream. It all just helps out the channel. And I guess we're gonna be here for the long haul, so to speak. Yeah, it was. I mean, I'll bring it up for a second because if I can find it.
To benefit. And we're taking a
I mean, look at that. Like, that is the face of an animal. He's a monster. Like, a good thing a jury wasn't in the room for that. Oh, we definitely are. We are going to finish this thing. We are staying here till the end of the day at this point. We have to. But that is the face of evil. Before I forget, let me bring this back to the live feed. All right. While this is on a break, I think I'm going to go get a quick snack, and I will snack a quick drink, I should say. And I'll be right back. Hey, Debos Nation, good to see you. And I'll be right back. All right, I'm back. Sorry about that. Still on a break, I see. Wonder when they're coming back, though. Like, thought they would be back by now. You gotta love live television or live streaming. I feel so sorry for their judge. She is forced to try and deal with this pelutnit child and preserve his rights so the case isn't overruled on appeal. Yeah, and I think the judge, though, she's doing a good job of handling him overall. Yeah, that might be what they're doing, but even that, the afternoon breaks only last about 15 or 20 minutes. Let's see if I can find any info. I think this guy knows he cannot win, and that's why he wanted to fire his counsel and do it himself for his last ditch of power he has left. I completely agree with that, Debos. I mean, he's been a power-hungry monster since the beginning of this trial, and whenever he doesn't get his way, he has a tantrum like he's done multiple times today. I mean, he's freaked out in the past, but this is the worst I've seen him. If I'm reading the reports correctly, I'm reading some news reports about this case. It does seem like she has kicked him out of the courtroom again. So when we come back from this, don't be surprised if he's in the other courtroom, which is what it sounds like. That may be why it's taken so long, but who knows? The judge has gone so far out of her way, it's almost like he is getting a law class from the judge. And I get what the judge is trying to do, like we were saying, preserve his rights and stuff, but at the same time, Brooks, he willingly gave up his legal counsel, and he has to realize that a courtroom is not law school. And for the record, YouTube University isn't law school either, or whoever the hell is giving him this sovereign citizen nonsensical advice. It's all nonsense. Just seeing if I can get any more info. Oh yeah, he was staring at the judge. Yeah, I'll go back and play it. Seems like we have some time, so
We scale with
Dwell from 1997, an OWI third from 1997, an OWI fourth from 2003, criminal trespass to dwelling from 2006.
All right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're taking a break.
So that's what happened a couple of minutes ago. Yeah, he doesn't have, but he's getting this soft sit stuff from somewhere, so presumably somebody else in jail. Go back to the live feed, and we're still waiting. Oh yeah, I've seen it on. I've been checking Twitter during this break. Been looking at it. I've seen it a couple of times already. This fragile man cannot handle that the judge is a woman and in control of his future. It's true. He hates the fact that a woman is in charge of this case, probably, and he just hates it. Yeah, just don't mind me, guys. Just check in things on Twitter while we're waiting. Because when we come back, you know it's going to be interesting. Maybe Devon Bay can assist his appeal. That would be interesting. And hell, you may as well call Chili De Castro too while we're at it. Now that would be a sight to see. Twitter, oh lord. I'm just now figuring out YouTube, and don't get me started on the craziness of Discord. Oh yeah, he tried yesterday, the very first witness he tried to call, he said, and I quote, "The defendant calls the state of Wisconsin." I bursted out laughing when he said that. And obviously, the state of Wisconsin didn't show up. That'd be interesting, though. Chili, the fifth grade scholar, will help Darrell Brooks. But I wonder what other frauditors and soffits think watching this trial. I'm sure they would think he's doing a great job right now. At least in their little mental minds, they think he's doing a great job. Yeah, I think so. I think after that, she's had enough of him. And this judge has been very, very, very patient with him. First grade. Oh, I get it. Chili, the first grade scholar, will help Darrell Brooks. Other soffits aren't allowed to watch anything that tells the truth about soffits. Like Scientologists, they aren't allowed to research Scientology. No, it's not. I don't know, maybe something happened after they cut off the mics and put the camera to the clock, maybe. But I haven't heard of anything happen. I mean, I haven't read that anything else happened, other than the fact that they were likely moving him to the other courtroom. No other lawyer would be able to get away with this. They would be disciplined by the bar for their actions. Yes, they would be. Oh, my mic was muted. I was saying this has been a long break, but now he's still in the courtroom. They're about to get started again. How is he still in the courtroom? And of course, yes, he is reading from the Bible again. Still no audio, so I'm guessing the judge isn't there yet. He knows he's going down for the rest of his life and he can't face it. I think that's absolutely correct, Gary.
We were before.
Here we go.
I'd like to continue by bringing the jury out momentarily, Madam Clerk, and having you call your next witness. I trust that you're ready to do that, sir. All right, then.
And we
Madam-
need to complete the task of. the
Oh, we do.
priors for Mr.
I knew I would left something in my office, but I reviewed it, so go ahead. What is the state's request then as it relates to the prior record?
We believe the proper answer would be 7 prior convictions, Your Honor, and that would not obviously be counting the OWI first conviction from 1993, which is at the top because it's the age of that, and obviously that appropriate. There's also one that's noted, 06 CM 2039. It was a case, but all the charges were dismissed and read in, so we're not counting that file either.
Can you go run and get that for me, please? Thank you. Just gonna have that brought back out. I took it with and I left it on my desk.
They're talking about an upcoming witness who
Remind me of the
has
statute again on priors.
prior convictions.
90609.
Thank you. And a copy of the record was provided to the defendant.
It was. It has not been discussed with Mr. Lozano.
That was going to be kind of my next topic once, thank you. I look at this again. All right, Mr. Brooks, do you have a position on the prior convictions for this witness? The state is asking for a determination by this court that there are 7 prior convictions for purposes of questioning the witness, whether that's by you or by them if they so choose. And that would be for a determination under 90609.
No, I don't believe so. I believe it's one of Brooks' witnesses.
What? I don't know what you're asking.
Mr. Brooks, you may recall at some point, I believe we had a discussion about prior convictions. I think maybe we only discussed that if you were to testify, we would have to have that conversation. So in fairness, I don't.
No, there was one state's witness that had one prior that we discussed. And
That's
the court
right.
ruled.
We did. I recall now. So at that point, I directed your attention to 90609. And then I made a ruling based upon the factors that are enumerated in that statute. You've been provided with a listing of the record. I would direct your attention to, I'm not sure if I see that book out there, but the statute book that I previously provided to you, but that the 90609 would be in there. But in any event, the state is asking that I make a determination about how many for purposes of the questioning of this witness. Do you have any comment, statement, or position on that?
He doesn't understand the question.
Looks like it's 9 on here.
Which is the one the state referenced that the charges are listed, but they were dismissed?
2000, well, it's recorded as 06 CM 2039. 2 times violate harassment / restraining order, and then it says DM / RI, which means dismissed and read in. 2X MBJ, which would be 2 times misdemeanor bail jumping, dismissed and read in. So no convictions from that.
Yeah, you're probably right.
So why is it on the sheet?
This would be an accurate listing of the cases that you found when investigating the witness's background.
Yes, Your Honor.
And nothing since 2007.
That's correct.
All right. Any statement you want to make, sir, on what the number of convictions this court should consider under 90609?
What is dismissed and read in? Does that mean there was no charge?
No, it means it was, when there was a conviction for something else, the charge was dismissed and read in, and then the court considered it at the time of sentencing. So they are not convictions, but it was a case. So that's why, my understanding why it was listed.
So the two. So where it says dismissed and read in, that would be the restraining order and the MBJ.
Right, misdemeanor bail jumping. So 2 counts of violate harassment restraining order were dismissed and read in, along with 2 counts of misdemeanor bail jumping dismissed and read in. I'm guessing, but the state can confirm that it either was read into 06 CM 1859 or 06 CM 3149.
Yes, I believe it was the 1859 case, Your Honor.
So at the time of the conviction for resisting obstructing, there was a misdemeanor bail jumping dismissed and read in, and then the other charges, all of which are listed under 06 CM 2039, dismissed and read in.
So then 8. Should be 8.
The OWI first would not be criminal, as I understand it, and so I believe that's why it's not, the state did not ask it that it be counted. Because the statute requires conviction of a crime or an adjudication of delinquency.
So there's no crime for OWI?
An OWI first would not be a crime, it would be a forfeiture.
Yeah, I just noticed that now that you pointed it out. His mic is covered.
I still would say 8 just based on the fact that there's continued OWIs. All the way up to a 5th.
Remind the parties of the factors to consider for exclusion include the lapse of time since the conviction, or in this case, convictions, the rehabilitation or pardon of the person convicted, the gravity of the crime, the involvement of dishonesty or false statement in the crime, the frequency of the convictions, and any other relevant factors. So based on that, do you have any argument that it should be less than that?
Less than what, 8?
Well, it'll be less than 7. He has 7 convictions as I count them.
And that's not counting OWI first.
Correct, because it's not a crime. It can't be counted under the statute.
Then it's 7. Should be 7.
All right. Do you want to make any argument about whether any should be excluded under the statute based upon the factors I just read to you?
Well, you already made reference to one of them not being a crime. So that brings it to 8. I don't understand the whole.
Well, for example, the last conviction was in 2007. It's now 2022. So do you want to make an argument to the court that perhaps he's been rehabilitated?
He's wasting time for the sake of wasting time.
I don't want to speculate on the next man's life, but if it's 7 on here, well, I guess it brings it to 7. And whether OWI first is not a crime, it still counts as what it essentially is nowhere to get to 2, 3, 4, and 5 without the first. Looks like 7 to me.
All right, then. Anything further from the state on this?
No, Judge, thank you.
given the number of convictions, factually, although the first one's not a crime, the OWI first, Mr. Brooks is correct, is from 1993, and without that, you don't get the other criminal OWIs. But I would note the record is from the criminal record is from 1997 through 2007. That spans about a 10-year time span. It's now 2022, but there's essentially an agreement by the parties that there are 7 convictions that are listed here. I've looked at the lapse of time since the convictions. I don't know about rehabilitation or pardon, other than it looks like he did complete the earned release program, which would have resulted in a reduction of initial confinement and then converted to extended supervision. I don't see violations of probation listed, meaning that he was revoked. I see some extensions, but that could be for a variety of reasons. But given that there was a pattern with the OWIs, that the last one was a felony, that goes to the gravity of the crime. And the other issues, I'll find that for purposes of his testimony, that this witness has 7 convictions. He may be asked, have you been convicted of a crime? His answer should be yes. And then the follow-up, how many times? The answer will be 7.
That will have to be told to Mr. Liscano before he testifies, Your Honor, I believe.
I agree. State willing to relay that information.
I'd rather not, given the accusations levied by Mr. Brooks. I think it's better we do it in open court, Your Honor.
All right. Who's your next witness? Will it be Mr. Liscano? Because if it is, I'll just have him come in now and I can put him on the stand and advise him of that.
May I ask who's present right now?
For sure, Mr. Hayes and Mr. Liscano, and I'm not sure the 330 witnesses, I think, are probably on their way. They're on their way.
All right, so Hayes and Liscano are still here.
Yes.
All right. Those are the 2 who are here, sir. I'll tell you what, either way, let's just bring Mr. Liscano in case he's not your first, but then I don't have to deal with the interruption with the jury. You don't have to call him first unless you want to, but I'll just bring him in and advise him. So if someone from victim witness could bring him in, please. Can I have a first name for this witness, please?
It's
Abel, thank
Abel,
you.
but I believe it's pronounced a different way. It's Abel.
Abel, thank you.
Abel.
Subject matter jurisdiction, Your Honor.
Court declines to address that.
Of course. Subject matter jurisdiction.
For the record.
Your objection's noted. Court
Should have seen that one coming.
Do you want Mr. Liscano on the stand, or are you going to call Mr. Hayes first? Just so I know what to do when he comes in.
I don't currently I can't find paperwork for Mr. Hayes. Can a police report or something be provided in case I want to call Mr. Hayes first?
Yes, we will accommodate that request. It'll just take me a minute, Your Honor, to find it.
And
I'll have to
more
have it printed and brought
stalling.
over, or Mr. Witchow can run. Thank you, Mr.
I will give you
Witchow.
permission to email it to Teresa, and she can print it in the courtroom. That
Well,
will assist.
it's part of a 700-page PDF, so I can't just email one page.
I see.
At least I don't know how to do that. Copy and paste it into a Word document.
That's all right. You can do it the way that you need to. All right. Mr. Liscano, I'm just going to have you for a moment take a seat. You're not going to testify just yet, but just come up and take a seat just at the end of my jury box for now. I'm not going to have you come up to the witness stand. Everyone can have a seat. I want to advise you that I'm aware you have a prior record. And so for purposes of testimony, I've made a determination that if asked, have you been convicted of a crime? Your answer should be yes. And then if someone asks the follow-up, how many times? The answer to that is 7. Have you heard me say that? Do you understand that?
Yes.
All right, thank you. I'm not sure that you'll be called next, but I wanted to do that while I didn't have the jury here. You can go back out into the hallway then. Thank you. All right, then let's have the jury brought out, please.
Exactly. This is not first year law 101. I heard other judges say lack of knowledge is not an excuse to explain more than the usual to him. Exactly. I 100% agree with that, T-Bose. I mean, the judge is doing everything she can to avoid a mistrial or an appeal.
All rise.
Thank you, everyone. Please be seated. The defense may call its next witness.
Defense calls, is it Jason Hayes? Jason?
All right. We'll have the witness brought in. Is it Haynes or Hayes? Does anyone know?
No N to the best of my knowledge.
Hayes? All right. Good afternoon, sir. If you would please make your way to the witness stand, which is on my right. Upper riser. When you get there, please remain standing. Raise your right hand. My clerk, Teresa, who's across from you, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. The first thing I will ask you to do is to state your first and last names for the record and spell each.
Jason, Jason, Hayes, Hayes.
Thank you. Go ahead, sir. Your witness.
Just 1 second.
And now, of course, he is once again going to delay questioning the witness. Because why wouldn't he?
I accept for value and return for value this document for the record.
You gotta be kidding me.
Good afternoon, Mr. Hayes. Is that how you pronounce Hayes?
Yep,
What do you do for a living?
I'm a retail sales associate for a food broker, Damon Worldwide,
Been doing that for a long time?
21 years.
Yes, a long time. The evening of November 21st, 2021. You recall that evening pretty well?
Fairly well, yes.
I agree with that.
What
That's
were
for
you doing
sure.
that evening?
Went to the parade.
Did you go to the parade with family, friends?
I went there with my daughter.
Do you recall what time you arrived?
30 minutes before the parade started.
Were you scheduled to do any marching in the parade itself, or
No.
just spectating?
Yes.
Just for the record, did you say yes to being a spectator?
Yes.
Thank
That's
you.
what I thought he said.
Yeah, yeah.
I just wanted to make sure there was.
Yeah, he answered. He answered. Anything unusual catch your eye that day that you recall?
Yes.
And what did you see?
Besides the parade,
Yeah, I'm sorry. That was unusual that caught your eye that evening.
well, where we were, yes, a red truck came through where we were. It honked and swerved.
I guess I want to back up a little bit. Where were you positioned at that
We
time?
were all the way at the beginning of the parade.
Okay.
Like it was Main and corner of Main and White Rock.
Okay. And you said you observed this vehicle honked and swerved.
Yes.
What did it swerve from?
I'm sorry.
What did it swerve from?
Where?
Or was it? I guess the correct question would be, why did it swerve?
I don't know. I wasn't driving. I don't know what his intentions were.
And you stated that the vehicle honked. Was that just a single honk, or was it a beep beep, or
One honk.
Oh God, here we go with the stupid horn again.
Do you recall stating that it honked several times?
I don't
And
recall.
when you were initially.
He's brought
I
up
don't
this
recall.
damn horn so many times during cross-exam when the prosecution was making their
So-
case.
Well, before we get to that, did you see where the vehicle went after it honked and swerved?
Yes, it kept on going straight down Main East, well, the same route the parade went.
Did you get a description of who was driving the vehicle you saw that
I
day?
did not.
Did you get a license plate?
I did not.
Do you recall if the vehicle had any tinted windows?
No.
And I'm assuming at some point you either were interviewed by law enforcement or seek to be interviewed by law enforcement.
I did, by a detective.
And do you recall if that was the same evening or?
It was.
Thanks, Devos. Glad you're enjoying the
A couple
stream, my
days
friend.
after.
Do you recall in that interview that you had with the detective stating that your kids were playing in the roadway and the operator of the vehicle honked the horn several times and veered to the left around the kids?
Yes,
So in your opinion, it wasn't trying to strike the kids?
correct, yes.
And after it continued, I think you said east?
Yep.
Would that be correct? East?
Yep.
Did you see the vehicle strike anyone?
I did not, no.
Do you recall what side of the street the vehicle was traveling on at that
It
time?
was on the right side.
The right side.
So we were on the north side of the road.
So the right side would be.
Yep.
Did you see the vehicle stay on the north side of the road for the duration of the time that you observed it?
Yes.
So you never saw it go to the other side of the road, or?
No.
No further questions at this time.
Thank you. Any cross?
Yes, just briefly.
Mhm.
Good afternoon, Mr. Hayes.
Good afternoon.
Thank you for your attendance, sir. Mr. Hayes, do you remember seeing a police officer at this intersection as well?
I don't recall.
Okay. Do you remember writing in your report or telling the police officer that a police officer chased the vehicle on foot?
Objection, leading.
Overruled. It's cross. You may answer.
I do remember that I thought I saw a police chasing after the car on foot.
Okay. And do you remember also telling the same officer that the SUV took off down the street and that it accelerated?
Yes.
Objection.
Is that
Hold on, there's been a.
Here we go with the stupid objections.
I guess the objection to be what officer is being referred to.
He doesn't even know what he's objecting to.
Overruled. The state may continue asking the question.
I guess I was asking, was that referring to?
That might be part of the reason, but
Objection is noted. It's overruled.
they might have
The state may
actual
ask
real
question.
questions.
Is that your recollection, sir, that the vehicle sped off and accelerated away?
Yes.
Objection speculative.
Overruled.
Do you also recall telling the officer who interviewed you that the driver of the vehicle had a dark complexion and a beard?
Yes.
Is that accurate with your recollection of the driver?
Yes.
But you didn't see a face, you couldn't
No.
identify anybody beyond those descriptions, correct?
Hold on. There's been an objection to leading. It's overruled. The witness may answer.
No.
All right, thank you, sir. Those were all my questions.
Thank you. Any redirect, sir?
Briefly,
He doesn't know how to use his objections. He's proven that time and time again throughout the trial.
you made a reference to the driver of the vehicle having a dark complexion. What would you consider a dark complexion?
A dark complexion. I don't know.
It is kind of hard. Did you notice any clothing?
I did
on
not
the driver?
know.
Did you notice any hair?
No.
No further questions?
All right, thank you. You may step down. And you are excused. The defense may call its next witness, please.
That witness, though, didn't really help his case. Like, I don't know, at least in my mind, it really didn't seem like it helped him.
Quick question before I do: who's supposed to be arriving at 3:30? Just so I know.
I'm not sure.
Fabias and Urel will be here at 3:30. Mr. Liscano is here now, Your Honor.
Thank you.
I knew who's here now. Just trying to get clarity.
Are you going to call Mr. Liscano?
It would appear so. He's the one that's here.
All right, then he may. Defense is
Wow.
calling Abel Liscano.
His attitude, man, like, can't stand
Defense
it.
is calling Abel Liscano.
All right, very well. We'll have him brought in. Thank you.
And that's exactly true. None of these witnesses are helping him. Like, they're just digging his hole
Sir, if you would
deeper.
please make your way to the witness stand. When you get there, please remain standing, raise your right hand. And my clerk Teresa, who will be across from you or is across from you, will swear you in. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, sir. Please have a seat. First thing I will have you do is to state your first and last names for the record and spell each.
Abel Lascano, ABEL LAZZANO.
Thank you. Your witness, sir.
Good afternoon, Mr. Lascano. What do you do for a living currently?
I'm a hairdresser.
No judgment whatsoever on this question. Have you ever been convicted of a crime?
Yes, I have.
And how many times?
7.
Do you recall the night of November 21st, 2021 pretty well? I know it's been a minute, but
Best as I can, yeah.
what were you doing that evening, if you recall?
The Christmas parade?
Were you marching in the parade? Or,
No, I was watching it.
who were you there with? Family, friends?
My wife and my daughter.
Do you recall where you were positioned to watch the parade?
I was standing in front of the Corey Insurance on Main Street.
Okay. Is that part of Main Street close to like a side street? If you recall,
not too far from Maple.
Do you recall the side streets being barricaded during the parade?
I don't remember.
Do you recall what time you arrived at the parade that evening?
It had just started, so whatever time that was at.
You recall something other than the parade catching your attention that day?
People getting hurt, yeah.
And what did you see that day, if you recall?
I saw a red SUV plow over a bunch of people.
And how is this supposed to help his case? He may as well just be a witness for the prosecution.
Yeah, you're standing right there.
And how many people did you see in the vehicle?
Just one, the driver.
So, do you recall flagging down a law enforcement vehicle that evening?
Yeah, I do.
And do you recall what you told the officer that evening?
Not very well.
Yes, he did.
I'm gonna attempt to see if anything brings back some recollection. First, do you recall the name of the officer you flagged down that evening?
Officer Moss.
Do you recall telling Officer Moss that you observed 3 or 4 people in the SUV as it passed you?
I don't remember that.
That's exactly what he's doing. He's literally helping the prosecution. Like, what the hell is he trying to accomplish with this witness?
So, to your recollection, the SUV that you saw, did it have tinted windows?
I don't remember.
And do you remember what the description was that evening that you gave to law enforcement?
I told him it was a red SUV.
The description of the driver, do you remember that?
I know he was a black male.
Is that all you recall about your description?
That's all I remember.
After seeing this vehicle, what did you do?
We left. I got my family out of there.
And where did you go?
We headed back to the car.
Do you recall where your vehicle was parked?
Believe it's the Lindholm or what building.
Oh, I'm waiting for that to happen. I'm just waiting on it.
And did you see the vehicle stop on Maple Street?
Which vehicle?
The SUV that you claim you saw.
Oh, no, I didn't see it stop. No. It kept going through the parade.
And speaking with, is it Detective Moss? Well, speaking with law enforcement that evening, do you recall advising law enforcement that you observed 3 black subjects running from the vehicle?
No, I don't remember that.
If it pleases the court, I would like to show the witness this. I'm referring to page 4 exactly.
Is it a statement this witness personally wrote?
I believe it's what, I don't think he wrote it himself.
So it's a summary written by another person.
By, I don't know if it's Officer Moss or Detective Moss. I'm not sure what his rank is.
Continue with your questions. I'm going to deny the request that you showed the exhibit or the paperwork to the witness.
Do you recall making the statements to Detective Moss that you observed one where it says one was described as running southbound on Maple towards College Avenue? Do you recall that?
No, I don't.
Do you recall stating that the other 2 were described as running in a westerly direction from the rear of 338 Maple Street?
No.
Do you recall stating that one black subject was described as tall, wearing a blue top and blue and black pants, while the other subjects were described as 2 short black males wearing sweatpants?
Barely, a little bit of that.
So, which of these subjects do you minimally recall wearing those items that evening?
No, you asked me if I remember people running, and I said no. I remember describing those people to him.
That would be great to see.
I remember.
So where did you observe those?
Standing by the vehicle, where I found the vehicle, where I spotted it.
just so we have clarity, describe the subjects you saw that evening standing by the vehicle.
I don't remember that good. I mean, you were describing them, so it brought back a little bit, but I can't tell you. That was too long ago.
And how did you come upon the vehicle at the address of 338 Maple Street that evening?
I was walking my family back to the car. Try to get them to safety. So I was keeping an eye out and I spotted it.
Do you recall stating that you saw the SUV reverse into a driveway?
No.
Do you recall why that would be reported?
No. When I found it, it was parked already.
Do you recall when you initially had the interaction with Detective Moss? Do you recall leading him to where the vehicle was ultimately found?
Yeah.
I'd really love to know how he's thinking in his head, how this is helping him. Because to the rest of us, obviously, it's just hurting him more than
Do you
anything.
recall yelling at subjects standing outside of the building where or near where the vehicle was that evening?
I remember asking them. I don't remember yelling at them.
Thank you for coming, Ravenwingg. I'm glad you enjoyed the stream. And I'll see you next time, my friend. Have a great weekend.
Do you recall why the report says that you advised Detective Moss that there are 3 black subjects, specifically black subjects, running from the vehicle?
No, I don't remember.
Were you yourself injured in this incident that evening?
No.
Do you recall stating that, well, let me back up for a minute.
Did you speak with another detective that evening, if you recall?
Yes, I did.
And do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with two different law enforcement officers that evening.
Yep, that's all it is. BS line of questioning.
Do
Now,
you recall in your interview with Detective Coates?
Bruins are the best. Just saying.
In reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
In your opinion, did it look like they were nervous or attempting to hide?
Well, everybody was running past them and walking really fast, and they were just standing around there. They were the only ones not doing much. So yeah, they stood out.
Now, this is the question actually was in reference to when you spoke with Detective Coates that evening, in reference to seeing the vehicle in the parade as it passed you. Do you recall at that point, while at the parade that evening, do you recall stating to Detective Coates that it appeared that there were 3 or 4 people in the Ford Escape as it passed you during the parade that evening?
No, I don't remember that.
Any reason why the Detective Coates would report that that's what you stated to him?
Like I said before, I saw 2 or 3 people by the vehicle, so I assumed they were with the vehicle. So they must have been in the vehicle during the parade. I saw the driver going by because he hit somebody right in front of us.
Do you recall in your interview with Detective Coates that evening stating that the 3 individuals, and I'm referring to who you saw next to the vehicle, so it's clarification. The 3 individuals who were standing in a line shoulder to shoulder as African American males?
Yeah.
So it's fair to say that's what you observed that evening?
I saw at least 2 of them. And looked like they were standing in front of it.
And during that interview with Detective Coates that evening, do you recall stating to Detective Coates that you may be able to recognize the older male. So I'm assuming one of the individuals that you saw standing shoulder to shoulder was a older male.
I don't remember.
I like Discord. It's just fun. It's kind of like, to me, it's the modern day version of AIM Instant Messenger.
Any reason why multiple, well, I'm not gonna say multiple, two. Any reason why the two detectives that you spoke with that night both reported that you stated you saw 3 black subjects running from the vehicle?
No.
And during the parade incident, were you or anyone you were with injured that evening?
No.
No further questions at this time.
Thank you, Andy Cross.
Yes, Your Honor, thank you. Good afternoon, Mr. Lescano.
Good afternoon.
Hey, Miss Mandy, good to
Sir,
see you. Hope you're doing well.
You said you watched the parade near Curry Insurance, is that correct?
Yeah, right in front.
Okay. Do you remember, you said you saw the SUV strike some people in the parade?
Yeah.
Yes. Do you remember what group of people in the parade? Can you remember anything about the name or the banner or the costumes or anything like that?
Objection leading.
Overruled, Ms. Cross.
Yeah, got the face cam on today.
Overruled. The witness may answer. I believe he said no. His answer may
Yeah, no, I don't remember.
Okay. Do you remember seeing the SUV strike more than one person?
Yeah.
Objection, speculative.
Overruled.
About how many people did you see the SUV strike, sir?
Objection, speculative.
Overruled.
It was crowds. I mean, when it was coming through, because I was standing over my daughter and my wife, they were sitting on the curb. I said, through, and at first it looked like it was just pushing people out of the way, and then it just kept swerving back, and it was just plowing everybody out of the way until it got to in front of us. Then it actually hit somebody, and it just did like a cartwheel in there.
You remember that?
Yeah, it was right in front of us.
That's exactly what he's gonna do. I agree, Carlina.
Answer.
That's what his plan is. He said that for a couple of witnesses now.
Directioning his hand from right to left, describing the vehicle coming from right to left. And then when he said he saw someone go into the air, he was like twirling his fingers as if to say it kind of tumbled in the air. All right, go ahead.
Thank you. So, Mr. Lescano, I want to talk about the moment when you located this vehicle on Maple, okay? I'm going to ask, Madam Clerk, could you please turn on the AV system? We're going to put up State's Exhibit 65.
Go ahead.
Objection to the relevancy of Exhibit 65.
Noted, overruled. It's been received. The state may proceed.
He probably doesn't know what Exhibit 65 is.
Seconds, but before we begin to play it, sir, do you recognize the area on the screen that's
Yeah.
shown in this picture?
Yeah, I believe that's Central Middle School,
Where?
right at where the stairs is.
Okay, the red brick on the left side of the picture?
Yeah.
Objection,
Okay.
speculative.
Overruled. His answer may stand, he said, I believe.
And would you agree with me, the house where the SUV was found was up in this area here where I just put the green dot on the screen?
Yeah.
Objection, leading.
Overruled.
Here we go with the ridiculous
That looks right,
objections
correct, sir?
again.
Objection, leading.
Overruled.
All right, we're gonna clear the screen, please, and we're gonna play this entire clip for 36 seconds. Please watch and see if you see yourself or any of your family members in this clip.
Objection to the relevancy of this video to this particular witness.
Overruled. You may play the clip.
Overruled on what grounds, Your Honor? Is that a tacit agreement?
Freaking hell, tacit agreement. The judge doesn't have to answer you. The judge has explained this to him multiple times that they are allowed to lead on cross-exam. He does not
Sir, did
understand
you see
it.
yourself or your family in that clip?
Objection, speculative.
Overruled.
No, I did not.
Okay. Now, you said you did see, by the time you walked past the car, you saw 2 or 3 black males standing near the car, right?
Objection, mischaracterization of this. He said 3. Specifically said the number.
Overruled.
And you also said you saw 2 or 3 what you thought to be black males on the porch of the residence there, correct?
Objection, stated it was black males. Asked and answered.
Overruled. The witness may answer.
No.
I'm sorry, go ahead.
No, there was 2 or 3 standing by the vehicle.
Okay.
And then on the porch, there was maybe 3 or 4 more people. I don't know if they were, I'm sure they were white, but
okay.
I was trying to not make it obvious because at the time, I believe that they were with the vehicle. So I didn't want them to see that I saw them. So I just did what I thought was right at the time.
Sure. Do you happen to know the people that live at this house?
Objection, speculative.
Overruled.
No, I do not.
Would it be reasonable, do you think, Mr. Lescano, that people living in the house heard the crash and came outside and that's who you saw standing there by the vehicle?
Objection, there was never any crash mentioned.
I'll sustain. Calls for speculation.
Mr. Lescano, is it possible that the people you saw standing near the vehicle were in fact just neighbors that saw the vehicle the same way you did?
Yeah.
You described that at the time you went by on Maple Street, there was a lot of people running around in the area. Is that correct?
Objection, mischaracterization of testimony.
Overruled.
Yes, it was.
And these are people hurrying away from the parade with their families, trying to get to safety just like you were.
He
correct?
does not know how to use. He does not know how to use his objections.
You didn't see anything like that in State's Exhibit 65, did you?
Hey, welcome back, Cats Gamer. Good to see you.
You said on direct examination that you saw the driver of the SUV in the parade. Is that right?
Yes, I did.
And you see that driver present in this courtroom here today, please?
Objection, speculative.
Overruled.
Yes, he's sitting right over there.
Are you sure about that, sir?
Yes.
Objection, speculative.
Overruled.
You said
And
that.
it mischaracterizes the testimony because that was not testified to before.
Oh my God.
Your objections are overruled. I believe the witness already answered. Go ahead.
Did you happen to notice in Exhibit 65 the red SUV in that video clip that you watched?
No.
You didn't see it at
Couldn't
all,
see
did
it,
you?
no.
Okay, just wondered. Mr. Lescano, have you and I ever spoken about this case, sir?
No.
What about Attorney Basie here to my right? You have heard her ever talk about this case through your testimony?
Objection, hearsay.
Overruled.
No.
Mr. Witschow on the end, did you ever talk to him about
Objection.
your testimony, sir?
Objection, hearsay.
Overruled.
No.
All right, thank you, sir. I don't have any other questions.
Thank you. Any redirect?
Yep.
Go ahead.
You stated that you saw the driver, correct? Of the SUV that you saw that day, correct?
Yes.
How did the driver look that day you saw him?
He had a scruffy beard and he was a black male.
Did you see what the driver was wearing?
No, I don't remember that.
Did you see if the driver had any hair?
I don't remember that either.
Did you see if the driver had anything noticeable about their appearance, tattoos, scars, marks, anything like that?
No. I saw the side, the profile, the side. You were flying fast down that street. I wasn't paying attention to the color of clothes you were wearing. I knew it was a black male and had a scruffy beard. The first thing I told my wife is he was a black guy driving.
And do you recall how long you were able to get a side view, as you called it, of the alleged driver?
Well, it had to be a couple seconds.
And
Yeah.
in a couple seconds time, you were able
Wouldn't
to
be
make out
surprised.
the driver's profile and race just by a couple seconds.
Yeah. It's not hard. I tell if you were white or if you were black and if you had a beard. No, that's it. I don't know what color shirt you had on. If you had hair, a hat on backwards.
Give it up, Brooks. He's already identified that it was you
So that leads
driving.
back to the question of, is that the only person you saw in the vehicle?
From what I remember, yes. I saw the driver. Like I said before, the reason why I thought there was 3 or 4 because I saw 3 or 4 people around the vehicle when I spotted it.
So would it be
That's
fair,
the only reason.
would it be fair to say that
If I had to guess, yes, that's what he's trying for.
when you spoke with 2 different
At least that's what it
detectives
sounds
that
like.
evening, the evening of the parade, both of those officers reported that you stated there were 3 or 4 people in the SUV as it passed you. Is that fair to say?
Oh, wait, can you repeat that again?
Just for clarification, you already stated previously in testimony that you spoke with 2 different detectives that evening, correct?
Yes, I did.
And both detectives that you spoke with that evening, the evening of November 21st, 2021, you stated to both of those law enforcement officers, detectives, that you observed 3 or 4 people in the SUV.
Like I said before, the reason why I said there must have been 3 or 4 was because they were standing by a vehicle. So I assumed that they were with the vehicle. I don't remember seeing them in the vehicle when you were hitting the people.
You stated this to both detectives,
All of
different
his
detectives, the evening of November 21st, 2021. And this was in relation to what you saw from the vehicle at the parade, not where the vehicle was later found. Any reason why you stated to both detectives in relation to what you saw at the parade? Why both detectives in their reports stated that you told them that you observed 3 or 4 people in the SUV at the time of the parade?
every single witness he's called
The question is,
has
why did you
made the
report that
prosecution's case
to 2
stronger.
different detectives
He hasn't had one
on the
witness
same
that
evening?
has actually helped his case so far.
Like I told you before, when I walked past the vehicle, I spotted more than one individual standing in front of the vehicle. So I assumed they were with the vehicle. That's why I said they were inside.
I'm sorry.
That's why I said they were in the vehicle. I said there had to be at least 3 of them in the vehicle. That's the only reason I said that.
So why would you report that you saw this during the parade?
I don't know.
And during both
interviews with detectives that evening, the evening of November 21st, 2021. You also stated to both detectives that you observed 3 or 4 black or African American is the word used. 3 or 4 African Americans running from the vehicle. Any reason why both detectives reported that you said that?
I don't remember.
No further questions.
Thank you, sir. You may step down. We have additional witnesses here.
Yes, Your Honor, ready?
All right, would that be how many people?
There's 2 left.
Okay, so the 2 left on your list. Your next witness, sir.
So I'm guessing that's.
He doesn't know who his witnesses are.
Just give me 1 quick second, Your Honor.
They're
1
his
quick second.
witnesses, and he doesn't know who they are. He's just stalling again. He probably knows exactly who he wants to call, but he's just stalling like he has been throughout this damn freaking trial.
Sorry about that, Your Honor. I'm just making sure I have the correct paperwork.
My jurors need to stand. Go ahead.
This is what I was looking for. Some of this stuff is so much paperwork.
Okay, great. That'd be great.
Okay, I'm ready, Your
Go ahead, call your next witness.
Honor.
We've been waiting on you the entire time.
Kathleen Uriel?
Urel? That's how I think it is. We'll find out. All right, ma'am, if you would please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and my clerk Teresa, who's on my left, will swear you in. And go ahead and come all the way up. Thank you.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
Kathleen, Kathleen. Last name Urell, Yourell.
Thank you so much. Your witness, go ahead.
Good afternoon, Miss Uriel. Is it Uriel?
Urell.
Uriel. What do you do for a living?
I'm in workforce management for a call center.
November 21st, 2021. Directing your attention there. You recall that evening pretty well?
Off and on, sir.
That's fair. It has been a while. Do you recall what you were doing that evening?
Yes, sir.
And what were you doing that evening?
At what time?
Around 3:30, 4 o'clock-ish.
I was dropping off my children who were participating in the parade.
And did you yourself stay for the parade?
Partial parade, yes.
Yeah, but we all know
Partial meaning,
he'll stall
maybe a few
some
minutes.
way. He'll stall.
Until my group of children went by.
Okay. Do you recall where you were positioned during watching your group participate in the parade?
Yes, on north and east, right on the corner there.
North and east.
If you're going parade route, it would be on the right-hand side.
Okay. Just so we have clarification.
That is true. He has.
Exhibit, I believe it's
He says that he's been saying that's all the questions I have for now. So he's gonna retry. He's gonna try and recall all the witnesses.
Can we show it to the witness first?
He doesn't want it published, so just to the witness for now.
Just not yet. Just I want to make sure the witness gets a chance to view it first. Can you see that on your screen yet?
I do.
And using the touch screen, it's a touch screen. Can you point out where
It's not published. So do you
Oh.
want it published?
I'm sorry. Yeah, publish.
Sorry, I didn't mean to interrupt, but I just wanted to point
So
that out.
just so I know, to use the touch, it has to be published.
No, she could use it, but if you're gonna have her do it, it should be done in front of the jury.
Fair.
Okay, go ahead.
I think we got to wait on the jury, right?
Thank you.
For the jury, and can you, using the touch screen on your screen, can you point out exactly where you were positioned?
When I was watching it,
Yes, when you were watching
right on the corner. Sorry. Oh, well.
it.
You
want
bet
me to
there'll
do
be a
it again,
tantrum.
do it
The
again.
arrow.
We'll
No
clear it, you
doubt.
can do it again.
No doubt about it.
If you don't want, do you want the arrow?
Well, it was to the.
Clear it again.
Okay.
So it's a touch screen, so use your index finger and you can draw a circle.
Okay.
I was gonna
Can you
say
clear
that.
Well, I mean, it was right there, but.
I was gonna say a circle or a little dot if.
Well, I thought I was doing that. But...
Yeah.
Oh.
Hold on.
Heavy
We'll do it
hands.
again. So press and hold while you draw.
Okay.
And you said that would be approximately East Main and Northeast.
Correct.
And do you recall if those will there's side streets right there that you can see? Is that fair to say?
Correct.
And those side streets would be Northeast and Buckley, correct?
Correct.
Do you recall if there were barricades at those?
I can't honestly recall. I can't be sure.
We can take Exhibit 15 down.
Thank you. Go ahead.
And you said you stayed at the parade until your group had passed.
Correct.
And
It was hard to see, but
what time did you
I
leave?
saw it.
I can't determine the time. It was right after my group of kids went by.
And where'd you go from there?
I walked down, well, I went to go get the car because I had to go pick them up at the end of the parade.
And I'm assuming at some point your attention got drawn to something happening. That'd be fair to say?
Not necessarily.
What do you remember when you went to go get the vehicle to pick up members of your group? That'd be fair to say first? I don't want to assume.
Yeah.
Do you recall anything happening at that point?
A situation did occur before the said big event that took place.
What do you recall happening at that time once you were on your way to get your vehicle?
I think I need more specifics from you to give the details you may be looking for.
While you were getting your vehicle, did you observe anything happening? Did you overhear about anything happening at that point?
Nothing of that nature. Well, all I can say is that I was walking past White Rock.
Did you see anything that may have alerted your attention at that time?
Yes, a car coming through the parade at the beginning on White Rock where the parade was starting. So when I left, I walked down Main to White Rock on the corner there. Then a gentleman, a child who I don't know who they were, and myself walked across the street. And at this time, a car was beeping and weaving around a slight curve that White Rock has, and then continued on.
Did you see did you see where the car went at that point?
Yes, I did. As it came around the slight curve White Rock has, it started to move forward, and then it went straight across. When I was thinking it was going to leave the parade route, if you leave the parade route on Main, you're leaving. Sorry, if you turn left, you're leaving the parade route. If you're turning right, you're going right into the parade. And it went right to if you're looking at the parade, it was on the right-hand side. And it's continued on into the parade.
Hold on, just for the record, she was using her hands
Yeah.
during her testimony. I just need,
Left.
that's okay. I just need to make a
Yeah.
record of it. Usually her right hand just kind of demonstrating the course of travel that she described, the vehicle. And I think that's probably all I need to put on the record about that. Go ahead, next question.
I want to back up a little bit. When you first observed this car, as you say, you recall that it was blowing its horn.
Yep, the horn was beeping.
Do you recall if you saw who was operating that vehicle?
Unfortunately, sir, I can't recall.
Do you recall if you might have seen multiple people in the vehicle at that time? Or?
You know, unfortunately, due to the time passing, I cannot recall.
That's fair. It has been a while.
Do you recall about what time that was that you observed the vehicle?
Again, I can't be sure.
Sorry if I keep asking.
No,
stuff.
I can't be sure. I'm sorry.
And yet he thinks he's doing a great job right now. As if he was actually accomplishing something other than making it an even easier case for the state.
At the time that you observed the vehicle, did you see it strike anyone?
I did not, or at least I don't recall. I'm sorry.
And do you recall if the vehicle was speeding at that point that you observed it?
It wasn't speeding, but it was, all I can state is it wasn't speeding.
That is true. The way this is going.
Did you happen to catch the license plate number of the vehicle at that time?
No, not at all.
Do you recall if the vehicle had any tinted windows?
I couldn't recall. I'm
Any
sorry.
windows rolled down or up at the time you observed it?
No, unfortunately, I don't remember.
Do you recall if the vehicle passed close to where you were walking at the time?
Yeah, it was close enough that it could have easily have had clipped me or the two people that were in front of me.
Were the two people that you referred to in front of you, were any of you hurt at that time?
No.
No further questions right now.
Hey, Cross.
Yes, thank you. Good afternoon, Mr. Bell. Thank you for
See, he said no further questions right now.
You
So
testified on direct examination that you don't recall.
we all know what he's
whether
gonna
or
do.
not you saw more than one person in that vehicle we're talking about. Remember saying that?
Yes.
You remember meeting on December 2nd, 2021 for an interview with Detective Jay Carpenter from the Waukesha Police Department?
I remember going as to a lot of topic of conversations. I unfortunately can't recall those too clearly.
Do you remember telling Detective Carpenter that you only observed a driver in the vehicle?
Objection, leading witness.
Yeah,
Overruled, you may answer.
I can't be too sure.
Overruled, she may answer.
Can you say that again? I'm sorry.
I can't be too sure. Again, some of the conversations I may have had that day.
Do you remember what this vehicle looked like?
I do not.
Do you remember telling Detective Carpenter that it was a red truck?
I do not.
Can we please put up for everybody Exhibit 15 again?
Go ahead.
Can we zoom in on the intersection of?
Yep,
East and
none
Main?
of his witnesses have been helpful to him whatsoever.
Go ahead.
Yet in his delusional mind, he thinks he's doing something great. Like,
Thank you.
he's literally helping the
Testimony is that you were standing
prosecution.
here on the northeast corner of Buckley and Main Street. Is that right?
Correct.
Objection already answered that, asked and answered.
Overruled, she may answer.
You said correct.
Correct.
And after your children walked by in the parade, you walked in this direction towards the intersection of White Rock and Main. Is that correct?
Objection,
Correct.
leading and speculative.
Overruled as to both, you may answer. If there is another objection, just
I'll
wait
pause.
until I rule on it.
Sorry.
Thank you. No, that's okay.
Correct, that was.
And then you crossed through the crosswalk on the north side of Main Street. Is that correct?
Yes.
Is that when you saw this vehicle we've been talking about?
Yes,
So you were standing in the crosswalk.
correct.
Do you remember a police
Oh, it's
officer being
true.
at that intersection?
I can't be too sure.
Was it clear to you that this was a parade route?
Yes, it was very clear.
Was it clear to you that traffic from White Rock should not have driven onto Main Street
Yes,
unless they were part of the parade?
yes.
Did it appear to you as though the vehicle we've been talking about was part of the parade?
No.
How many children do you have, Miss Urel?
Objection irrelevant.
Overruled. You may answer.
4 children.
All 4 of your kids were marching in the parade that day, weren't they?
Yes.
Objection leading.
Overruled.
Sorry.
Your oldest daughter, Charlotte, she was 14 at the time?
Yes.
She was marching with the Extreme Dance Group as an alumni, wasn't she?
She was handing out candy.
Objection.
There was an objection, it's overruled.
I didn't even state why I was objecting, but okay. We still need a 15.
Yes, please. You see on that map the 5 points intersection?
Yes.
When you were standing in the crosswalk at White Rock in Maine, could you see the 5 points intersection?
I could not.
You didn't see your kids get hit, did you?
I did not.
Objection leading.
Sorry.
Overruled.
Okay, I'm sorry.
Objection hearsay.
Overruled.
You didn't.
I did not.
Did you see them later that night?
Objection leading.
Overruled. You may answer.
I was only able to see 2 of my children that night.
When did you see the other 2?
Days later, when I was able to leave Children's Hospital.
As their mother, you were directly involved in their medical care, and the decisions that were made in that process in the days after the parade?
Objection leading.
Overruled. You may answer.
Yes, their father and I.
Charlotte suffered a chipped vertebrae from being struck, didn't she?
She did.
Objection
Sorry.
leading.
Overruled. You may answer.
She did.
Your daughter Alice, she was 10 at the time, wasn't she?
She was.
She suffered chipped front teeth, is that correct?
Yes.
And facial scarring
Yes.
and road rash
Yes.
and a broken fibula and tibia
Yes.
and broken metatarsal bones.
Yes.
She was observed in a concussion protocol, is that correct?
She was.
Your daughter Vivian, she was marching with the Extreme Dance Group too, wasn't she?
Yes, she was.
How old was she in November of 21?
She just turned 7.
Vivian suffered a severe concussion, didn't she?
Objection leading.
Overruled.
Because he's an idiot.
Yes.
And road rash
Extreme road rash.
and a lung contusion
Yes.
and facial scarring.
Yes.
And your 7-year-old daughter Vivian suffered a broken tailbone, didn't she?
She did.
Your son Grayson, he was 8 on November 21st, 2021. Is that correct?
That is
Objection
correct.
leading.
Overruled.
He was walking with the Extreme Dance Group handing out candy. Is that right?
He was.
He went to the hospital after the parade, didn't he?
Yes.
He suffered a compound fracture in his femur. Is that correct?
An open compound fracture.
Meaning the bone came through the skin?
Yes.
Objection hearsay. I don't believe he's a doctor.
Overruled. The witness may answer based upon personal knowledge.
Is that a yes?
Yes.
A police officer saved Grayson's life by placing a tourniquet on that open leg wound. Is that correct?
Yes.
I don't have any other questions.
Will you read the record?
No redirect.
Thank you, ma'am. You may step down.
And I think you're exactly right, JCarr. He's loving every second of this.
Let me call your next witness, please.
He had no
Take down these exhibitors. You're gonna stay up on there.
Thank you. We'll take it down.
he had no redirect for that witness. That's literally a free witness for the prosecution right there. And the jury is not, I'm sure the jury is pissed with Brooks.
Please call your next witness.
Just 1 second.
And here we go with Stalin again. Uh-oh. Hang on. Might have to reload the page. Yeah.
Please call your next witness.
Just 1 second. So you one more person here, right?
It's my understanding, sir. Would that be correct, Attorney
Yes.
Upper?
Yes, she's in the courtroom, ready to go, Your Honor.
Defense calls Catrice. I don't know how to say the last name.
Can you give me the spelling that you have?
Yeah.
B-A-B-I.
Sure, I will.
S-Z.
Maybe sometime this weekend, maybe, or something.
Fabias?
Maybe. We'll figure it out.
Fabias. All right. Thank you. You are at the witness stand. Would you please raise your right hand? My clerk, Teresa, will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. Please have a seat. First thing I will ask you to do is to state your first and last names for the record and then spell each.
He loves to stall.
Catrice Fabias, Katrice Babiazz.
Thank you. My apologies for mispronouncing that earlier. Go ahead, your witness.
Good afternoon, Miss Fabias.
Correct.
I'm surprised I got it right. What do you do for a living?
I am a law enforcement dispatch supervisor.
And how long have you been doing that now?
I've been in law enforcement for 16 years.
The evening of November 21st, 2021, were you on duty that evening?
I was not.
What were you doing that evening?
I was attending the Waukesha Christmas parade with my family.
And do you recall what time you arrived there with your family that evening?
I arrived to the parade shortly after it started, so it was right after 4 p.m.
And do you recall where you were positioned at with your family when you arrived at the parade that evening?
Yes.
And where were you positioned at?
I was towards the beginning of the parade. I was on Main Street where it connects with White Rock.
Did anything catch your eye that evening when you were positioned watching the parade with your family?
Yes.
What did you see?
I saw a red.
Evening when you were positioned.
I saw a red SUV coming from White Rock Avenue. The vehicle caught my attention because people started yelling, and the driver was honking the horn.
And do you recall, to the best of your knowledge, it's been a little bit, the driver of the vehicle you observed was honking his horn? Was it gesturing to people?
Yes.
And what do you see? What did you see the gesturing as?
I'm sorry, I don't understand the question.
What was the gesturing?
What was the driver gesturing?
Yes. I'm sorry.
It's okay. So he was taking his hand and going like this, really rapidly, aggressively.
So for the record, the witness had her right hand up above, probably above her, I wouldn't say at a 90-degree angle, but somewhere maybe at a 45-degree angle with her hand waving back and forth multiple times in a rapid motion. Go ahead.
You yourself being in law enforcement and just based on what you were observing, the driver of the vehicle you observed was honking his horn and gesturing with this motion. Would you take that motion as trying to alert people to move out of the way? Grounds.
Sustained as to the form of the question, please rephrase.
How did you yourself take that gesturing?
I took that gesturing as the driver was telling people to get out of his way.
Let me back up. Did the vehicle pass pretty close to where you were positioned?
Yes, the vehicle almost struck my daughter.
Do you recall seeing the driver?
I looked the driver right in the eyes.
And how did the driver look?
Oh boy, here we
The
go.
driver looked like through me.
What do you mean through you? Describe what you mean by through you.
I feel that it is very hard to explain that look, but it was very frightening.
Do you recall what the driver was wearing?
The driver had a hoodie sweatshirt on, and something on his head. I wasn't sure if it was the hood of the sweater or maybe a beanie hat. It was winter. I'm not 100% sure.
Were you able to see any hair?
I did see hair, yes.
How would you describe the hair?
The hair on the head was in front, like dreads down here from what I could see underneath the hood or the hat. And then there was facial hair, beard and mustache.
Did the vehicle?
Hold on, I just need to make a record of, she was also using her hands, that's okay, to indicate at the neck, like under the chin, neck area, with her hands coming down a few inches to indicate what she was describing as hair being seen from.
Another great witness for the prosecution.
Go ahead, sir.
When you observed the vehicle approaching, was the vehicle speeding?
When the vehicle was approaching from White Rock, the vehicle was not speeding at that time.
To the best of your knowledge, do you recall there being any barriers present where you were positioned at?
Yes.
Do you recall if the vehicle you observed had any tinted windows?
I do not recall.
Were you able to make out a license plate number of the vehicle, being that it had passed so closely by you?
No, once the vehicle continued past my position, I was more concerned about my children that were with me.
I'm not sure if the
I'm
jail made him
assuming at
cut
some
his
point
hair
you
or not.
spoke with
That is a
law
good
enforcement about
question.
what you saw that evening. Would that be fair to say?
Yes,
And do you recall what agency that was?
I do.
And what agency was that?
The FBI.
At what point were you not able to see the SUV once it passed you?
I lost sight of the SUV once it went into a bunch of people.
Yeah, that's most likely comedian Will. The most likely scenario. He probably did it himself.
Do you recall what date it was that you spoke with the FBI agents on? Was that the same evening or a few days after?
It was not the same evening of the parade, but it was that week. It was within the next few days.
The day you spoke with FBI agents, do you recall stating the driver was wearing a red top that appeared to be made out of a sweatshirt-like material?
I don't recall exactly what was said to the agent, but I do remember the sweatshirt, yes.
A red sweatshirt?
It's possible.
Just a little bit ago, you said that, well, when asked the question of did you recall hair for the driver, you stated and made the gesture that the hair was in front. Do you recall saying that?
Yes, sir.
Do you recall when speaking with FBI agents stating that the hair was pulled back?
The hair appeared to be like possibly in a ponytail, but it was so full that it was coming forward.
Yeah, he's tried saying that. He tried saying that it doesn't look like him. I think he did it a couple of times while the prosecution was making their case.
Do you recall Well, let me back up. Did you leave the parade at that point
At what point?
after seeing the vehicle?
Yes.
Good night, Gary. Thank you for hanging out, and I'll see you next time, my friend. Have a great weekend.
Were you injured the evening of the incident?
Yes.
You were injured?
Yes, I was.
Any reason why that's not reported?
Probably because I didn't tell anyone else.
If you were injured, why not tell anyone?
Because I haven't wanted to talk about the traumatic experience that I went through for still reliving the weeks and days after the incident.
It doesn't make any sense. You talked to FBI agents a few days where you said you didn't, to be fair, you said you didn't know. You said it was that week is what you said. The same week. You spoke with FBI agents, reported no injuries.
They didn't ask me about injuries.
Well, would it be fair to say that kind of information would come up when talking to law enforcement, seeing as how you yourself?
He's mad at his
Law
own witness. He's
just seems
literally
odd.
angry at his own witness that he
I do
called.
not. I was not physically injured.
Oh. But you didn't report this at any time whatsoever. Grounds.
Sustained. Already answered.
So did you speak to anyone about this in law enforcement?
Objection made.
Grounds.
Overruled. She may answer. He clarified law enforcement. Did she speak to anyone about this in law enforcement? I interpreted this as the injury.
Right.
So go ahead.
I feel like, no, I did not.
Did you file any claims related to the incident?
No, I did not.
So today, your first time bringing up your alleged injury?
No, it is not.
At some point, you were subpoenaed by the district attorney's office to testify here to testify in this trial. Would that be fair to say?
Yes, it is.
Do you recall when you received that subpoena?
From the district attorney's office, it was in July.
And do you recall whom you spoke with about the information regarding the subpoena?
I'm convinced he doesn't.
I contacted the victim witness advocate, Carrie Peterson.
And now he's bringing up the subpoena, which I don't see has relevance to the trial or testimony, but
You
that's just
contacted
me.
the Ms. Peterson after receiving the subpoena.
Correct. The instructions told me to.
Okay. You ever spoke with anyone directly at the district attorney's office?
No, correction. Yes, when I walked in today, I met there and let them know I was here. And then they walked me into a room and I waited until I was called by you.
So before today, you had no interactions with anyone related to the district attorney's office besides I think you said victim advocate?
So the victim advocates who have been in connection with and letting me know when to come and all of that.
Of the three district attorneys seated to my left at this table, had you had any interactions of any kind with any of those three district attorneys?
I have not.
Take care,
I
Debos.
believe, just for the record, when you asked that attorney.
Have a good
to
weekend, my
To
friend.
herself and the two people.
Maybe I'll see you later.
Because since there's two tables,
What would be the reason for that?
since there's two tables of individuals, I think she wanted to make the witness aware. And I just wanted to point it out for the record since it happened.
Working in law enforcement for 16 years, I'm sure this isn't your first time being involved in a trial. Would that be fair to say?
I have not been in a trial for law enforcement. No, I have not.
You've never witnessed a trial, sat at a trial, been in a trial?
I have not.
Have you ever testified in any way before today? Grounds?
Overruled, she may answer.
I have testified before, yes.
So it would be fair to say that you would have knowledge of where an alleged defendant and the district attorney would sit in the courtroom, correct?
I know where they're sitting, yes.
Want to back up a little bit to the observation of the vehicle the evening of November 21st, 2021. While you observed the vehicle approaching your position, did you see it strike anyone?
I did not see the vehicle strike anyone, no.
From your opinion, observing the vehicle approaching your position, did it appear that the vehicle attempted to strike anyone?
Yes,
And why would you come to that conclusion?
because I saw an officer have to jump out of the way in order for
When
the,
it was approaching
When it was
Question
a,
was when it was approaching.
I'm
Hold on,
confused.
hold on, everyone. The question was asked, this witness is going to be allowed to answer the question fully without interruption. Go ahead and answer the question.
Thank you. I misunderstood his question, I guess.
Answer the question
okay.
that as you understood it.
Yep. So I saw that an officer had to get out of the way, and he was attempting to stop Mr. Brooks from driving through the parade, and he was at the last minute jumped out of the way from the vehicle. Otherwise, he would have been struck.
You just used the name Mr. Brooks for the first time that you've been testifying. Would that be fair to say?
Oh
I
boy.
don't understand your question.
You just used the name Mr. Brooks for the first time since you've been testifying. Is that fair to say?
That's fair to say, yes.
Why haven't you used that name before? You've been up there for quite some time.
I didn't need to.
So what changed for the last question that you needed to?
Oh my
I
god.
don't understand your question.
You just stated that
Such a dumb
you didn't mention the
question.
name before because you didn't need to. So what about the last question that you answered made you feel like you needed to use the name for that question and no question before that?
I don't know.
Yep, that's all they are. Word games.
Out of curiosity, how did you come to the knowledge of that name?
It was on the subpoena I received last week.
You just stated a little bit earlier in your testimony that you received your subpoena in July. Now you said last week.
Those are both correct.
So you received two separate subpoenas?
Correct.
What was the difference between the two?
One was from the district attorney's office and one was from you.
He doesn't know how subpoenas
So
work.
the one that you received from the
Oh
district attorney's
boy.
office in July didn't have a case caption on it?
Okay, what's a case caption?
Just 1 second. 1 second, Your Honor.
Your Honor, I just have this line of questioning. I really don't know what the relevance is for the purposes of this trial.
There was no objection at first.
But there's no.
I'm
What
not
is
sure.
the
Maybe a
objection under
paralegal, maybe,
906?
but I'm
11.
not sure.
I don't believe it advances.
I think
trial.
I think you know where I was getting at with the question.
Then you need to ask your question directly, sir. Go ahead, but I'm sustaining it as to the form of the question.
When you were subpoenaed in July by the district attorney's office, the subpoena didn't contain information to the case you were being subpoenaed for?
Objection to relevance.
Grounds.
Sustained, you don't have to answer that. I sustained the objection on that, those grounds. Ask the question, I believe that you're trying to ask, not that one.
His
Was the name
entire
that you mentioned, Mr. Brooks, anywhere on the subpoena that you received from the district attorney's office in July?
yes,
Objection, relevance.
Grounds,
Oh,
and his
sustained.
entire defense has been stupid.
grounds for the sustained. That was
Not
the-
relevant.
Even if you can even call it a defense, because he's actually helping the prosecution.
Mind-boggling.
Oh boy, here we go. Comments under his breath. Mind-boggling.
Sir, in July, when you received your subpoena from the district attorney's office, were you even aware what you were being subpoenaed for?
Objection, relevance.
Grounds.
Sustained. Not relevant.
She's testifying in the trial, and it's not relevant that she got subpoenaed?
Mr. Brooks, she's here under your subpoena.
What?
You called her as a witness.
The
It's your
subpoena that you, the subpoena
God.
is relevant because she
Mr.
was
Brooks,
already
under
subpoenaed.
90611, please ask the witness a
This is
relevant
mind-boggling.
and probative.
90611. Gotta love 90611. He's about to blow up.
Remind the
Grab your
jury that the
popcorn.
Statements of the parties or the attorneys are not evidence.
So were you aware that it was a chance you would be possibly testifying in this trial?
Yes.
And did you know who the trial was for?
Objection.
Grounds.
Sustained.
Grounds for the
relevant.
sustained.
It's not
I've
relevant.
never heard of nobody testifying in a trial that they didn't know who the trial was for.
Mr.
I think
Brooks,
that's, I think
I'm
that's very
sustaining the
relevant.
objection under 90611 and I'm asking you to move on.
Oh, it's ridiculous, man.
Shut down the questioning.
Seems to me like a like a lot of your answers are coached. Is that fair to say?
No.
So the subpoena that you got last week, is that how you learned the name that you used?
Objection, relevance
Grounds.
for the same reason I argued.
Grounds.
Asked and answered. She's indicated the answer already. 90611, sir. Next question.
The
That's what he
is that the
thinks.
first time that she saw the name.
It's not relevant.
That
Next
was not
question.
asked and answered. That was not asked nor answered.
Under 90611, please ask a question, sir.
Man, what is y'all people trying to pull up, man? This is ridiculous.
Mr. Brooks, if you don't ask another question that's relevant and probative under 90611, then I will turn the witness over to the state for their cross-examination.
And then I should be able to get redirect, right? Your Honor?
Ask a question, or I will declare the examination by you to be ended.
It's not an examination. It's a
Yeah.
hearing.
It's a direct examination, sir. Under 90611, you are directed to ask a question, or I will
I-
Yeah,
ask the
remember-
state if they
I
have
heard
any
you, Your Honor.
questions.
I heard you.
Oh,
I heard
hang
you.
on.
Thank you.
Remember, this is
Next
his
question,
own
please.
witness that he called to the stand. He's about to blow another gasket. You can feel it coming. It's like a storm that's about to hit.
Know who the plaintiff is in this matter?
Oh God, here we go.
Who's the plaintiff?
Who's the
State of
plaintiff?
Wisconsin.
Is that an entity or a living human being?
Objection.
Grounds.
Relevance.
Not relevant, sustained. Next question.
Have you ever had any interaction with the plaintiff?
We've been through this so many times during the trial.
Sustained.
Vague.
As to the form
Who
of the
the hell-
question,
Ever had
Right.
any
Who is the
interaction with the state
plaintiff?
of Wisconsin?
do not answer that question. Next question, sir. Under 90611.
Shut it down,
Was there an
Judge.
objection or was that just a ruling? I'm not sure. You're both was talking at the same time.
Under 90611, I directed the witness not to answer that irrelevant question. Ask your next question, sir.
also remember this is all right in front of the jury, so you gotta wonder
Mr.
how the
Brooks,
jury feels about
that's
this.
your next question.
I'm gonna get to it.
Thank you.
Wow. He's giving that stare death again. Look at him.
So when did you first report your alleged injury?
You do not have to answer that question. Next question, sir.
Grounds for
906.11, sub 1, sub A, sub B, and sub C.
is that lawful law?
Oh, God.
You may sit down. Does the state have any questions for this witness?
Judge just shut down his questioning.
Ma'am, that day on November 21st of last year, you were there with 2 kids?
I was, yes.
What were their ages on that date?
Objection.
3
relevancy.
and
Overrule, the witness may answer.
Of course it's gonna be overruled.
Because you
3
don't know
and
what relevancy means.
And I don't know, Mr. Brooks sits it down. And I'm asking the questions right now.
Mr. Brooks, please sit down. Mr. Brooks, you're not asking the questions.
I'm not saying
I would
anything.
ask you to sit down, please.
Oh,
It
boy.
is disrespectful to this witness and to the state and to the court.
No, it's not. Not doing anything wrong. I'm merely standing here.
It's like a child.
Parade, on November 21st.
He's like a child, man.
Of last year, approximately where were you watching the parade from?
Asked and answered objection.
Mr. Brooks, it's cross-examination. Just because you asked the question initially and she answered does not mean the state doesn't get to follow up on it.
So the state can ask the same question I
The
asked.
state can ask their question.
So how
Go
come when
ahead.
I did that,
Overrule,
it was
the witness may
it was
answer.
sustained?
I was on Main Street, but right by where the intersection of White Rock, and I was in the roadway.
I'm going to show you what's been marked and previously admitted into evidence as State's Exhibit 15.
Go ahead.
And I ask that the screen be cleared. And ma'am, does this
Can you
show?
wait until it's in the jury
I'm
box?
sorry.
I'm sorry. The jury would let me know when it's there. Thank you. It's there now. Go ahead.
Ma'am, do you see a purple line on that would indicate the parade route going from White Rock Avenue down Main Street?
Yes, I do.
And can you approximate where you and your kids were watching the parade?
Yes. Do you want?
If you, I'm sorry, it's a touch screen. I keep forgetting to say that. Touch screens, just put a dot right where it is. Okay.
Maybe on the other side of that red line?
So, okay, can we clear the screen and maybe just put a dot? I think that, or a circle. I think a circle would be good. Okay, thank you. Would be fair to say is to your left would have been Pleasant Street?
That is correct.
Were there barricades blocking Pleasant Street?
There were
Objection. Asked and answered.
Overrule, the witness may answer.
There were barricades that were partially black. They were on Main Street, but partially blocking Pleasant Street as well.
Could a car have gone down Pleasant Street?
Yes.
Objection.
Overruled, the
Hearsay.
witness may answer. It's not hearsay.
So when the red
Hearsay.
SUV came down White Rock Avenue and was making its turn onto East Main Street, as you testified, it could have just gone straight onto Pleasant Street, correct?
That is
Objection.
correct.
It's hearsay. She's speaking as
Hold
first
on.
eyewitness,
There's an
first-hand
objection.
eyewitness.
Mr. Brooks, your objection is noted. It's overruled. The witness may
usual.
answer.
It's always overruled.
Go ahead, you may answer.
Then learn how to use your objections
Sorry,
properly.
There's a lot of talking.
And maybe all of them won't get
Your question
overruled.
was, just to clarify, could the vehicle have gone straight onto Pleasant Street? Is that right?
Yes,
Okay, yes.
thank you. And where you stated that you and your kids were partially in the roadway when the red SUV came through?
Yes, we were.
Objection.
And
That's mischaracterization of what was testified to.
Overruled, the witness may answer. Go ahead.
Give me answer.
Can you repeat it?
Sure. Were you and your kids all in the roadway when the red SUV went through?
Yes, we were.
Okay. You weren't part of the parade, correct?
We were not.
Okay. So were you standing with other people that were in the roadway?
Yes, we were.
And was one of your kids going to get candy when the red SUV came through?
Yes, my
Objection,
daughter.
speaking as a first-hand eyewitness.
Because she is a first-hand eyewitness.
No, I'm talking about you.
The objection is noted.
Wow.
It's overruled. The question is proper,
Holy
and the witness
crap.
may answer.
Yes, my daughter was further in the roadway. We were all in the road, but she was further in the roadway, reaching to grab candy.
At any other time, you stated that this was towards the end of the parade. Is that correct?
Yeah, we saw Santa, and he's always like the end of the parade.
And had your daughter gone to get candy at other times?
The entire time.
Had she, during the time preceding the red SUV coming through, had she almost been struck by any other participants in the parade?
No, she was nowhere near like where the vehicles were driving through the parade. She was no.
So she's going out to get some candy that had been thrown, I assume, correct?
Yes.
And
Overruled, the witness's answer may stand.
you see this red SUV coming. Is it coming from your right or from your left?
The red SUV was coming from my right side, which was White Rock.
Okay. And how close did it come to your daughter?
It was, I wouldn't be able to give an accurate judgment, but it felt very, very close.
Had you not pulled your daughter away, would that car have hit your daughter?
Objection, speculative.
Overruled.
It's very possible.
So you say that you saw a police officer have some contact with the red SUV. Do you recall that?
Yes.
Can you describe that for the jury?
Well, there was a few times that police officers attempted to stop the red SUV. The first one was been where we were on Main and White Rock. And then there were also other people trying to stop it too. And then again, as it drove, once it turned onto Main, the next road, I believe is Buckley. And there was another officer who tried to stop that red SUV again.
And which is the officer who had to step out of the way in order to not get hit by the red SUV?
What was the question?
Where was the officer located who had to step out of the way to avoid being struck by the red SUV?
I believe that was the officer around Buckley and Maine.
And ma'am, as the car passed your location, did it increase its speed?
Yes.
Do you know where in the roadway it traveled down?
Objection, speculation.
Overruled, the witness may answer.
The direction of travel?
Where in the road? Was it on the left-hand side, the right-hand side, or in the middle?
It was all over the road.
You saw it all over the road?
Yes.
So going, and why don't you describe for the jury what you saw?
Driving the vehicle, once it turned onto Main, it drove side to side, and then I lost sight when there were through the people as it got down the hill.
Nothing further.
Thank you. Can you read the rest?
Yep. You said you observed multiple officers try to stop the vehicle. Is that correct?
Yes.
You described one at, I think you said it was Buckley, right?
Yes.
Why didn't you report the other officers that you allegedly saw attempt to stop the vehicle?
I don't know what you're asking.
The report that the interview that was conducted with the FBI. That was who did your interview, correct?
Yes.
Why is it not in the report about the multiple officers that you say you saw attempted to stop the vehicle?
I don't know why it wasn't put in the report.
Do you recall if you told the FBI agents?
It's been a year. I believe so, but it's been a year.
When you say it's been a year, I'm assuming that means that there's some details you don't quite recall all the way. That'd be fair to say.
Yes.
Oh yeah, it's been a year. She's not going to remember every single thing that happened that day.
So it'd be fair to say that if there's details you don't recall, how can you recall half the travel of the SUV that you claim you saw?
Oh boy.
Can you rephrase the question? I'm not understanding.
I think it was clear, but I'll ask again. You just acknowledged that there may be some details that you don't quite recall.
Well, someone would remember. Someone would remember an SUV plowing into a group of people, no matter how long it's been.
Judging by what you just stated, wouldn't it be fair to say that that's a possibility?
No.
So you recall all the details of what you observed that evening, November 21st, 2021?
No.
So what other details do you not recall?
You're under, how does someone recall the details that they don't recall?
Yeah, that's what I wonder.
Sustained is to the form of the question.
Seems very funny. Seems almost as if you're recalling what you want to recall and purposely not recalling.
Objection,
Don't.
badgering the witness.
Yes, sustained. You do not have to answer that, and you are warned. You may not badger or argue with this witness. Next question.
Badger or argue? What do you mean?
Oh boy.
What do you mean?
Don't intimidate the witness is what I mean.
How am I intimidating the witness?
Badgering the witness by eye rolling, by pursing your lips, by making facial movements regarding her
Does she
answers.
feel intimidated?
is
Here we go.
Badgering the witness.
Are you kidding me?
Under 90611,
You really
please
can't- you
ask
really
your
can't
next
be serious.
question.
You can't be serious right now. Intimidating the witness. What have I done to intimidate the witness?
You just tried arguing with
The
her,
last question was
jackass.
badgering, which is a form can
But you
be.
said
Mr. Brooks, I've made my ruling under 90611.
specifically said
Please ask a
intimidate.
question or
I'm trying
I
to
will
merely-
stop the
How
questioning.
did I intimidate?
Under 90611, sub 1, sub A, sub B, and sub C, ask your next question or the questioning of this
How are
witness
you
will
even a
end.
judge? How are you even a judge?
All right. You may-
Wow.
Thank you.
How are you even a judge?
Come on, man.
Holy crap.
This must be all about the 62 trust, right? That you want to be the beneficiary of?
I'm going to give the jury their closing instruction. We are done with testimony for today. Please do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited
She's
to
sending the
face-to-face
jury home, but
conversations.
you know Brooks is still gonna argue with her after the jury
Do
leaves.
not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek.
You know he's gonna
information
try
regarding
fighting the
public records of any
judge,
party or
arguing with the
witness in
judge
this
right
case.
now.
Any
As soon as that jury
information you
leaves.
obtain outside the courtroom could be misleading,
So
inaccurate,
don't
or
go anywhere
incomplete.
because we might
Relying
not be
on this
done yet.
information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social
He has
media,
that
photos,
death
or in any
stare,
other way,
like
on or off the
earlier.
computer. Do not permit anyone to
He is
communicate
so
with you
pissed.
about this matter, either in person, electronically, or by any other means. If anyone does so, despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
Call yourself a judge as much as bias you put up in here. Don't even tell the jury the truth. Got no integrity whatsoever. None.
Wow. This is not going to end well for Brooks.
Thank you, everyone. Please be seated. I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods and provided that to the state. Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Monday.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know a subpoena form was filled out.
If
So
I want her to be here, she gonna be here.
I agree with
So
the
just
state
just
that
know that.
she could certainly appear.
It ain't even gotta be no arrangement. All I gotta say is come, she gonna come.
What a piece of shit.
That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you
We
to
said-
have her
we
here
said
at
all
9
that- We said
a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr.
judge?
Brooks, I need to make a record of
I
some
need to
things.
make a record too.
You don't
When
need
am
to-
I gonna get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement or make the record that I need to make. He
leave
hasn't
anyway,
sat
so what
down
do it matter?
for
You
the
can
better
hold me
part
in
of 2
contempt all
hours.
you want. You can hold me in contempt all you want.
I'm not
All
holding
you
you
gotta
in
do is tell me
contempt.
if it's criminal or civil, so I can hit
Right.
you with you.
I need to
with
clear
what you
the
know is
courtroom because
coming.
I do need
I'ma
to
give
make.
you what you know is coming.
I need him to go to the
If
other
it's civil-
courtroom because I do need to put some
if
things
it's
on the
civil,
record. The record should
Where's the
reflect
contract between you and
that
I?
Mr. Brooks
If it's
is
criminal,
yelling at me.
what is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to
Mr.
the
It
next
ain't no Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making tacit agreements, being biased, judicial misconduct, trying to steal somebody's
He has exploded. And we're not done yet. He's being moved to the other courtroom so the judge can make her final rulings for the day. And he's going to go off in that courtroom too, I bet. Definitely the most interesting day of the trial by far. You can cite in tactic agreements and an all bunch of other sovereign citizen nonsense. Oh yeah, freaking! I'm looking at Twitter right now. Freaking ton of conversation about Brooks. What a way to end the week, though. Take care, Bama. Have a great weekend. I believe there are other witnesses at some point next week, maybe? I'm not sure. Yes, he did. He blew his chance for appeal. Any chance for appeal. Yeah, that's a great question. What are we going to do now? It's the weekend. Like, really? We're just waiting for them to come back so she can put stuff on the record, and that'll be the end of it for the week. Although I will say, this has been my longest stream ever. Probably likely will ever be. We've been going now 8 hours and 52 minutes. And I don't think I've even eaten today, so once this wraps up, I think I might go order a pizza. I'm not sure. Oh, that would be so funny. That would be hilarious. Thank you, Frank, for hanging out all day with me. I appreciate your support, my friend. And thank you to all of you for hanging out throughout the day. I wasn't sure if I was going to stream the entire thing or not.
I know I'm muted.
But here we go. let them know we can hear you. It is.
Am I muted?
Thank you, Payson, for being here since the beginning as well. And to all of you, I really do appreciate all of your support. It's been a long but very fun and entertaining day. Looks like they're going to be getting started here in just a moment. I'm not sure if I'm going to post anything yet this weekend, like a new sovereign citizen video. I'm not sure, but we'll see. It's a maybe right now, but we'll have to see. Yep, and it's the longest stream that I have ever been on and ever have done. I wasn't planning on going all day today. I figured maybe just do the morning session and then wrap it up, but I'm glad I did the stream all day today.
To reflect that Mr. Brooks is in the adjacent courtroom. I have verified the audio and video are working appropriately. I need to address some scheduling issues, but before I do that, I need to make a record that at the very end of, after I read the closing instructions, Mr. Brooks started to make disparaging remarks about the court in the presence of the jury. I did not respond to those. And once that jury left, he got incredibly loud. He was yelling at me. He, I think, had been standing for the better part of the last couple of hours, even though at one point I directed him to sit down after the direct examination of the last witness. It was apparent to me that he was not pleased with some of the rulings that I had been making regarding objections. I would just remind him that this was a witness he called, therefore it's proper and allowable under the law, under 906.11 sub 3 to be exact, for the state to ask leading questions, which they did. And at the very end of that, there was an objection based on badgering, which, as the record reflects, I sustained. His voice got louder. He continued to stand. He was being very argumentative with that witness who, again, he called. Given his posture, given his staring, given his pursing of his lips, given the way that he kept asking the same question in different ways, but over and over, not satisfied with the responses that had been given. Or
I'll have to see how my schedule is, but
that is why
I
made
might
the
do a
finding
stream.
at that
I'm not
time
sure.
and
I'm
sustained
not
the
sure
objection
yet.
for badgering. It was Mr. Brooks who asked me what that meant, and I indicated it's a form of intimidating a witness. I don't mean that in the sense of there's a charge of intimidating a witness. That's not certainly what I meant, but really in the common everyday usage, it's another word. It's a synonym for badgering. Clearly, he was displeased with the court. After that, I cut off the examination, which I had given a number of warnings that I would do if he didn't ask an appropriate, a probative, a relevant question. During that time of both the, frankly, even during his direct examination, definitely during the state's cross-examination and then redirect, it was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips and make other gestures.
He's reading the Bible again.
That he did, that it was apparent to this court, he did not like her testimony. And again, I'd remind everyone that it was his witness. And he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing outside the presence of the jury so that I could get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which there is, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning.
It would be
Also
great if
advise
he
him that he has
testifies.
a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, excuse me, consent or lack of consent, or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question on what is your decision, a failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony. the scope of it, Chambers versus Mississippi. It's a U.S. Supreme Court case from 1973, found at 410 U.S. 284. Rock versus Arkansas, also a U.S. Supreme Court case, 483 U.S. 44. State versus Anthony, which is a Wisconsin case, 2015 Wisconsin 20. These cases, of course, recognize that a defendant in a criminal case has a fundamental constitutional right to testify in his or her own defense.
Yeah, I think you're
stems
right.
from various
I think you're
constitutional
right.
provisions, including the 14th
He wants to
Amendment,
create another
which protects the
dumpster
defendant's due
fire.
process rights to be heard and offer testimony. The 6th Amendment, which protects a defendant's right to call witnesses in their favor. And the 5th Amendment, which protects a defendant's right against compelled testimony unless he chooses to speak on his or her own behalf. I'd also point the parties to State versus McDowell, 2004, Wisconsin 70. Although the right to testify is a fundamental constitutional right grounded in personal autonomy, it is not absolute. There is no constitutional right to present irrelevant evidence. State versus Robinson, 146, Wisconsin 2nd, 315. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Citing to Rock versus Arkansas, there's a balancing test that if and when this court is faced with any of these situations that I will be prepared to go through. Of course, Illinois versus Allen is also important, and all of the other cases that I've cited along the way. State versus Anthony is also important, as I've noted previously. I've relied heavily, of course, during the course of this trial on 90611. And the primary purpose of a criminal trial is to develop relevant facts on which a determination of guilt or innocence can be made. Efficiency is a secondary objective of trial. And of course, it is the circuit courts and the judges assigned to those circuit courts that are charged with administering the trial and serving these two purposes. So just tying up, I guess, the last loose end. I've referenced it already, but I think it's worth repeating again. If the defendant wishes to call Ms. Dawn Woods to the stand, I expect her to be here. I expect one of two things to happen. Either he testifies first or he doesn't, or he calls. He can certainly call her after he testifies, but if she is not here at 9 o'clock, when I've advised the jury to be here, I will, of course, have gone through the colloquy with Mr. Brooks. And I expect people to be on time and to be ready to go, to be fully prepared. And then, of course, the state, if it so chooses, does have the option to call rebuttal witnesses and offer rebuttal testimony.
We would not anticipate that as of right now, Your Honor, just so you know for timing.
Thank you. I appreciate that because once the evidentiary phase of the trial is closed, of course, I will be sending the jury home because I do anticipate a very lengthy jury instruction conference. And it's my hope that that is something we can get done by the end of the day on Monday, but since it's just the parties and not a jury here, I will go as late as it takes with the hope of, and with the plan of, again, assuming the state doesn't call any rebuttal witnesses, to start instructing the jury on Tuesday morning. I anticipate that
Oh,
is
look
going
at
to be
him.
an incredibly
Reading the
lengthy
Bible. It's
process.
pathetic.
We have been working, Madam Clerk has been working very hard on pulling together, just from what we have thus far, the jury instructions. I believe it's well over 100 pages. Yes, with my advanced eyes, I need 14-point font. So with that caveat, but the preliminary instructions were 69 pages with the 14-point font. So I know it's going to take some time. I know I'm going to need some breaks.
That's
do
a
not
lot of jury
anticipate
instructions.
getting done with, sorry, I keep saying preliminary, but I don't anticipate getting done with the advisement of the jury instructions before the lunch hour. I can't tell you how long it's going to take. It may take the whole day, but the party should, well, the state would go first, so the state should be prepared perhaps to start closing arguments. I'll ask you at a later point, probably sometime on Monday, if you have an idea of how long that will be, because that will frankly dictate in part like where we are with how long it takes for me to go through the instructions, and whether I just instruct and then bring the jury back the next day for closing arguments. But that's generally the framework that I intend to follow. Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead.
Do that now?
Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department as they were memorialized in supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue that we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that witness and presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to Dawn Woods, the defendant's mother, long day, who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, she would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions. She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr. Brooks and ask him if there's anything he needs to make a record of at this point on the topics that have been raised.
And here comes the stupid games again. Let me guess. He's going to say he hasn't been
Anything
listening.
you wish to address before we break for the day?
Yeah, I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them.
There's a procedure you have to do to make that happen. You haven't been doing
I've put you
it.
on notice, and I've stated it on the record, even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do. So this is something that's been stated on the record numerous times. I did hear a reference to what was he just talking about? Whatever he was just talking about is in regards to
Yes, he
going to
is.
get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up.
Here comes the conspiracies. They're all against me. The judge is against me. The prosecution's against me. The jury's against me.
You sit up there earlier and made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts of evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said? But not one time did somebody say, no, we're going to strike that. Not one time. But if it had been me, it would have got struck. Or if it had been me, it would have been a problem. If it had been me, I'd have been held in contempt. Why was the bond not addressed? Why was the statement of particulars not addressed? No filings that I seem to file need to be addressed. After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you, which clearly states on there, I do not waive my right to assistance of counsel. And you accepted that. But you still turn around and continue to violate my Sixth Amendment right. Violate my First Amendment right by telling me what I can and can't say.
No, she's not.
Which I have the right to say whatever I want to say and to be heard. That's the First Amendment. You sit up here and talking about
someone mute him.
Option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take, but it's awful funny that it never got mentioned before. You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceedings.
That's why you
Yes,
keep your
you
lawyers if
find
you
a way
don't
to get around
understand the
just like you
proceedings.
found a way to get
You
around answering
willingly
what your name
fired
was,
your
which you're a public
lawyers.
servant. The name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction for the record.
Yeah, we
Have
all
yet
know
to show
that.
you even have a
It's all
license to
just
practice law.
BS.
Haven't proven that yet. And neither has the prosecution. Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence?
Come on, say delegation of
The oath that
authority.
you haven't even honored, not one bit.
That would be great.
Doing enough to keep your face clean doesn't constitute being fair. Doesn't constitute being impartial. When the jury was selected, I struck the whole jury. That never got in any way, shape, or form. When you were informed way before that I was striking the whole jury.
He
So
struck
how
the
can you
whole
go over that
jury.
constitutional right, which I have the right to not pass a jury?
Mr. Brooks, I'm muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He is simply rehashing previous determinations of this court. I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And with that, I'm going to end for the day. I'll see the parties at 8:30 a.m. on Monday. Thank you, everyone. We are in recess.
And that does it for today. And what a day it has been. Eventful to say the least. Thanks so much, Mark Baggett. It's been a fun day. Have a wonderful weekend. I know your dreams will be of this weekend, which is why I smoke, not cigarettes. So yeah, that is going to do it for me. It's been now 9 hours, the longest stream I've ever done. It's been an awesome day hanging out with each and every one of you. Like I said earlier, I'm not sure if I'm going to have a new video this weekend or not. I'm not sure if I'm going to be able to stream on Monday the trial. I'll have to see how my schedule looks, but if I can, I will. So yeah, I hope everybody has a great weekend. I'm going to go get something to eat. Might order a pizza. And let me just say, go through the comments one last time. That's been great. Thank you. Many thanks, Mark. That was fascinating. Yes, it has been. Thank you so much. And thank you to all of you, because it wouldn't be a stream without all of you guys. Thanks for the fun stream, Mark and chat. Take care, everyone. And yes, take care, everyone. And as always, I'll see you next time. Have a great weekend, everyone.